right here on Fox 6. But for now, I'll send things back to you guys in the studio.
Good morning, everyone. This is the final day of the Theodore Edgecomb trial. I'm not really sure what's going on with the live stream for Milwaukee. I mean, it looks like there's some sort of police shooting that occurred, or a shooting of a police officer. I'm trying to find a different feed, so just hang tight. Let's see what we can get going.
About to start, guys. Hang on, waiting for Spectrum. Guys, about to start.
I'm Sheriff Ernell Lucas, E-A-R-N-E-L-L, L-U-C-A-S. I want to give a statement on the actions and activities of Milwaukee County Sheriff's deputies, along with several surrounding area law enforcement agencies overnight. At approximately 2:08 a.m., a Milwaukee County Sheriff's deputy attempted to make a traffic stop of a vehicle for a registration violation in the area of West Adler and South 68th Street. The deputy who initiated the initial stop requested assistance. As deputies were arriving, the driver and passenger of the vehicle fled on foot. The driver was taken into custody after a brief foot pursuit near the on-ramp of I-94 and 68th Street. Sheriff's deputies and officers from the West Dallas Police Department assisted in a search for the second subject. Shortly after 3 a.m., 3 a.m. observed a male subject.
As we go throughout the day,
climb out of a garbage 3 a.m. in the area of West Adler and 64th Street. A perimeter was reestablished.
Yeah, guys, I'm still looking for a different live feed to go off of, so if you happen to know of one, don't be afraid to tell me. I'm still looking for one that might show the trial, but this seems to be big news in Milwaukee.
The subject was approached by one of our deputies, at which time the subject produced a firearm and fired at our deputy, striking him several times in both his arms and his torso. The deputy was conveyed.
Would you like to get a new metal roof installed for 99 cents? Click the link below this.
At this time, his injuries do not appear to be life-threatening. We all should be very grateful and thankful for that officer, for that deputy. Sheriff's deputies and officers from multiple surrounding agencies now began a search for the shooting suspect. And at the same time, a shelter-in-place order was issued. During the search, sheriff deputies and officers encountered a male subject crouching down behind a vehicle in the area of South 60th and Main Streets and issued commands for the subject to cooperate. Subsequently, the deputies and officers heard a single shot and found the subject lying on the ground from a self-inflicted gunshot wound. The Milwaukee Police Department was requested to conduct an independent investigation into this matter. Investigators at this time have not established whether the subject found dead from the self-inflicted gunshot wound is connected
guys, I'm
to the
not.
shooting of the deputy.
Yeah, I'm not really able to find
At this
anything
time,
else right now.
the
So
shelter-in-place order still remains in effect. Residents are asked to contact 911.
Violet, this is
if
showing
they
up
see
all
something
over the Milwaukee
suspicious.
news channels. I think this is taking over
And anyone
news
with
coverage right now.
information regarding this investigation is asked to contact the Milwaukee Police Department at 414-935-7360. Again, that number is 414-935-7360, or contact Crime Stoppers at 414-224-TIPS. Again, that's 414-224-TIPS. I want to thank all the area law enforcement agencies that responded to the call of help from one of our sheriff's deputies. The law enforcement support and collaboration is some of the best I've ever seen in my years in law enforcement. And we're grateful for those partners from all the surrounding agencies. Too many for me to mention, but all of them know who they are and what role that they played. I want to say thank you to all those agencies. And again, I want to ask the public to be patient as we still continue to sort through the investigation, as we're still trying to make connections between the individual that was found dead, as well as information as we were just walking out here that an individual was found in the neighborhood who may possibly be connected to this incident. So with that, I'll stop and take a few brief questions.
Is the deputy who pulled over this car in the first place the same deputy that was shot?
No, it was a deputy, another deputy that made the initial stop. It was not the deputy that was shot, no.
And we know that you have one person in custody, the driver. How many suspects are you looking for? Just one, and is that driver in custody?
Yes, we after the initial stop and the subjects exiting the vehicle, we did take into custody the driver shortly thereafter. The second subject remained on the loose, and we were still seeking that subject. The deputy is 26 years of age. He's been with our agency now for about 18 months. He works our patrol division on the third shift. He's a very fine officer, a very fine member of this agency. Thank goodness his injuries at this point do not appear to be life-threatening. We've got to be very fortunate.
Well, that's good
This
news.
is twice within 2 weeks, law enforcement officers have encountered individuals with weapons and have been shot doing their jobs. And we're just very grateful and thankful that his injuries do not appear to be life-threatening.
So I just want to make sure I have this clear. We have one person dead, but we're unsure if that person is the suspect. Or could you tell the public right now who is sheltering in place and has been for several hours?
Again, it was an individual that officers and deputies noted in the neighborhood. And
Does it really count as sheltering in place if you're sleeping through part of it?
Behind the vehicle, and when they attempted to make contact with the individual, they heard a single shot. And following that shot, they found the individual lying down from a single self-inflicted gunshot wound. So at this point right now, we've not been able to make the connections as to what that individual's involvement was and is to this investigation. The Milwaukee Police Department and its investigators are working through that. We hope to make those connections here very shortly through some forensic evidence and other evidence so that, again, we can give the all clear in the neighborhood.
We just were over at 67th and Dixon and saw some of your deputies taping the scene over there. Can you tell me what's going
again, just as we were walking out here, we received word that an individual was found walking in the neighborhood. After a brief pursuit, he was taken into custody by law enforcement, sheriff's deputies, and police officers. And we're still trying to determine what that individual's connection to this investigation may be as well.
When you guys send out alerts like this,
We've not made that connection at this point. It's too early to tell, but we're working and trying to determine that right as quickly as we can.
when you guys, no, it's okay, I apologize. When you all send out alerts like this, exactly how big of an area got that alert? We know people as far as up to 1 million people we're hearing received this alert. So how do you guys justify who receives it versus who doesn't?
That's determined by the Office of Emergency Management. The lieutenant that was in command on the street felt it important that we issue an alert to the immediate area. How far and wide the area of coverage goes, I can't answer that for you at this point right now, but we're just very grateful that that lieutenant made the decision to do what was in the best interest of the residents of this immediate neighborhood.
Did law enforcement ever discharge about that?
It hasn't been determined at this point, but every indication I have right now that no, that's no officers discharged their weapons.
You mentioned that the officer who was shot was consciously breathing and being treated for his injuries. Have you been able to connect with them and figure out if they can tell you anything about the suspect crashing the car? If the person that did have a self-defense gunshot wound, if that is the person who did it?
We are working to determine the identities of the two individuals, the one that's deceased as well as the individual that was just taken into custody a short time ago. I've personally not made no contact. I'm leaving here to go out to the hospital to talk with the officer and his family. I think investigators have been able...
Okay, guys, I think we pretty much understand what's going on. I just decided to turn down the sound on the press conference a little bit. Yeah, so how do you guys think Theodore's his direct and cross went? I'm kind of curious to hear your guys' thoughts.
I don't know at this time. I'm still trying to determine that. Yeah. Thank you all very much. Thank you. Thank you so much. Thank you.
All right, I guess we're going to wait now and see what happens. I'm glad you guys caught up on a lot of that. That wasn't a... I think those were people trying to act smarter than they thought they were, and it just fell apart. I really like the part where they talk about throwing the gun away, and Theodore's only answer was, well, I was worried about protecting myself. I mean, that was just like a robot not being able to process a command properly, and it just locked up. As much as I came into this hoping Theodore was in the right, no, he was clearly in the wrong. He had no right to do what he did. He even admitted, oh, it was an accident. So, yeah, he didn't do himself any favors there. There we go, back to a familiar screen we're used to. Sue, I think that part of this issue, and I'm not trying to make fun of Theodore, but I don't think he's very smart, is part of the issue, and I think he may think he's smarter than he actually is. That was kind of the vibe I got. And that's always a dangerous combination if you think you're smart enough to fool the world and you're clearly not. Part of me is wondering if he cooked up this story about the 6 month long vision quest to find the attorneys, or if that was a defense idea, because either way, that was a very stupid idea. It doesn't make any sense. Um, but yeah, I can tell you his attorneys are woefully unprepared for this and unqualified. Um, if this is the best they could do with the one witness they've had the entire time, they could be coaching and shaping and forming direct testimony and preparing him for cross for months now. If this is the best they can do, I mean, these guys, Theodore needs to get his money back because this was awful. Well, at this point, there's going to have to be a lesser included because if he did not intentionally kill the person, well, then he doesn't qualify for intentional homicide. Now, I don't know how exactly it's worded in Wisconsin, and we'll hear about it, but intent is not only just you meant to do it, but do your actions have a reasonable likelihood of causing a certain situation? So, shooting at somebody, carrying a gun, and pointing it at them, well, yeah, there's a very good likelihood that you'll end up shooting them, and you can't be surprised by that. So, he still might qualify for intent under Wisconsin law. Robert, this has nothing to do with race. Theodore admitted he didn't intend to shoot him, he didn't intend to kill him. The rest of his story doesn't make any sense. I mean, yeah, he got cornered and didn't like it, so he pulled out his gun. I mean, he got scared and it sounds like he acted like a coward. He wasn't willing to take a beating that he tried to start. You know, Violet, you mentioned the whole driving and he feared for his life, and that's fine, but once the car stops, like I mentioned before, self defense is like the windmill at the putt putt course. Okay, well, when the car's coming at you, that right to self defense is open, but it stopped. So you're no longer in fear of it. It has to be moving again. There has to be that immediacy, that threat. So if he had turned around and shot him as they were about to hit him on the bridge, I think that would have been fine, but once the car stops, it's over. Till the car moves again. Yeah, Johnny, yes, it was. He did mention some things like Ahmaud Arbery. But you know what? You may not like for me to say this, but if you can pull something out of your butt to try to help your case, he's up there fighting for his life. I don't blame him. It makes sense to me. You might try to infuse race into a case if you can to conflate issues. I mean, yes, there's this idea as an attorney, I should solely want it to be tried on the case itself. But in reality, at the end of the day, my job is to put my attorney in the best, or my job is to put my client in the best position possible. And as long as I can do that within the bounds of ethics and the bounds of the law, those are my guide rails. So, if you can make a case about racial issues, that's a little less, you know, the way I want to go. But if that means I keep you out of prison, then I'll do it. Because that's my ultimate goal at the end of the day. I mean, Johnny, my primary goal, if you're my client, it's to help you. I mean, that's my only consideration. If I want to worry about what's going to happen to society, I mean, you go work for the prosecutor's office. Um, Because I think about it. Oh, my job. Even if you're guilty, the fact that society won't burn down is going to burn down over this. That's not my problem. I mean, I think it would be very problematic if attorneys were willing to sacrifice their clients for the greater society, because that's not how it should be. I mean, you're with them. You're with them till the end. I mean, it's not necessarily like a ride or die situation, but if you're my client, you know, and the airplane's about to crash, I'm riding with you all the way to the very end till it stops. So, yeah, at least that's how I look at it. I know there's attorneys who might back away from it. They might try to bail on cases if things were happening that way, but I don't feel that's right. When you're with them all the way. Jackie, as far as saying that his bike would have been damaged, I don't know. I mean, everything reacts differently. I mean, you might have been a fender bender where there's just like a scuff of paint you can peel off. I mean, it doesn't sound like anybody was going super fast, and if I think Theodore's hamming up what happened. I mean, it sounds like he got into like a Tour de France style crash, but I bet he kind of got bumped over and then kind of lost his own balance. So, I mean, I don't know if you'd be able to tell if the bike really got injured. Uh, yes, I agree. Okay, yes, if that makes, I think that's probably a proper way of looking at it, Rennie. Funny lady, the harshness of sentencing for murder offenses in America really doesn't stop people from killing each other. For example, where I'm at in Ohio, murder is 15 to life, a 15-year minimum sentence for the potential of life. I don't think he's lying to himself because he's paranoid. It's he's lied to himself and come up with this story, and after a while, you end up buying your own nonsense. I'm sorry. Yeah, that makes sense. The paranoia was related to the shooting, but also I think he was happy kind of being a punk about this. Haha, I punched that guy, and then, oh shit, this guy means business is coming after me. Uh, I really think that's ultimately what happened. Well, Sue, as far as the bike is concerned, that's not ultimately a determinative thing. Because remember, like I said, that was a bunch of prior things, and also it was an accident. That's clearly was an intent. So you aren't allowed to use force to defend yourself from somebody who, it was clearly an accident. I mean, all that just does is show the backstory of how we got to a shooting. Um, Oh, Adirondack, you did mention this. The security guard stuff and the weapons training. Uh, yeah, I don't think it helped him. I think he was trying to give him some sort of. They were fishing. They were grasping at straws at that point, trying to give him some sort of credibility that he's not just, some random bum who doesn't have any idea what's going on. That, because like he said, I helped the Coast Guard and the Border Patrol. Like, I'm serving America. It's just like the military, except not. I mean, that was more of them trying to bolster his character more than anything. And also just so he didn't look like a random Yahoo with a pistol. Matthew, I don't know if it shocked the attorneys, but there's an issue. And I said this before. These guys, even if they try criminal cases, it takes a lot to try a self-defense case. You need to know what self-defense is. And I really think these guys just went online and said, oh, what's in self-defense? And, oh, it's got a couple of elements. There's innocence, there's immediacy, there's a disparity of force. Is the threat real? I think they just went off and checked those boxes and said, oh, cool, I can do this. And yeah, you can check the boxes, but there's a lot to it. And they looked at the Kyle Rittenhouse trial and said, oh, they used Dr. John Black. We'll get him. This is not a DUI case where you can kind of wing it by seeing what somebody else does. You have to understand it. And that's why, like in my one recap, understanding weapons, because they tried to introduce Ruger magazines for a Ruger pistol, claiming that that was the weapon he dumped, but then it looks like he used a Glock pistol, and based on Theodore's testimony, it sounds like he had a Glock pistol. So it sounds like evidence is getting dumped in that shouldn't have been. Or you can use it to show the state's lying and doesn't know what actually happened. It's not a simple thing. Much like a tax case. You wouldn't just hire a regular attorney. You would hire a tax attorney. Or if you had a patent issue, you would hire a patent attorney. So it requires you to pick a specialized person. Sue, that doesn't actually mean anything. There's no something that'll stop you from using a racial slur, so I don't think that's a proper argument. It just sounds like he wouldn't be the type of guy to use them, period. Sorry, guys, I'm getting a little paranoid. It's going to start and we won't know about it, so I just want to double check. Uh, Rodney, you're asking about Judge Borowski. Look, he has done a very good job at trial. Certainly, every judge at some point has had a trial or a ruling of theirs overturned. I don't know on what grounds. Sometimes complete grounds, sometimes on minor grounds. But no, he's been very good so far. I think he's done a very good job. Once again, his Theodore's attorneys are fools, and this judge is not going to tolerate that. If you went into any of the judges I'm in front of and act the way they have and been as incompetent and unprepared, you'd be testing all their patience too, and some of them would be even worse than Judge Borowski. So, once again, I think he's been an overall fair judge. This is just a shitty case with shitty facts. Going into this, we thought there'd be a lot more to it, but now looking at it, I am completely blown away they didn't get a plea out of this, because I would have been leaning on Theodore and telling him he needs to plea out. Now, if the prosecution's offer was life, the same as if he went to trial, I understand going to trial, but even then, I'd be prepared a whole lot more than this. Chris, there may not have been a plea offer. Sometimes when you're in a case, you've done something so bad, the prosecutor's plea offer is plea to the indictment. So sometimes there is no plea offer. Like I think in the Ahmaud Arbery case, there was no plea offer made. You have no right to a plea offer either. So sometimes you've got, it's sometimes when you're in a criminal case, it's game 7. You go to trial and hope you win. Sorry, I killed the question feed. Sue, as far as the whole paralegal issue, that's just sloppy attorney work. They weren't prepared right. There are ways they could have got those Facebook posts in without even needing their attorney, needing their paralegal. Ugh, that was duh. Um, you can, well, and I assume Wisconsin's the same way. Actually, I'm not going to assume, but generally use it as impeachment evidence to show, hey, Mrs. Clearman, you think your husband's this nice guy, but look, we've got a bunch of Facebook posts where he was dropping N-bombs. Now, when you do that, there's a way you go about it, and you don't need somebody to introduce it. You would have Mrs. Clearman authenticate it, saying, hey, is this your husband's Facebook profile? Yeah, how do you know? It's his picture. Okay, cool, so you recognize it. Yes. Did you know he had a Facebook? Yes. It looks like you've posted on it. Is this yours? Yes. And then you say, hey, in this post, he said, I hate all these N-words. Well, that's how you get it in without having the paralegal. But once again, these guys sucked at laying foundations. They sucked at how to work the rules of evidence. So this is clearly, these were all avoidable issues. Yeah, guys, yesterday, I'm sorry, I let it run and I thought it would keep running after I left. I know it covered up to lunch, and I'm sorry that it didn't go afterwards. I had to handle my actual clients during the day, so I'll be here for the whole thing, though, today. David, I think it's entirely possible he used a racial slur. Or if he didn't use a racial slur, it was probably like motherfucker or something very serious. Um, I don't think this idea of he said, "Oh, what the heck," you know, golly gosh darn it. He didn't say any of that, and we know he didn't. But did he use the N word? I don't know. Usually, when you have that graded disparity, well, the truth's somewhere in the middle. And also, you have a problem. Theodore is not very credible. He's not very trustworthy at this point. I mean, it was almost to the point where the prosecutor have asked, "What's your favorite color?" And his answer would be, "I reacted in defense to protect my life." Oh, Mark, they didn't they shouldn't be disbarred. That's not at all. Disbarring that's like the nuclear option. That's a death penalty for an attorney. Do I think that they were do I think what they did was as bad as what Binger did in Kyle's trial? No. The way Binger attacked the constitutional underpinnings of our jurisprudence, I think was such a greater danger and threat than a couple of defense attorneys trying to hack together some, you know, defense on a case that was a complete loser. So no, and that's part of their job is as a defense attorney, you give me a mountain of dog turds and I have to turn it into the Michelangelo. Michelangelo's David. I have to turn it into a statue. Sometimes I can do it. A lot of times I can't. But you got to try. And there's an understanding that defense work is not, you don't just come in here and say, "Oh yeah, well my guy did it. Please, have mercy on him." Yeah, Granny, I thought he was gonna. He appeared. He seemed very likable at the beginning during his direct. But yeah, I think that was a combination of the lack of intensive preparation, and also I just think Theodore is not the smartest guy in the room. Mark, what do you mean about wording him? Do you mean, are they coaching his testimony or telling him what to say? Sue, I'm not exactly sure what you mean when they should have focused on the self-defense part. Well, Mark, once again, that's part of, I think, Theodore not being that bright and latching on to things, but also, once again, this is just they were out of their depth, and they weren't prepared for this, and I think they had a mental idea this trial was going to go a lot better than they did, and just they weren't able to think on their feet and come up with a new strategy, so they were kind of stuck with what they had. Oh, Violet, you want me to do a poll? Jeez, I gotta figure that out now. Sue, when Stephanie Trotter testified, she said she watched him trying to look like getting into his pockets, but she was never actually able to get into it. So it doesn't that kind of defeats the claim that she either put something in there or took something out if she couldn't get into it, and that's just because Jason's huge and she couldn't roll him over. Oh, I hear noise.
Versus Theodore Edgecomb, 20 CF 3535. Appearances.
Grand shooter for the
Kyle,
state.
I'm not betting that's going to be the case. They're going to convict him.
Yeah, Lamar on behalf of Theodore Edgecomb.
Mr. Hubner, so it doesn't get ugly as we argue, grab the microphone, use it, please.
Oh, this is going to get interesting.
Proactive. I apologize.
All right, it's just after 9 o'clock. The jury's back. There's possibly one or two things to discuss. Then I'm going to instruct the jury. Both sides will make closing arguments. I think the state suggested an hour. The defense suggested an hour and a half.
Hour and a
I'll
half?
allow up
You
to an
don't-
hour and a half.
Oh, Jesus
maximum.
Christ.
That's a hard stop at an hour and a half.
God
Again,
almighty,
both
we don't need
sides
that much
hopefully
time.
are aware that you don't necessarily have to use the hour and a half, and sometimes, if not most times,
You could do
not
this in 20 minutes.
spending too long on a closing is advisable. We discussed yesterday the instructions that the state submitted. I don't know if either side has anything to add on that. I believe it was the defense that drafted a proposed additional instruction. Is that correct?
That's correct, Your Honor. I made some additional edits after speaking with Attorney Hubner. I'm about to email our final draft of that to the court and to Attorney Hubner. I don't believe there's an objection on it.
The defense takes an hour and a half.
Well, I
I'm
guess I
taking a
need to see
nap.
the final draft, but Mr. Hubner?
Your Honor, I don't necessarily have an objection to it. I just
Or I'm gonna play a
raised the
game of
concern
squad.
that the defense counsel's version had the court explicitly telling the jury about the tragedy in Waukesha, which I thought was potentially...
Is no way going to happen. I don't need an argument from either side.
Out.
No way on God's earth am I going to allow a sentence that says, finally, evidence was received that the defendant was on bail at the time of the charged offense. Any recent events in the neighboring county of Waukesha shall not affect your deliberations in any way, and you are to decide this case solely based on the law and facts presented to you during the trial. Mentioning that situation in Waukesha, I presume, obviously that's a reference to the Brooks case, arguably one of the biggest tragedies and worst crimes this city, or I should say state, has seen in the last decade. I mean, no way. It's hyperbole, it's inflammatory, it has nothing to do with this case. It would potentially distract the jury, not a chance. So as long as that's out, let's get me the revised version, please.
And Attorney Hubner.
I will give him credit. That is a sneaky way of trying to get the Waukesha thing in there and try to infuse some racial issues into the case for the jury. So, hey, part of being a lawyer is being a little sneaky, and how clever can you be? But the judge, yeah. Ultimately, the judge is right on getting rid of that. Like I said, Johnny, if that's the cards you have to play, those are the cards you have to play.
As far as the special instruction, the second paragraph that's proposed and the third paragraph, I don't particularly have a problem with. I think they accurately portray the situation and accurately state the law. I want to hear the state's position on the first paragraph. The first paragraph reads, evidence was received in this case that the defendant had other open cases at the time the offense was committed. You are not to allow this fact to affect your deliberations on the defendant's guilt or innocence as to the charged offense in any way. The state want to comment on that? You know, my concern is the defendant discussed some of those open cases because, as I said yesterday, he clearly opened the door. I think the defendant feigned ignorance on his multiple criminal cases. The parameters were drawn multiple times by this court in pretrial motions and in conversations off the record, and the defendant on multiple occasions, I think, feigned ignorance or was making a speech to the jury saying he knows nothing about the fact that he had two criminal cases with two separate criminal defense attorneys. So it goes to veracity. So saying that that's not a factor, I don't know.
Maybe, Your Honor, then the best way to do it is to leave the first sentence as is, and the second sentence should just state that evidence was received only as it applies to the defendant's credibility, and it should not be used for any other purpose.
I think that's better. It's a credibility determination, Mr. Ahmad. Your client put that in issue. His credibility was put in issue by his repeated denials and repeated conflicting testimony. It is an issue. It affects his credibility. So if you want to modify that sentence, fine. I want the jury in here. I want to instruct them. I want closings done. Say that again, Mr. Hubner, please.
That evidence was allowed only as it pertains to the defendant's credibility, and it should not be used for any other purpose.
I think with that modification and the other modification to the last line, it's acceptable, and I'll give the instruction being requested by the defense with those two modifications.
There's a couple of other issues, Judge, for closing instructions.
I will be brief.
Number one, we are requesting, based on the case law, an instruction for negligent homicide. That's under 1175, homicide by negligent handling of a dangerous weapon. The testimony or the basis for that is during cross-examination, I believe there was some clarification questions asked by Attorney Hubner about how the gun had just gone off, and then...
Counsel, I apologize for interrupting. then arguably we take self-defense off the table, and I won't instruct on self-defense.
So, Judge,
Then it's just an up or down, guilty or not guilty on the counts. Because your client, I mean, arguably, as I thought about the testimony yesterday, there were statements made by your client that could lead a jury to at least consider and possibly believe the self-defense claim. But, as you know, he repeatedly insisted on direct and cross that yes, the gun just went off, acting like it was somehow an accident. So, I'll hear from both sides, but I don't see how negligent homicide fits with self-defense.
This is why I give clients clip-on ties if they can't handle it.
Well, I think
Be
Mr.
Ivory's
Ahmad
tying
wants to
Theodore's
finish his
tie.
argument, and then I'll respond, Judge, if that's okay.
Okay, go ahead.
Judge, State v. Carroll Watkins, 244, Wisconsin 2nd, 205. It's a 2002 Wisconsin Supreme Court case.
Gotta learn how to do a double Windsor, bro.
It was a review of a decision of the Court of Appeals, and basically the Wisconsin Supreme Court said those two concepts are not mutually exclusive, which is specifically self-defense and then negligent homicide. If there was some facts in that case where the court found that there was a basis for both, and that's just an issue for the trier of fact. That was a court trial in the original case, but essentially it's no different. It's a jury question as to how they want to resolve all of these charges. They're already going to be receiving the lesser includeds, so they're going to have already 4 different homicide degrees to consider. There is some evidence under the some evidence standard also if they decide to resolve the case for an accident, according to the defendant's testimony, which is testimony that was developed further by the state, then I think that's also been put into issue. I think the state's argument, Judge, is going to be that, well, in the Watkins case, there was first some assertion of the threat of force, and followed by then an accident occurring, perhaps, from a struggle between the parties. In this case, the facts that would support that would be there was some testimony about Mr. Edgecomb telling Mr. Clearman to stop, and then he approached, and then Mr. Clearman had his fists up, and we saw the video, and we've seen that many, many times in this case. There was a lunge, and then there was a very quick discharge of the weapon. I think there was some evidence that there was a showing of the threat of force, and obviously it's not the same exact case, but there is a basis to have the jury also look at that charge and consider it in deliberations.
First of all, Your Honor, I don't believe if you are to go to accept what defense counsel is stating regarding the Supreme Court case, it's not the same. In that case, what happened was the individual pointed the firearm in a deliberate show of force. This defendant, according to what the defendant all of a sudden came up with at the 11th hour, was that he didn't. He says stop, but he never shows the gun. He never points the gun. He supposedly has it down at his side. And then he doesn't even necessarily say, defense counsel, I think, was trying to get him to say that he aimed it. He never necessarily even said that. He says he backs up and it goes off as the victim is supposedly lunging or trying to spear him to get the gun. I also do not agree that the video shows a lunge. The video shows the victim literally collapsing.
I do not see a lunge on any of the videos that were played multiple times. I did not see anything that was close to a lunge. The jury's the finder of fact, but I did not see a lunge.
I mean,
I agree with the judge. I didn't see a lunge
based
either.
on these facts, Judge, in that case, they're not mutually exclusive. In this case, they are. There is not a situation in which what the defendant testified to is consistent or even comes remotely close to the intentional use of force, or even show of force. According to him, he didn't do anything. So they are mutually exclusive, even under the case that defense counsel cites. So self-defense would not apply if you have this negligent homicide. I would just also note that in order for a jury to acquit on second-degree reckless, which is they'd have to get all the way down to second-degree reckless.
Reality, the jury will decide.
For human life, no intent, they get down to second-degree reckless. In order to get from second-degree reckless to homicide by negligent use of a dangerous weapon, the only difference between those two is reckless requires, and just so we have it 100%, that the defendant in that situation was aware that his conduct created unreasonable and substantial risk of death or great bodily harm. In negligent, it's just that he should have been aware. Well, he admits to having weapons training. He admits to knowing that there's about the weapons.
Read that distinction again, please.
Sure, Your Honor. I pulled up the. Let me just pull up the actual jury instruction that separates the two of them, because if we're looking at this, the difference between criminal reckless and criminal negligence. This is from the jury instructions. Both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal reckless requires that the person engaging in the conduct be aware of that risk, while criminal negligence requires that the person engaging in that conduct should have been aware of that risk. In this case, I don't think there's anything that puts that portion of it at play. As to the difference of whether or not the defendant did or should have known. He states he has weapons training, and I don't necessarily know that's in play. I would just note, if defense counsel was going to do this, the least thing they could have done is draft it for us. If the court wants to add it, I'm working on it now.
I agree with the state. I don't think under that case, I don't think it's the same. I don't think it applies. I don't think it applies based on the facts and the testimony. The state makes a salient point somewhere out of nowhere on redirect to defense questioning. Somehow, I think it was a surprise to everyone, the defendant says he has weapons training. That's a very salient point. I'm not giving negligence. If the defense has given or modified that last sentence or two on the special instruction, email it to my clerk, e-file the final version. I guess you can e-file the other versions just for the record, but then I want to bring the jury in and give them the instructions, which will take a bit, and proceed to closings.
Violet, when he means working on
modify that special instruction,
they're
please.
literally typing right now, trying to prepare jury
Did he file
instructions.
that and submit that?
Hang on a second.
Usually you just type it in Word and format it with double spacing in the proper font, and you give it to the judge. Just emailing it to him. So that's when he said he's working on it. I've been in that situation. You're sitting in court and you're typing out and banging out a new jury instruction right then and there. Darren, it worked pretty good for Kyle. Darren Richings, he probably worked as like schmuck security somewhere for a company guarding like a warehouse maybe at some point, but he was trying to ham up I'm working with the Coast Guard and making people think he's a good person. Yes, Violet, the way the instructions work, the defense will come up with some, the prosecutor will come up with some, and then the court has a general instruction list, and you kind of add to it, and then you argue over which ones are applicable. I actually cover this in one of my videos. I talked about when the Kyle Rittenhouse trial, what do you do when the jury's out for deliberation? I cover a little bit about jury instructions, I think, in there. Is a verdict going to happen today? Yeah, I don't think this will take them very long to come back.
All right, 2-minute recess. My clerk's printing.
Lori, I'd say probably no more than 5 to 10 minutes before the jury shows up. But the judge reading instructions is going to be very boring. Kyle, when he takes it under advisement, he's been advised by counsel, and then he's going to make a decision later. That's his polite way of saying, I'm not going to do this right now. Violet, if they just said guilty from the jury box, they should be thrown out, and then I would argue a dismissal. No, Don, he has not done instructions yet. They're still discussing what needs to be in the instructions for the final draft. David, as much as I would like to hope from the start that I was on Theodore's side, the facts don't support him. I don't think it's a racial issue. He just doesn't have a case of self-defense. Darren Richings, he has to go on the stand. They can't prove other things that happened through the other witnesses, then he has to take the stand. Even though a trial is about fact, did a crime occur or did it not, you have to tell a story at the end of the day. A story has to show you the context of what happened. And for a jury, they always want to know why. Even though that's never a point, juries want to know why. And for a self-defense case, you killed a man, the jury's going to want to know, why did you do it? And I can tell you definitely that happens. Jurors want to know why. I've had jurors come up to me after cases and ask me questions about how did this happen or why did this happen, because I know facts that lead up to things through the police reports, and I explain it to them, and sometimes it makes sense for them, and it gives them that closure, because it's like watching a movie and you don't get the full plot. You don't have some of the prior context and lead up. You need to know the why. If you don't know the why, the story's incomplete, and for a lot of people, that'll drive you up the wall. David, if it was the other way around... David Ward, if it was the other way around, I hope that person would be charged. Like, if it was Jason and Theodore instead, I hope Jason would have been charged. I mean, if I had like a time machine right now, I would go in Theodore's waistband and pull his Glock out and go give it to Ahmaud Arbery so he can hose down the McMichaels and get away. I just, this isn't a good one. This isn't a good case of self-defense. You know, even if you switch the parties around, this is just a really bad case. Oh, well, my apologies, Don. I didn't mean to talk down to you. What kind of law do you practice? Well, Matthew, it's 9:30 there, so if they're not breaking till noon, the judge might just let this run all the way and then let the jury have lunch and start deliberations. They don't need an hour and a half. This is going to be horrible. Their opening arguments, both sides were short, sweet, and fast. I think you could present a case in like 30 minutes for closing. I mean, the states, they could just run through it. Boom, 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 boom. Here's where he lied. Here's where it doesn't make sense. Yeah, maybe 45 minutes, I guess, but that's really taxing somebody to force them to listen straight through the whole time. This hour and 30-minute nonsense, you don't need that much time. Ed, as far as a chance of a retrial, uh, if you're talking about on an appeal, I don't see any massive evidentiary grounds. I mean, maybe there's something in Wisconsin law I'm not aware of, but if this were in Ohio and you hired me to do the appeal, I mean, I would argue a bunch of points, but I'm not counting on the appeals court sustaining any of them. They'd overrule all the objections and then confirm the sentence. Canadian Dawn, that's correct. The judge cannot overrule or redirect a guilty or not guilty verdict. And guys, I know there's some arguments in here and some issues being talked about race-wise. Uh, let's be fair. There have been times where people of, black people or other minorities have been in situations where they probably had the right to act a certain way and were wrongly convicted, or that they were attacked and their aggressors were not charged. So, I understand some of the angst there. So I don't think it's unreasonable to see, well, maybe in this case that was the case as well. But if you look at it from 10,000 feet and then you look at it closer and closer, this is just an average murder. There's nothing special to it. And Lil Miss, you kind of bring up the whole issue about racism. There's nothing wrong with talking about race, but to accuse people of racism, I'm willing to do it a lot in the chat. Guys, I'm an attorney. I'm probably fairly libertarian when it comes to stuff, so I'm willing to put up with a lot. But you don't need to attack each other. So as long as you guys don't do that, I'm willing to let pretty much everything slide. And race is important. You can't ignore it when it comes to societal issues, especially in America. Now, are they always important? No. Are they always going to be something that controls a narrative or an argument? No, but some people, they may feel it's more important than others, but you guys need to talk about it. David, I honestly don't think race has a factor to play here. He's just a normal dude who murdered a guy. If somebody wants to attack me, fuck them. I really don't care. I'm the one on here talking and offering my piece. Adam, we don't need to talk about uniform crime statistics. Darren, thank you for the statistical analysis. Stacy, it's for some people to look at this not through the lens of race. I mean, for some people, you can't deny them that shaped their life. I mean, I think the Ahmaud Arbery case is a great example. That wasn't prosecuted for a while, and I think that it was wrong that it wasn't prosecuted. And that had there been no video footage of it, that would have been completely swept under the rug, and that would have been a fucking travesty had that happened. That would have been a miscarriage of justice. So, I understand that there's that, trauma that exists. Now, Do I think that should be seen all the time? No, but I also think it's wrong to act like, well, it's never there. Do I think the McMichaels will win their appeals? Honestly, I think they might win on the grounds that they were maybe improperly charged during the jury instructions. But at the end of the day, they're still going to be doing a ton of time. So, great, they may get life instead of life without parole, but, for the dad, that's still a death sentence. So, I mean, I could see that happening, but they're not walking out of prison free men. David, Kyle Rittenhouse, if Kyle Rittenhouse was black and some black guy mowed down a couple of white dudes coming at him, I would totally be fine with that. I totally would. Or like when the NFAC, the Not Fucking Around Coalition people were doing their march, if some Klansmen rode up and that entire column of armed black people air conditioned the shit out of a pickup truck full of Klansmen, okay, cool. So it's, when people say, well, if Kyle was black, well, find me a similar situation. Like, it's got to be fairly close for us to make comparisons. John, why can a judge reverse a guilty verdict but not a not guilty verdict? Well, a jury may incorrectly convict somebody if the evidence clearly doesn't support that. And the judge should be able to stop that from happening. So they have the right, if it's clear the jury has lost their way and they convict, he should be allowed to stop that. If the jury decides he hasn't met the burden and they decide to acquit what's obviously a guilty man, that's, how's the judge to know that they really don't believe the state? I think that's sacrosanct and it should be protected, because otherwise you get to countries like, well, pretty much everywhere. Even countries we share a common legal heritage with, Canada, Australia, New Zealand, Britain, you can appeal acquittals. In Canada, a court can overturn it and say, nope, that was the wrong verdict. I don't like that idea. If the jury acquits, that's it. Sorry, game over, them's the breaks. Guys, seriously, we're not talking about the FBI crime statistics right now. We can maybe do that another day, but let's not do that right now. Jules, when you mentioned the lawyers are talking about money, I mean, were they talking about what they're making watching this, or are they talking about the cost of defending a case like this? Chris Garrett, I do think he did exercise decent means of retreat. If he kept on riding down the bridge, there's like a little concrete wall, but at the end of the bridge, the wall stops. So guess what? That car following you is still right on your ass. So it's a temporary retreat. Also, he could go down the stairs. But to go down the stairs while you're somebody who's trying to fight you, well, that's dangerous. I mean, they could shove you down the stairs, you could trip and fall trying to get away. That's a dangerous move, turning your back on your aggressor. You're not expected to do that either. And then also the 20-foot drop, I think everybody agrees that it's like a 20-foot drop if he jumped. 20 feet is enough to kill you. It certainly would be a serious injury. So you're not expected to risk injury to retreat. And I don't think Wisconsin has a duty to retreat either. So, I think it's being showed that Theodore had no other choice. And in that situation, being boxed in like that, I don't blame him because you can't outrun the car either. Yeah, I will give David credit for not crying, but I will say, in Kyle Rittenhouse's defense, I think that was 100% legitimate. It sounds like he has massive PTSD from that entire situation. Now, Kim Potter crying, yeah, I think she's crying because she realized she fucked up and was, that was the worst part for her. But yeah, I think I think Theodore handled himself very well. I think he's got a lot of composure, so I don't blame him for not crying as much as some people think he should have. Well, Darren, he didn't say that they were the KKK chasing him, but he felt like, oh no, it's a group of people chasing me down after I punched a white person. This could be all his friends, and, it's like a de facto lynching or a mob coming after him. So he's saying it wasn't exactly the KKK, but he's like, it felt like it.
I am living proof.
Sorry, guys. Like I said, I just double check every once in a while. I don't want him to move on without us. Sandow Legal, I don't think the argument was that his public defender who's handling his misdemeanor cases would defend him here, but it's that person could help arrange for him to turn himself in, or more importantly, they would contact another person in the public defender's office who handles the serious crimes to get in touch with Theodore and have them work on the case. Because I think that's ultimately what would happen. I mean, I worked in a public defender's office for a bit, and I remember working, and somebody came into the front desk and said, hey, I've got an issue with some minor things. I was able to talk to him about it, but a guy came in, he said, I have a warrant out for attempted murder. I said, hang tight, we need to get you in touch with one of the other attorneys who was a lot older and more experienced. And I got a hold of him, and the guy came over, my colleague came over and talked to the guy. I think that was really what they were getting at, that he didn't take advantage of that option. And then feigning ignorance, like, oh, I don't know what kind of law they do. Like, okay, he knew what was going on, and it's clear he knew that they were public defenders as it came out on redirect. Sue, I don't like the way Halderson's attorneys did it. There was more than enough they could have done to point the finger at the girlfriend that she was the one who killed them. I think that may have been an issue of Chandler telling them not to do it and them respecting that wish, but I really would have done it anyway, because otherwise Chandler goes to prison for life without parole for this manipulative girl, and she could have, he could have probably gotten a lot lesser sentence. So, no, I don't think they did it right. They should have gone harder in the paint. Now, I do understand the theory. Maybe he did say, yeah, I did it and I enjoyed it and I ate my mom's brains. And if that's the case, then yes, I understand they're stuck with what they have. But they can still attack the girlfriend because they don't have to put him on the stand. Yeah, like I said, Sue, there were a lot of issues that they could have used to deflect blame onto the girlfriend and suspicion, but they didn't do it. I don't know why. At the end of the day, the jury still could have convicted Chandler, so I don't know how much that would have helped at the end. Violet, I don't know that she didn't do it. I have no idea. Maybe Chandler did it, but I also think it's fair to say she definitely helped. Either she did it or she helped him. I don't know the true nature of it. Like, let's be real. There's no way this happened and she had no idea. She definitely played a role. Dawn, I have no idea when court's set to begin at this point. Who knows what's going on? Uh, Maybe Theodore ran back off to Kentucky. Meunier, if I'm butchering that, I apologize. Why did the wife lie? I covered this in my recap. I think that she thought that was her way of helping things. That, oh no, if it comes out that my husband did say what the fuck, or maybe he did drop the N-bomb. Maybe he did. She's going to say, oh no, they're going to hate him and think he's a racist piece of shit, and then they're going to say, it's good Theodore killed him. And that, oh no, it looks like he ran towards the fight and wanted to cause problems. They're going to say, oh, well, fuck Jason, he got what he deserved for messing around. That was her way, I think, of trying to help. She wanted to church it up and soften the blow. But, I mean, people saw clearly right through that. It was clear she was lying. I guarantee you the jurors even thought, if you ask them, they know she's lying. CB, yeah, but it takes like 2 seconds to print the jury instructions. It's probably a total of like 15 pages. And like using a laserjet printer, they'll shoot them out like a machine gun. So they should all have it by now. Johnny, what's this about cocaine? Kassan, why didn't the wife get charged? There's got to be some foreseeability in your actions, you know. Also, number two, if you're the prosecutor, you're an elected official. So, not this guy who's been trying the case, but his boss is an elected official. That doesn't look good in the press if you prosecute somebody like that. And then finally, and I'd argue this is probably the most important thing, if you guys go back and watch my one video about the truck driver in Colorado, when you are a prosecutor and you charge someone, you have to look at, okay, did they break the law? Sure. Is there a theoretical possibility they've broken the law? Maybe. Does it serve the interest of justice? What do we get out of this as a society? Does this help protect us from a very bad person? Does it set a standard that show people we're not going to tolerate X, Y, and Z tomfoolery anymore? And then just simply, does this make sense? To waste all this time, these resources, give this person a criminal charge, possibly convict them, possibly incarcerate them. You know, for Evangeline and Clearman, does it make sense that we should do that? No, I don't think so. And then for the aiding and abetting, yeah, that one's probably a little more realistic, but still, at the end of the day, does that really help us here? I'd argue no, it does not. Well, and Dominic Black is a perfect example of that, Binger going after him. But Binger's a piece of shit, so pieces of shit act like pieces of shit. And Binger was upset. I bet if he had convicted Kyle, he would have let Dominic off the hook, but, you know, he just ate a big L. I mean, Binger ate shit on national TV. You gotta get your win in somewhere, and that plea was a win for him. Well, funny lady, even if there are points of law, maybe I can get all the law to stick. I meet all the elements. Should I still do it? I talk about this in there, just like in Jurassic Park. If you spend too much time thinking about can you do it, it's the issue of should you do it. Oh, yes, Thomas C. Binger is a shit-healing motherfucker. He's a very slick attorney, but overall he's a piece of shit. And I would not want him as my neighbor.
I've got a jury waiting,
I
gentlemen.
apologize for swearing like
Mr.
that,
Huebner.
but that's really how I feel.
I'm willing to allow the negligent, although self-defense wouldn't apply to it under the theory that the defense is trying to get it in this situation. So it has been modified that way. Then after I did that...
Ooh, we're allowing negligent homicide.
So you're, can I characterize it as reluctantly stipulating to the instruction on negligent homicide? Yes. Fine,
He's
because
guilty
as
of
I said off
negligent
the
homicide.
record, I was not going to give it. I think the decision in Watkins, which I glanced at yesterday and had a bit more time to review while we were off the record, is a different situation. But if the state's stipulating, fine, I'll give the instruction on negligent homicide. Now I think we've reached the point where literally the jury can consider every form of homicide that exists in the Wisconsin statutes, correct? Am I missing one?
Felony murder, you're missing felony murder. I'm not asking for felony murder.
Well, please don't, because we've already given 5 of the 6 possible homicide instructions that exist in Wisconsin. I'd like to not set the world record for lengthy jury instructions. Mr. Mott, I hope we're done discussing this. Is there another issue?
The last issue, placing on the record, states objecting, but I think if we're doing the negligent, then the accident 772 should be given. I know this. The accident 772 instruction should be given based on what was elicited in cross. That's
Huebner knows he's going to get a conviction. That's why he doesn't care.
Mr. Huebner.
Your Honor, accident is him trying to state
accident's an affirmative
trying to
defense.
allege that he did not have the mental state in order to commit the negligent. If their whole point is that it was criminal negligence.
I'm not clear what the point is at this point. Maybe it'll be illuminating to listen to the closings, and the jury is the ultimate arbiter. The jury will consider the evidence. The jury will render a verdict. But I'm extremely confused by the point the defense has been trying to make. They tried to make one point for an entire 6 or 7 days. Then their client took the stand and basically changed what was being implied, if not directly argued to the jury. Mr. Edgecomb did everything he could yesterday to say, the gun just went off. So I'm not clear what point the defense is making. Maybe we'll find out at the closings.
Anyway, I don't think accident applies with this fact pattern. It applied in that other, in the case the defense is referring to. It doesn't apply to this. The defendant is not disavowing the mental state. In fact, he's in fact stating he had the mental state, especially based on his weapons training. So therefore, Sorry, I'm trying to get
I don't blame the state. By the way, gentlemen, we discussed a lot of this yesterday. We spent 45 minutes on instructions yesterday. It's frustrating when the defense adds all these additional requests on the morning I'm going to instruct the jury. I told the jury to be here between 8:45 and 9. They were all here by 8:45. It is now 10 o'clock.
This is
It
a
benefits
constant
no
theme
one,
with
and it
the
is not
defense.
fair to a jury to have them sit in the jury room hour upon hour.
This is why he has problems with the defense. They should have brought this up yesterday and been ready to go, but they do stuff at the last minute.
772 accident does not apply, and I'm not giving it.
So he's going to get convicted of something,
That
pretty
request
much.
is denied. So, give me a minute, as we've now done, I think, 4 separate versions or 3 or 4 versions of the instructions. Hang on.
Tony, that's not always the case. I've been in court before, and I had a really nasty habit when I started practicing. I would be in court, and I would start just running ahead of the court reporter, and she couldn't keep up. Sometimes if I get really going, I might start mumbling or just flying through it, and I'm told to slow down. But also, when people start talking, some court reporters, the minute somebody else talks, it screws up what they're doing. So I don't think she's that bad. It's a hard thing to do, court reporting. Precious, you haven't missed anything. We're still not starting closing arguments. The only thing that's new is negligent homicide will be something the jury can consider. Violet, this actually may help because this is a lesser charge. So if negligent homicide gets in and he gets convicted of that, I think you have to consider that a win from Theodore's position. Matthew, I think a public defender would have done better, but also I think a lot of other attorneys would have done better for Theodore. If he gets convicted of the lessers, I don't think life is an option. Forget Wisconsin's murder statutes at this point, though.
All right, having the jury brought in. Everybody can remain seated and silent, not just when the instructions are being read, but during closing arguments and the like, please.
Wolfie Master, he apparently did get money to pay and money was raised, but I don't know how much they were charged for this, but like I said before, and I've said it in my other videos, whatever he paid them is a crime because these guys have ripped him off. Lisa, no, they usually don't give you the benefit of the doubt when your attorneys suck. A lot of them don't realize necessarily that you're screwing up as an attorney, so that I've never heard of that happening. Beeps, this judge's decision is that they don't stand for the jury. It is weird, and very typically you do stand for the jury, but I think Judge Borowski just doesn't care. He does it. He can do it however he wants. It's his courtroom.
Fine, the jury's coming in.
So if there was that big a COVID concern, I think they would make everybody sit at their tables to ask questions. Randy, actually, in many courtrooms, you do have to stand up, and if you don't stand for the jury, you won't have a good day in front of the judge.
Welcome back, ladies and gentlemen.
Guy, this was not a good self-defense
I'm
case
sure
gone bad.
over
This
the
was a
last
bad
week
self-defense
plus, at times
case
you must
that
think, geez, Borowski cannot tell time.
turned out bad.
Because I said you'd been around 9, and it's more like 10. We've been discussing a few things, discussing the jury instructions. I'm going to read you the jury instructions. The jury instructions are frankly rather lengthy. They're somewhat, if not complicated, at least involved. So I don't expect you to memorize them. You don't have your notepads. You don't need your notepads. There's no way you can memorize them. Rain Man couldn't memorize them, okay? So you will get a copy of the instructions when you deliberate after the instructions and the closing arguments. Ladies and gentlemen, members of the jury, as I've said, I will now instruct you on the principles of law which you are obligated to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law that I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and judgment, reach your verdict. If any member of the jury, if any of you has an impression of my opinion as to whether the defendant is guilty or not guilty, you are to disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the judges of the facts. The court is the judge of the law only. Evidence. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, any exhibits the court received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I have directed you to find. Anything you may have seen or heard outside of court is not evidence. You are to decide this case solely and only on the evidence offered and received during the trial. As you know, in this case, the information charges first-degree intentional homicide, use of a dangerous weapon. It's alleged that on or about September 22nd of 2020 at 1750 North Holton Street in Milwaukee County, the defendant did cause the death of Jason Clearman, another human being, with the intent to kill that person, contrary to the Wisconsin statutes. To this charge, the defendant has pled not guilty, which means the state must prove every element of the charged offense beyond a reasonable doubt. Crimes to consider. First-degree intentional homicide, self-defense, second-degree intentional homicide, first-degree reckless homicide, and second-degree reckless homicide. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide or second-degree reckless homicide, or finally, homicide by negligent use of a weapon, all of which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crimes referred to as first and second degree intentional homicide and first and second degree reckless homicide and homicide by negligent use of a dangerous weapon are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant cause the death of the victim. First and second degree intentional homicide require that the state prove the additional fact that the defendant acted with the intent to kill. First and second degree reckless homicide require that the defendant acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Homicide by negligent handling of a dangerous weapon requires that the defendant cause the death of the victim by criminally negligent conduct in the operation or handling of a dangerous weapon. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense. The criminal code in Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use force. Let me back up. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. Provocation. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he or she is in imminent danger of death or great bodily harm, he or she may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he or she reasonably believes that he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. A person who provokes an attack may regain the right to use or threaten force if the person in good faith withdraws from the fight and gives adequate notice of the withdrawal to his assailant. A person who provokes an attack, whether by lawful or unlawful conduct, with the intent to use such an attack as an excuse to cause death or great bodily harm to another person is not entitled to use or threaten force in self-defense. Retreat. In determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. As applied to this case, the effect of the law of self-defense is as follows. The defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent an imminent death or great bodily harm to himself. Continuing, the defendant is guilty of second-degree intentional homicide if the defendant caused the death of Jason Clearman with the intent to kill and actually believed the force was necessary to prevent imminent death or great bodily harm, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if the defendant caused the death of Jason Clearman with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of Jason Clearman by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. The defendant is guilty of second-degree reckless homicide if the defendant caused the death of Jason Clearman by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty of first or second degree intentional homicide or for first or second degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed gentlemen. I just discussed something with the attorneys, obviously, just to clarify it. Let me reread that last sentence and then continue. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first or second degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will then be instructed to consider the last offense of negligent homicide. The facts necessary to constitute each crime will now be defined for you, explained in greater detail. First-degree intentional homicide, as defined in the criminal code, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The burden of proof. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Jason Clearman. Cause means the defendant's act was a substantial factor in producing the death. 2, the defendant acted with the intent to kill Jason Clearman. And 3, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the action. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances, in this case, bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While a motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, the defendant did not actually believe he was in imminent danger of death or great bodily harm, or 2, that the defendant did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be considered only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Clearman with the intent to kill, and the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant or must not find the defendant guilty of first-degree intentional homicide. And you must then consider whether the defendant is guilty of second-degree intentional homicide as defined in the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on that charge, on the charge of first-degree intentional homicide, you then should and must consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Jason Clearman. 2, the defendant acted with the intent to kill Jason Clearman. And 3, the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in the circumstances of the defendant would not have believed he was preventing or terminating an unlawful interference with his person. Or 2, that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm. Or 3, that a reasonable person in the circumstances of the defendant would not have believed that the amount of force necessary, amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts or actions, and not from the viewpoint of you, the jury, now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. Your decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Clearman with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of second-degree intentional homicide, and you then must consider whether the defendant is guilty of first-degree reckless homicide as defined in the Wisconsin Criminal Code. This homicide is also a lesser included offense of first-degree intentional homicide. You should and must make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on the charge of second-degree intentional homicide, you should and must then consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, the defendant caused the death of Jason Clearman. Cause means the defendant's act was a substantial factor in producing the death. Two, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death of great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all evidence in this case that the risk was unreasonable. And three, the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. Again, the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death, disregard, to the extent that it helps you decide whether or not the circumstances consider utter disregard the defendant's human life after the death occurred, to the extent that it helps you decide the jury's whether decision, or not the circumstances, if you're satisfied beyond a reasonable doubt that the defendant caused the death, to the extent that it helps you decide the jury's criminally reckless conduct, if you're satisfied beyond a reasonable doubt circumstances show utter disregard for the death, to the extent that it helps you find the defendant guilty criminally reckless conduct, if you're satisfied beyond. And if you are not so satisfied, you must not find the defendant guilty of first-degree reckless homicide, and you should and must then consider whether the defendant is guilty of second-degree reckless homicide in violation of the Criminal Code of Wisconsin. Second-degree reckless homicide is a lesser included offense of first-degree reckless homicide. Again, you should and must make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of first-degree, you should then consider whether the defendant is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by a person who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide. The difference between those two homicides is that the first-degree reckless homicide offense requires the proof of one addition. That is, that the circumstances of the defendant's conduct showed utter disregard for human life. If you're satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring the circumstances of the conduct showing utter disregard for human life, you should find the defendant guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Jason Clearman by criminally reckless conduct, you should find the defendant guilty of second-degree reckless homicide. If you are not so satisfied, you must not find the defendant guilty of second-degree reckless homicide. You then should and must consider whether the defendant is guilty of homicide by negligent handling of a dangerous weapon in violation of the Wisconsin Criminal Code. That offense is a lesser included offense of first and second-degree reckless homicide. Just should and must make every reasonable effort to agree unanimously on the charge of before considering the offense of homicide by negligent handling of a dangerous weapon. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of second-degree reckless homicide, consider whether the defendant is guilty of homicide by the negligent handling of a dangerous weapon. Homicide by negligent handling of a dangerous weapon is committed by one who causes the death of another human being, handling of a dangerous weapon. The burden of proof this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant operated or handled a dangerous weapon. 2, the defendant operated or handled a dangerous weapon in a manner constituting criminal negligence. 3, the defendant's operation or handling of a dangerous weapon in a manner constituting criminal negligence caused the death of Jason Clearman. Cause, again, means the defendant's act was a substantial factor in producing the death. Dangerous weapon. Dangerous weapon means a firearm, whether loaded or unloaded. A firearm is a weapon that acts with the force of gunpowder. Criminal negligence. Criminal negligence means a defendant's operation or handling of a dangerous weapon created a risk of death or great bodily harm, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant should have been aware that his operation or handling of a dangerous weapon created the unreasonable and substantial risk of death or great bodily harm. The difference between criminal recklessness and criminal negligence. Criminal recklessness and criminal negligence both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal recklessness requires that the person engaging in that conduct be aware of that risk, while criminal negligence requires that the person engaging in the conduct should have been aware of that risk. The jury's decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Clearman by criminal negligence in the operation or handling of a dangerous weapon, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. You are not, and these are all important, but this is important, you are not in any event to find the defendant guilty of more than one of those offenses. Use or possession of a dangerous weapon. The information, the charges in this case allege not only that the defendant committed the crime of either first or second degree intentional or first or second degree reckless homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty of any of those foregoing offenses, you must answer the following question. Did the defendant commit the crime of first or second degree intentional or first or second degree reckless homicide while using a dangerous weapon? Dangerous weapon means a firearm, whether loaded or unloaded. Before you may answer the second question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer that question, no. I told you guys these were long. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless during your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of proof. The burden of establishing every fact necessary to constitute guilt is on the state. Before you can return a guilty verdict, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. Reasonable doubt. Reasonable doubt means a doubt based on reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt based on guesswork or speculation. A doubt which arises merely from sympathy or from the fear of returning a guilty verdict is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of making a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. The information which I read from earlier is nothing more than a written, formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Improper questions. You are to disregard entirely any question that I, as the court, did not allow to be answered. You are not to guess at what a witness's answer may have been. If a question itself suggested certain information might be true, ignore the suggestion and do not consider that as evidence. Objections. The lawyers for both sides have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over an objection of an attorney, I, as the court, am not indicating any opinion about the evidence. You, the jury, you jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Expert opinion. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. You should consider the qualifications and credibility of any expert, the facts upon which any opinion is based, and the reasons for any opinion. Opinion evidence was received in this case to help you reach a conclusion. However, you are not bound by any expert's opinion. Circumstantial evidence. It is not necessary that every fact be proven directly by a witness or an exhibit. A fact can be proven indirectly by circumstantial evidence. Circumstantial evidence is evidence from which you, the jury, may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you, the jury, to decide. Exhibits. An exhibit becomes evidence only when it's received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Police reports. During the course of the trial, the lawyers may have referred to or used police reports with witnesses. In most cases, these reports will not be provided to you. If you are not provided a police report, you need to use your collective memory regarding any reference to such report. The weight of the evidence. The weight of the evidence does not depend on the number of witnesses on either side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. The jury's knowledge. In weighing the evidence, you, as the jury, may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Credibility. It is your duty, the duty of the jury, to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. If you believe that any of the parties or the court has an opinion as to the credibility of a certain witness, disregard and do not consider that, as you are the sole judges of the credibility of the witnesses. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the trial, the witness's conduct, appearance, and demeanor on the stand, the clearness or lack of clearness of a witness's recollection, the opportunity the witness had for observing and knowing matters testified about, the reasonableness of a witness's testimony, the apparent intelligence of a witness, any bias or prejudice, if any possible motives to falsify testimony, and all other facts and circumstances during the trial which tend to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. As you know, the defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. You should use the same factors to determine the credibility and the weight of the defendant's testimony that you would use to evaluate the testimony of any other witness. There's not a magic way for you to evaluate testimony. Instead, you need to use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you, and you should do the same thing here. Any remarks or comments by the attorneys are not evidence. If a remark or a comment suggested certain facts not in evidence, you're to disregard that suggestion. Evidence was received in this case that the defendant had other open cases at the time the charged offense was committed. That evidence was allowed only as it pertains to the defendant's credibility and should not be used for any other purpose. Furthermore, evidence was received that the defendant was temporarily restricted from possessing a firearm at the time of the charged offense. While one may be temporarily restricted from possessing a firearm due to court orders, this shall have no bearing on whether the defendant was privileged to act in self-defense. Under the law, the defendant still had the right to act in self-defense at the time of the offense, and you are to decide only whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Finally, evidence was also received that the defendant was on bail at the time of the charged offense. This fact shall also have no effect on your deliberations as to his guilt or innocence as to the charged offense. You are to decide this case solely and only based on the law and facts presented to you during the trial. In just a minute, both sides will make closing arguments. You are to consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. You are to draw your own conclusions from the evidence and decide upon and reach your verdict according to the evidence and under the instructions given to you by the court. At this time, I'm going to ask both sides to make closing statements. I have told both sides that they have a maximum of an hour and a half total each an hour and a half each for closing arguments. I've encouraged both sides to recognize that they don't need to use that entire hour and a half, and they may be shorter, but they will certainly be no longer than an hour and a half. That's a hard stop from this court for both sides. We'll proceed, certainly start and proceed with the closing from the state. Mr. Hubner.
Can everyone hear me? Okay, good. I see that. Ladies and gentlemen, first of all, I want to thank you for your time and your patience. This has taken longer than what you were told it would. You've listened to over 20 witnesses. You've heard over 100 exhibits. You've watched a video. You've seen me drink about 30 Diet Cokes. You've been here for a long time. And you've been patient. We're here about something that almost boggles the mind on how tragic what happened is. On September 22nd of 2020, two different men were heading out. The victim was with his wife. They went to a bar, they went to the happy hour, and then, because he'd been drinking, he asks his wife to drive. They decide, because it's a nice night, to drive down Brady. And he has his window open. Now, ladies and gentlemen, as you've heard, the defendant, well, he left home. And he left home with that firearm he wasn't supposed to have. He left with that firearm, and he's on his bike. And he's walking originally. Now, ladies and gentlemen, there is an incident that occurs. Ms. Clearman testified and told you about how, out of nowhere, in between two cars on the north side of the street, the defendant just kind of juts out. Keep in mind, ladies and gentlemen, that all the security video that we have, that we are able to find, shows him walking his bike on the north side of the street. Everything. Now, there has been a lot of discussion from the defense of, well, there's missing video that would have shown him flying up on a hood of a car and all of this, and the bike gets hit. Ladies and gentlemen, he's able to ride that bike for miles afterwards. There's no damage to the bike. You've seen the bike. There's no anything, any evidence to support that there was ever any hit between the car and the bike, anything. Nothing on the bike, no evidence whatsoever. And defense counsel started this trial by telling you how highly suspicious it was that 745 on Casablanca, which would have captured that, is somehow missing. Except, as the evidence shows, that's not true. You heard from Officer Howard, who watched that period. Nothing was there. The Zanya's Pizza, which covers that same area, doesn't happen. So all of a sudden now, we're moving to Gloriosos. Now that's the missing part. And then the defendant takes the stand and says, not even there, further east. Ladies and gentlemen, the police looked for where that incident occurred. They didn't find it. But regardless of it, ladies and gentlemen, all it was a situation in which Mr. Clearman yelled, possibly swore, and he hurt the defendant's feelings. He wasn't hit. He wasn't injured. There's no damage to the bike. There's no injury to him. And what does the defendant do? I can't let them get away. He gets on his bike. And he follows. He follows them. He goes right past the Dynamite where he's supposed to pick up the sushi. Doesn't care about this special night anymore. He had one thing on his mind. He was irate, and he wanted to catch up, and he sure did. And ladies and gentlemen, his own words to you tell you that this whole thing about him flying up on a car is a lie. Because he says, were you talking to me? He testified, well, he just wanted to see if they were going to admit to hitting him. But that never comes up. What he says is, I want to know if you were talking to me. And then he punches him. He punches the victim straight in the face. He punches the victim, causes his glasses to fly, causes blood to flow. And he gets on his bike, or stays on his bike, and just continues right around that corner. Now, ladies and gentlemen, yes, the victim put his hand on the car door and opened it and then closed it. And yes, he tells his wife to turn. And yes, they pull around and she stops the car. And he, the defendant, is now up on the sidewalk. And he continues to bike towards those stairs are. And then he stops. And ladies and gentlemen, you saw, yes, the victim starts off with that purposeful walk that several witnesses saw. And then, yes, even though some of them don't remember it, he got into that little bit of a jog. And he gets there and he squares up with the defendant. He's there, ladies and gentlemen. As Jose Perez and Jeff Parr told you, it looked like he was going to confront them. His wife even said to the police at the time, yes, she said he was going to talk to him. She told the police he was going to confront him. Confronting could mean yelling at him, asking him a question. Could be meaning to fight him. Could be doing exactly what Rod Trell Cameron said he was going to do, which was get in that boxer stance. He was going to punch the man, according to Rod Trell Cameron, that had punched him. The defendant threw a punch, and then when that person was getting ready to punch back, according to Rod Trell Cameron and Jeffrey Parr and Jose Perez and the victim's wife, he pulls a gun, aims it at the victim's head, and pulls the trigger. Victim drops. So cold-blooded. Rod Trell Cameron is on 911 saying, "You've got to get here. He's still here." When he talks to the police, "Dude's got to go. That was too cold-blooded." Now, ladies and gentlemen, when Jason, the victim, gets there, he has nothing in his hand. Nothing. No weapon. There's no evidence under any circumstances, under any view of anything that has been brought into this case to believe that he had a weapon in his hand. Defense counsel made a very big point over the fact that they were going to have a witness that came in and said that somehow the wife was going through his pockets and they were insinuating as though she was somehow putting the knife in. That also came for what seemed like one of the weirdest sidetracks where the defense was attempting to debate whether or not she even loved her husband. Remember that? A wife that purported to love his husband? Oh my God, she asks, is he right? She's so calm. We're spending all this time when the video that everybody knows about shows her in the back of the squad when the shock begins to fall off and the tears start coming and she goes, "Oh my God, my love. No one will love you like me, my love." She is heartbroken. She held it together as long as she could. Maybe you wouldn't have reacted that way. Maybe defense counsel wouldn't have reacted that way. But to question whether or not a woman who saw her husband's brains blown out of his head in front of her even loves her husband because of some tone is disgusting. And then we get this thing of, yes, she's somehow trying to secret the knife. That makes no sense. First of all, ladies and gentlemen, she told you, she went there, she wanted something, she grabbed his wallet. How do we know that? Because the video showed you. She goes to the cops, "I've got his wallet." We know what she was doing. She grabbed his wallet. Does it make sense? I don't know what I would do if my wife's brains were blown out in front of me. No one knows. Defense counsel questions that and makes it seem like somehow she's trying to take this knife and put it in his pocket. Ladies and gentlemen, in order for that to be true, Miss Clearman, at that moment in time, would have had to realize, I got to take this knife out of his hand. You know what? Instead of throwing it over the wall or putting it in the car or putting it in my purse, I'm going to put it in his pocket. And then, in order for someone to realize, because there's people around, maybe they see me go into his pocket, I'm going to take his wallet. so that I've got a ready excuse. That's the amount of thinking that they're expecting Ms. Clearman to have. And they're forgetting one thing, ladies and gentlemen. When he got punched, Mr. Clearman puts his hand up, remember? And he says to his wife, I'm bleeding. That hand, that right hand, has got blood all in the palm. That right hand, that when he touches, mere touches the car door in order to open and close it, leaves blood on the wall of the door and on the window. So much blood, ladies and gentlemen, that it's literally visible on the car. That bloody hand, in order for defense counsel's point to make any sense, would have had to gone into this pristine pocket by these pants, leaving no blood on the knife or on the pocket or anywhere. Didn't happen. Didn't happen. Mr. Clearman, according to Rotrell Cameron, gets into a boxing stance, and Rotrell said, I just would have boxed him. But the defendant pulls his firearm, he aims it, he puts one right above his eyes, right above the eyebrow, into the victim's brain, which causes him to drop a fatal wound. And keep in mind, ladies and gentlemen, what the ME told you about that. Slightly upward. Slightly upward. Front to back. No left to right deviation. It's a straight-on shot, just like all four witnesses described. Raising his hand with a gun in the hand, because when someone's got a weapon in their hand, you know what it is. You see it. You see that weapon. 4 people saw that gun in his hand. Not because it's down by the side and, oh, there's a lot item or they saw the gun because that was the threat and that was the weapon. And Mr. Clearman takes that bullet into the brain. And what does the defendant do after that, ladies and gentlemen? He runs. He takes off. Instead of taking the direct street there, he ends up taking a bike path in which police would not be able to be driving down. He takes the most obscure way to get to his house where he can't be found or seen by individuals. He gets into the house and he ditches. What does he ditch? The bike. The first thing, the main thing that everyone's saying about who he is the bicyclist. He gets rid of the bike and then he walks and he goes. And all we know is he never comes back. The gun that he used, according to him, he just throws it out the window because he, doesn't want someone to shoot him with it. Something that meant that he kept onto it, held onto this murder weapon for weeks through 2 states until all of a sudden he hits the cornfields of Indiana as though some voice comes out and says, if you ditch it, they won't find you. No, ladies and gentlemen, he's getting rid of the gun 2 states away because he's trying to avoid getting caught. That's why he dyes his hair. That's why he goes on the run. That's why he says he's from the Bahamas and tries every last ditch he can to not be held responsible. And when they come down, he plays dumb in the hopes that we won't be able to put it together on him. And then, ladies and gentlemen, it's all, the victim must have had a knife. And when that falls apart because their witness doesn't see anything in the wife's hands and there's no evidence to support he had anything, not one single witness supports that, all of a sudden, at the 11th hour, we go from, yep, I was defending myself, to it's an accident. He tried to get away. He tried to lie. He tried to play dumb. He tried to say the victim was doing something. And now it's just an accident. Now, ladies and gentlemen, those are the facts. And now you need to consider them in terms of the law. The first count you consider, ladies and gentlemen, is first-degree intentional homicide. The counts and elements are fairly simple. First, did he cause the death of the victim? Clearly he did. He shot him in the head. He falls down almost immediately. It's a mortal injury. It's a substantial factor. The defendant, under all circumstances, is the cause of the victim's death. Did he act with intent to kill? He raises his arm, according to 4 people, and shoots the victim in the face. The gunshot, front to back, slightly upward. That's not consistent with anything the defendant testified to, but it is consistent with 4 witnesses and video that show him with his arm, and the victim goes down. And intent to kill means this, and this is very important. Practically certain to cause death. That the defendant knew that when he shot the victim, it was practically certain to cause death. He told you he's got weapons training with all his maritime security. He's gone to the range. He's been taught on how to hit what he shoots at. Well, he did. And when you shoot and aim at someone's head, that is practically certain. He knew that. That is intent to kill, ladies and gentlemen. That is intent to kill. And now we get to how self-defense factors in. The third element of intentional homicide is that the defendant did not actually believe that the force was necessary. Did not actually believe. But this only comes into play if you don't believe he provoked the attack. A person who engages in conduct likely to provoke an attack and who provokes an attack is not allowed to use force against the attack. However, as defense counsel will tell you and as law says, if he withdraws and he makes it abundantly clear, he can regain that ability. But keep that in mind about actually believing the force was necessary. He is confronted with a man that he punched in the face. That man has no weapon. He has a gun. He withdraws it and he shoots him in the head. He started a fist fight. And then he brought a gun to it. He started a fist fight, and he brought a gun to it. That's what happened. And that's what he did. He did not actually believe he had to shoot the victim in the face. When the victim said words, he punched him. When the victim gets ready for a fight, he kills him. Every escalation of the violence in this case has come from the defendant. Every time. There is no weapon in the victim's hands. Now, ladies and gentlemen, if, for whatever reason, you believe that the defendant did actually believe the force was necessary and did actually believe that he was acting in self-defense and that there was a threat of unlawful interference, and there's no evidence to support other than his incredible testimony, then, ladies and gentlemen, you go to the next question, which is second-degree intentional. Again, he caused the death, intent to kill. There's no doubt about that. But then we get to do not, whether or not the defendant did not reasonably believe that the force was necessary. And if any one of these 3 apply, any one of them apply, then the defendant is guilty of second-degree intentional. A reasonable person would not believe he was preventing or terminating unlawful interference. He punches the victim and then shoots him.
They got to object to that.
Someone who said he just couldn't let the victim get away.
They got to object.
The next one is a reasonable person would not believe he was in danger of imminent death or great bodily harm. When he is looking at the victim, there is no visible weapon. As Rutrell Cameron told you, he just pulls it and he just shot him in the head. Remember that on the 911 call and to the police officer. He just shot him in the head. He just shot him in the head. And then he flees. And the last, ladies and gentlemen, is that a reasonable person would not have believed that the amount of force used was necessary. He brought a gun to a fist fight. He stunned it. That's not reasonable. If, for whatever reason, you do not believe that there is intent to kill, and you should, because under the law, as we've talked about, it's practically certain to cause death. His training, he knew it, he's been trained, he knows how to hit what he shoots at, and he did well, unfortunately in this case. You get to reckless. again, caused the death. We know about that. But then we get into criminally reckless conduct. Did he create a risk of death or great bodily harm? He shot him in the face. Was that unreasonable? Did he know it was unreasonable and substantial? At a close range, when that individual, the victim, according to Mr. Cameron, according to other people, are just going to confront him, no weapons, no punches, no nothing, he pulls a gun and he shoots him, that is unreasonable. He knows what he's doing. He's been trained. And in this situation, ladies and gentlemen, when you get to reckless homicide, the actual and reasonable belief portions of self-defense apply. It's not like an intentional where if, he actually believes, but it's unreasonable, it's second-degree intentional. In first-degree and second-degree reckless, if you find it to be unreasonable what he did, and you should, then he's guilty of either one of those, depending on how you view the last, and this is important, the last element of reckless conduct, utter disregard for human life. And in this situation, ladies and gentlemen, you are told you consider the defendant's conduct after the incident. You shot a man in the face. That's utter disregard for human life. And the last one, ladies and gentlemen, homicide by negligence. This thing that comes out of nowhere. After days of talking about how the defendant was forced out of self-defense to raise the gun and fire it, all of a sudden, after every other thing that has been tried
I would
has
object
failed,
at this point, too.
we now get the gun was pointing down, all of a sudden the guy's spearing him, and it goes off. Except the ME and the witnesses show that that's not what happened. He doesn't get slightly
But yes,
upward,
you can object during closing.
front to back, no left to right deviation. Except for in the way in which 4 people said it. Pulls the gun. Without warning, without anything, and he just shot him in the head. Ladies and gentlemen, in the beginning, defense counsel came up and he said, you see my hand, you see everything, you see everything about my hand. Well, someone did see all portions of a hand. The defendant saw the victim's hands.
Woo,
there was nothing
God.
in it. And he shot him. No weapon. Just a man who's confronting the defendant after the defendant punched him in the face. And for that reason, ladies and gentlemen, he's guilty.
Michael, cover what there's
Hang
to
on one
object
second.
to.
All right, proceed. All right, we'll take a short break. 5 minutes. Everybody can stretch your legs, get a glass of water. Can my bailiffs follow the jury out? Everybody in the gallery, silence, seated until the jury comes out, please.
Okay, Rich, we're not to the jury deciding. The defense still has to go. We're taking a break. Sold for sale paralegal Ashley
All right,
could have
jury's,
fixed this.
jury's out. Short 10-minute recess. Off the record.
Okay, so the part I was saying there should have been an objection to is when he said Theodore brought a gun to a fist fight, and that the way he's stating that, it almost sounds like Theodore's getting his ass kicked and then he goes and pulls out his gun right now. That's not what happened. Theodore punched him and then left. It's a separate fight, and I feel the prosecutor was conflating that and running it all together, which I don't think is proper. Because it's clear, even in the jury instructions, there was a discussion about retreat. And if Theodore retreats, he has the right to self-defense again. And the prosecutor admitted that too. But when he runs it all together sounding like it's one massive fight, that's not right. Immediately I would have objected to slow his roll and get him to be clear about what happened. Does this really change a whole lot? I don't think so, but I couldn't, I wouldn't be able to sit there and let that go by. And yes, you can object at any point in a trial. Opening arguments, closing arguments, the judge is reading jury instructions, the judge is admonishing a jury at the end of the day to go home and not watch the news. You can object at any point. As far as I know, some of you guys are thinking the prosecutor is being unprofessional or why is he yelling and being loud? Well, he's an advocate. He's advocating for a position, and he's allowed to have emotion. He's allowed to have some character come into the argument. And that wasn't improper. You know, part of this, his argument is, can you really fucking believe this guy? You can't. He's saying as professionally, everything this guy said is bullshit. I mean, I thought that was very well done. You know, you are allowed to have emotion when you're the prosecution. It's not just the defense that gets to talk a big game. And also, you know, you could see it when he did the whole, this is my hand, the back of my hand, that the defense brought up. Those are, you know, that's a good attorney who's paying attention. He uses what the other side said against them. Now, I can only imagine what the defense is going to do, but they're not that good. They wouldn't, I'm not expecting something like that from them. Cat's Gallery, correct. They are not evidence. They are the kind of the narrative or what evidence should be looked at, and it's their explanation of the case. Violet, I understand. Also, I apologize, guys. That was kind of I needed to get that out before I forgot about it, so my bad. Violet, yeah, for Theodore, it probably wasn't one fight, but in the eyes of the law, it is two separate fights. Zachary, no. This is far from Binger. Binger was atrocious. No, this is an average prosecution. This guy's been straight up. He's tried to be very fair. When it came to the whole thing about Theodore's convictions, he tried to avoid that by just getting Theodore to admit that he had access to defense attorneys. But when Theodore played dumb, he ended up being forced to go into things like the conviction. So, no, this prosecutor has been very much about trying to do this 100% above board. And a lot of attorneys do. Now, you might find attorneys who might be more hard-nosed in their case presentation or their prosecution of a case, but that's, you know, stylation. Well, miss, lawyers are not actors, we're salesmen. Miss GNX, as far as them objecting throughout the trial, there wasn't a whole lot of objectionable issues that arose, I think, that the defense attorneys could have done. I mean, the prosecution had a very well put together case. They clearly worked with their witnesses. They prepped them. Their witnesses also didn't have anything really scandalous to say. So, no, I mean, the prosecution had a bulletproof case overall. Sue? Okay. Hold on, I gotta close my door to my office. So, Sue, you mentioned these attorneys having a cocktail afterwards. I'll put it like this. I know prosecutors, and when I was a prosecutor, I knew defense attorneys because I interacted with them all the time. And for the Bar Association for my county, yeah, sure. We'll go to the Bar Association meetings. I'll say hello. If I'm out and about, if I go to the grocery store and I see one, yeah, sure, I'll say, hi, Bob. But that's really it. I'm not inviting him over to watch the Browns game. I mean, certainly we're not drinking afterwards after a trial. But that also doesn't mean if I see him crossing the street, I'm going to run him over with my car. It's a professional courtesy, he's a professional colleague. You know, I go hang out with other people. If I'm hanging out with people, it's going to be a defense attorney. So no, I really wouldn't just go hang out with a prosecutor. It just doesn't really work like that. There might be some cases where that happens, but you generally aren't hanging out with the other side. I mean, that looks bad. You know, if you're a defense attorney, that's bad for the brand anyway, looking like you're friends with the cops. Denisha, and if I messed, or Denny, or Danny, if I messed up your name, I'm sorry. Are lawyers allowed to cuss in court other than reading a statement? Or, you know, working with somebody in testimony? No. If he were to go up there and say, that's bullshit, or no fucking way can you believe this guy, or he's a fucking liar. Yeah, that would be bad. You would get in trouble from the court. The court would admonish you. That would look bad in front of the jury. You could be held in contempt, which means, in this case, he wouldn't throw them in jail because that would just blow the case up and make a mess. But he could fine you. He could hold a show cause hearing where the next day, after the trial's over, he'll say, you know, Assistant Prosecutor Hubner, why did you swear in court? You better give me a good reason why. And if he doesn't give a good reason, the judge could say, I fine you $500. I will submit this to the state bar for investigation. I'm going to make you write a letter of apology to the court staff and to the defense attorney and to the defendant and to all of the jurors. He can also say, I'm throwing you in jail for a day or two. That's the extreme version, but no, you're not allowed to swear unless it's part of the case. Guys, and I'm sorry, I kind of blew through all of that, so my bad. Tell me if I need to go over anything. Sometimes I get carried away when I talk, so don't be afraid to tell me to chill out. Was the prosecutor brilliant? I don't think he was brilliant. I think he was fine. You know, he's done a million trials, so he's well practiced. I mean, I would give that like a B plus. It was fine. It was average. It was good. You know, guys, for all of you those who are liking the stream and subscribing, thanks. I appreciate it. I really do. It means a lot to me, actually, believe it or not. Crafting journey, yeah, I've ran into the jury before in other places. I had a trial, and you know, an hour later, I was at the grocery store and ran into a juror. So, yeah, that happens a lot, especially in smaller towns. Elizabeth, manslaughter is not listed as a potential charge that being considered. I'm pretty sure it's not. I got to double check, but I could have sworn it wasn't. They were mainly stuck with the first degree intentional homicide, second degree intentional homicide, first degree reckless, second degree reckless, and criminal homicide. So manslaughter wasn't an option. And I'm not 100% sure how Wisconsin does manslaughter, so it might not even be applicable here. Oh, and the other thing I would have objected to was the state. The other thing I would have objected to is when the prosecutor brought up all of a sudden the brand new charge. That, you know, I think the judge probably would have overruled that, but it's not his job to come in and, oh, well, new stuff's coming out of thin air. The facts by the defendant clearly demonstrate it's possible given his testimony. That shouldn't have been, I think that was improper, but once again, that's not so improper that it'll cause the case to get overturned. But I don't like it when the prosecution makes statements like that. Eric, yes, Edgecomb did punch Clearman first, and then he shot him. But there's a punch, and then there's a big gap. It's not like it's a fight where Clearman was rearing back to punch. Edgecomb left. literally, you have to look at it in the eyes of the law. The fight was over, he ran off. And yes, he caught up to the guy. So that's like a whole round 2. So it wasn't like one continuous fight. Hold on, I'm trying to see here. Let me see. Jules asked, does the prosecution get rebuttal after the defense is closing? Yes. Because they carry the burden of proof, they get the final word. The rebuttal, I don't know if I think their rebuttal is going to be short and sweet, like, this is all nonsense. I think that's what he's going to have to say. Because he won't have enough time to cover every point the defense is probably going to raise. And yeah, be prepared. The defense is going to use every minute available to them. Cheryl, I'm not sure what case I'm going to be covering after this. There's a couple coming up that I'll be looking forward to. I'll just have to see. I mean, I'm not going to lie, I do look on like Court TV and Law and Crime because they're the ones who are covering nationwide trials, and I can kind of figure out what's good and what's not going to be good. There might be a trial or two coming up in Cleveland or the Cleveland area that might be televised. I'll be looking at. In Ohio in June, there is a trial involving a couple of fraternity members being charged with the death of a pledge that was being hazed during like a drinking ceremony. If that gets televised, I really want to cover that because I think it'll be very interesting, because it covers a lot of manslaughter issues, and it's a little bit out of the ordinary. So that's in June, and I'm hoping that does get coverage so we can watch it and talk about it. Also, it's where I went to my undergrad at in Bowling Green. Mike asked how much at all if you think the defendant testifying hurt the case. Well, in a way, he kind of gave himself an out to argue that it was not intentional homicide, which is better if you get convicted. The case was already looking bad. I mean, he can't. It was already in trouble, and I don't think he made it that much worse. It was just an extra nail in the coffin. All the other evidence so far clearly showed he didn't have the right to act in self-defense for lethal force. James, my clients, all I'm doing is watching this. James, I kind of caught up on everything. That's the only reason why I'm doing this today. All the work I had to do coming up for the next week or so, I've pretty much been caught up on. And yeah, I'll be this afternoon dealing with clients, so this is just I have a little bit of free time. I wanted to take a look at it. Jackie, thanks. Mods, if anybody's giving me shit, I'm okay with handling them. I just don't want anybody else being crappy to each other. That's one thing. I'm an adult, I can handle it. I'm also the one here with the microphone, so if somebody like James wants to run his mouth, I'll deal with that. And Maria, it wasn't just the plastic
It's
bag.
11:30.
There was a lot more to Cal Rittenhouse than
their
that.
closing. I would encourage this defense to take the advice the state did and not use the entire hour and a half. It's really not necessary. And 1.5 hours is an absolute hard stop.
The judge is trying to tell them they don't need
I'm going to tell
this.
the jury that I've ordered them lunch. Let's bring them in.
Denisha, think of court like the DMV, except people go to prison. Nothing's ever on time, usually. Ed, they're going to have to let B. Ivory Lamar do it. Anika Mir is not going to be... He's not a persuasive speaker. I would rather have B. Ivory Lamar do a closing. He's very outgoing. He's very vocal. He's got that commanding presence you want. Now, he may be an idiot and suck at his job, but he does have the public speaking part down. He, you know, I think he does a good job at the speaking. It's just what he conveys is garbage.
All right, jury's coming in. Silence in the gallery.
Yes, John Plaster. Yes, can we repeat the question? Lisa, no, he didn't say that, but he also knew the prosecution wasn't going to take 1.5 hours.
All right, the jury back.
Although
the jury,
he may
we're
have
gonna
said
work
that, I
into lunch.
forget.
The defense is going to do their closing. The state will have an opportunity to do rebuttal. I've ordered lunch. Lunch will be waiting for you.
James, no
so we're
worries.
gonna work
I
into
understand.
lunch, get
There
the
are a lot
closings
of
done, and get the case to 12 of you to deliberate. Defense can proceed.
James, there are a lot of shitty lawyers out there, so don't feel bad. It's all good.
Good morning, members of the jury. Robert Kennedy once said, "The glory of justice and the majesty of law are created not just by the Constitution, not by the courts, nor by the officers of the law, nor by the lawyers, but by the men and women who constitute our society, who are the protectors of the law, as they are themselves protected by the law." Members of the jury, it's been over a week now. And as the state has pointed out, you know, I've seen you very active and engaged in this case. You've been taking notes. And this is a traumatic situation, you know, for both parties that's involved in this case. This case has been filled with emotions on both sides of this case. And, you know, we really just thank you for just, you know, keeping an open mind as we go through the process. Now, the state just talked about, when we talked about the other side of the story. Remember that? The defense in this case has established everything that we said we would show you on the other side. The state didn't come up and talk about a wallet. You never heard about a wallet in this case. We told you that the crime scene was contaminated. We told you that seconds afterwards, there was tampering of evidence in this case. We promised that we would show it to you. That promise did not come back void. Now we're talking about a wallet all of a sudden. Now, 1.5 years later, there's an explanation for a wallet. Now, the truth of the matter is, no party here knows exactly what took place on September 22nd of 2020, because the state has not satisfied and filled their burden. They haven't proved anything beyond a reasonable doubt. What they've shown is theories. They haven't proved anything beyond a reasonable doubt. They just came up and said, oh, he didn't have a weapon. And then, yeah, okay, it was a weapon in his pocket. And then they talk about, it was a folded knife in the right pocket. Oh, no big deal. As if it takes so long for a folded knife to become a threat. Here's the knife. It's folded. Could go in a pocket very easily. Here the knife is extended. How long does it take for the knife to go from being extended to being folded? Let's find out. Less than a second. Now it's folded. Now, just at the onset here, I want to discuss a couple things with you. You know, you've heard a lot of testimony in this case, and this is a case that, as you can see, just with the coverage of this case, it evokes a lot of passion. You know, this case it's a precedent-setting case. You know, this is a rare case that has been presented to you where this time there's an African-American man who's now using self-defense against a Caucasian man. You don't see that every day. And he's not just anybody. The evidence is shown he's not just anybody. He's somebody that's well respected in this community and has been referred to by many as a prominent immigration lawyer. So, when you're faced with those circumstances, now I want to be the first to tell you, we put Mr. Edgecomb on the stand yesterday. Now, we thought about not putting him up for a couple reasons. Number one is because the state hadn't even proven their burden to begin with. Mr. Edgecomb insisted, I want to tell my story. We promised you in the opening that we would have him up to tell his story. But Mr. Edgecomb was scared. The same fear that he had after he'd been hunted down by these two individuals. That same fear where he described as being the next Ahmaud Arbery. The same fear he had with turning himself into law enforcement and wondering if he could be taken into custody safely, as he described what he recalled from Sandra Bland. That same fear he exhibited on this stand yesterday. Now the state would say, oh, we can't trust this testimony. Well, let's talk about his testimony. Mr. Edgecomb, we felt it necessary to get out all the bad facts right away. We told you in opening, we're going to talk about the good, the bad, and the ugly. I told you at the very beginning of the opening statement, there's three things. Mr. Edgecomb was not supposed to have a gun. He temporarily, not supposed to be in possession of a firearm at the time. We told you that. He's taking responsibility for that. You heard about Bill jumping charges in this case. He's taking responsibility. We also told you that Mr. Edgecomb did in fact punch Mr. Clarendon. He never disputed it. You heard him come on the stand and take responsibility for it. You heard him come on this stand and say that if I could do this over, yeah, I was upset. Yes, I was infuriated. But if I had another chance to do this, I would simply accept being hit by a vehicle, thrown into another, and being called a nigger. Those were his words on direct examination. What else did he admit on direct examination? See, it's not easy. This is the first time that Mr. Edgecomb ever been set in a witness box before. This is the first time he ever been charged with murder. These are serious charges. Who wouldn't be afraid? Especially in the city of Milwaukee, where you have amongst the largest incarceration rate for African American men. Of course, he had every right to be afraid. Now, you might say, well, why was his demeanor a little bit different with me than he was with the state? Let's talk about that. Well, first, I will tell you, when I first met Mr. Edgecomb, he was a little bit guarded, even with me.
Objection, Your Honor. As to defense counsel testifying as
Sustained.
not in front of the jury.
Sustained.
Mr.
And
Edgecomb.
watch Johnson hyperbole.
Ooh.
Mr. Edgecomb has had fears. He going before a government where it's not popular to use that type of force against another race. Mr. Edgecomb, he was afraid of being tripped up. Now with me, he's a little bit more comfortable. He's got a chance to know myself, an attorney Ahmaud, over the pendency of this case. It's a little bit different. But he understood that one wrong answer could potentially get him convicted of murder. So we talked about before that he has a diagnosis of attention deficit disorder. We don't want to play that up. He's a very intelligent person, but it's real. And sometimes the effects of that show itself when you're in a very highly stressful situation. Attorney Hubner, great attorney. There's times that both of us I've had to exert a certain amount of aggression or a certain amount of assertiveness to get the evidence in this case. The evidence, it doesn't just present itself. Sometimes you have to dig, you have to keep going. And there were times in this case, if you recall, Mr. Edgecomb, was trying to complete a sentence and was not allowed to. He wanted a simple yes or no. Well, every answer does not result in a yes or no answer, but that's the position he was in yesterday. Now, Mr. Edgecomb testified. You heard him say. Now, Mr. Edgecomb had, if you recall on cross-examination, he talked about, the gun went off after he lunged at me. You recall that? He said it a couple times. Mr. Edgecomb believes that he's already made it clear that he shot Mr. Clement. He intended to shoot Mr. Clement to stop a threat. He did not, however, intend to kill someone. There's a big difference. So every question that discussed homicide or murder or blowing someone's brains out, of course, Mr. Edgecomb was taken back by that and did not want to answer a question in a certain way, so he kept resorting to, my actions were in self-defense. I acted in self-defense. Then he went and he understood that part of your consideration, members of the jury, is to consider the reasonableness of his actions. We all know he shot Mr. Clement. We established that in opening statements. The question for you, though, is the reasonableness of those actions. Part of determining the reasonableness of Mr. Edgecomb's actions is when did he decide to shoot Mr. Clement? At what point did he decide to shoot Mr. Clement? That's the question. That goes to reasonableness. So Mr. Edgecomb kept reiterating, the shot went off at the time that he lunged at me. He's trying to explain to you the reasonableness of what he felt was at the time that he shot. He's not trying to imply that, this was just an accident. He's only trying to discuss the time frame. The shot went off after he lunged at me. Now, Mr. Edgecomb's no lawyer, not a doctor. He was on his way. I mean, he had just a few credits away from a psychology degree. He had a bright future. But we all articulate ourselves differently. Members of the jury, we're diverse people. The words I might say to describe something might not be the words that you might use. So we don't discredit Mr. Edgecomb based off of wordplay. So when he says, the gunshot goes off after he lunged at me, then he's followed by a very good aggressive question by the state that says, so it was an accident. So you killed him and it was an accident. Well, let's just think about that for a minute. Can you answer that in a yes or no? If he said yes, he just, that's what he ultimately said. Because he doesn't want to say, I intentionally killed Mr. Clearman. Because remember, he never intentionally tried to kill anyone. He only intentionally tried to stop a threat. Techniques used by a good prosecutor. Please don't hold that against Mr. Edgecomb. Go back to your notes. See what Mr. Edgecomb testified to on direct examination. On direct examination, did Mr. Edgecomb not tell you? I went down the stairs. Then I went home. I put the gun there. Go to your notes. Did Mr. Edgecomb not tell you when I asked him? I was right here, and I asked Mr. Edgecomb, did you give the police your ID at the time you were apprehended in Kentucky? Mr. Edgecomb said what on direct examination? No. On direct examination, I asked him, did you give them a fake name? Did you give the Kentucky Police Department a fake name? What did Mr. Edgecomb say? Yes. I asked on direct, why did you do so? Go to your notes. He explained it. He explained it. Then on direct examination, I also asked Mr. Edgecomb, did the Milwaukee Police Department detectives come down and when they asked you about something happening in Milwaukee, did you say, what happened in Milwaukee? Mr. Edgecomb said, yes, I said that. Members of the jury, there was a follow-up question to that. Why did you say that? When Mr. Edgecomb was comfortable, he answered the questions. When he's comfortable, he did not hesitate to not answer one question. Fear is real. Attention deficit disorder is a disability. It's real. Anxiety is real. Being charged with murder are real feelings. Every other witness that stepped up here, if they had a bad day on the stand, if we got some information out or they answered a question the way that they might not have wanted to, you know what happens to them? Nothing. They go home. They have dinner, they get up to the next day, and that's it. Not when you're the defendant in a murder case. That answer could determine whether you're convicted or not. That's the reality. That's why before he feels like he's getting tricked up on something, can you ask the question again? Now, we talked a lot about, the fear. We talked a lot about, what happened on the stand, and these are red herrings. It's a red herring. It's a distraction. So now let's talk about the state's burden of proof. Let's discuss it. They have the burden. As the court has appropriately indicated, the defense doesn't have to prove anything. Though everything we came up and talked about, we showed you. In opening, we told you. We've shown that. So let's talk about the burden of proof.
I have the same kind of chart I use at trial. This is a good thing to have, and I use this all the freaking time.
Now, as you see, the state has that burden. There's a lot of different thoughts that you might have. When you get different parts of evidence, it might lean you one way or not. So it's important to understand that it's only the state that has the burden of proving something beyond a reasonable doubt. It can't be probably, it can't be maybe. So let's go through what the state's witnesses showed us. In fact, we actually like the state's witnesses. In fact, we would have, there's a couple of people that was noticed on the state's list that we thought were great witnesses, and we called them ourselves. A lot of proving reasonable doubt can be established just off the state's witnesses. For example, let's go to the first slide. So we discussed reasonable doubt. Again, it's not probably guilty. It's not guilt likely. None of that. All that will result in not guilty. If it's not beyond a reasonable doubt, it's not guilty. And at the end of this defense presentation, we're going to ask that you find Mr. Edgecomb guilty on all counts. We started with first degree intentional. You're going to see some lower charges that have been added. We're going to ask that all charges that you find Mr. Edgecomb not guilty. Let's go to the first slide. Mr. Rotrell Cameron. Now, this is probably one of the most memorable witnesses in this case. He's the only witness that was brought in with an orange jumpsuit. Mr. Rotrell Cameron, let's go over the highlights of his testimony. He stated that the incident was cold-blooded. He stated that the shooting appeared to be cold-blooded. That's why the state liked his testimony. That's what he was brought in for. Mr. Cameron testified that he was going to pick up his subpoena
back to your table. We need a break. Let's take the jury out. I need the gallery cleared right now. Bail's out. Everybody out.
Uh-oh.
Quietly and professionally, but out.
Something's going down.
Off the record.
Oops, somebody tossed their cookies, it looks like. No, Adirondack, that guy was in a jumpsuit because he was on a material witness warrant. He actually had no criminal charges pending. It's because the prosecution didn't think he would show up to court, so they had him arrested. I think somebody got sick. I've had a case where a juror or two got sick during trial, which is never during closing. I mean, guys, it's kind of COVID time. It's flu season. Shit happens. All kinds of stuff happens at a trial. Trials can be very wild. Sometimes they're very unremarkable, and sometimes you'd think this was out of a TV script. So, it just happens. So, what happened there, going back, you cannot testify when you're the attorney. You're not allowed to testify. Number one. Number two, you're not allowed to introduce new evidence during a closing argument. All evidence has been submitted. Talking about the personal experience like that, you can't say, I felt that way or he was that way with me, but you could turn around and say, how would you feel? And ask the jury that. You ask the jury, anything you may be thinking, you put that on the jurors to consider, because then it's not you giving testimony. You would say to the jurors, how would you feel sitting in his shoes with an attorney you never met before? How would you feel up on that stand knowing if you feel like if you mess up, you're going to prison for life? There are ways you can do it, but once again, this is where you get to skilled attorneys versus unskilled attorneys. How do you bring this up? How do you go forward with it? What I would tell you is, no, hold on. What are we complaining about? Gabby, he's saying B. Ivory Lamar he's complaining about him, not me. That said, though, I will give Attorney Lamar some credit right now. He's come out, I think, has been doing very well, except for that slip up, and that's really not that big of a deal. That's an oopsie poopsie on the scale of mistakes you can make. Demonstrating the knife, that was a phenomenal thing to do. Because show it to the jury, whip it out, and now the jury gets to see that blade right in front of their face. You wave around a potential weapon. You want them to see that. I think that was a very good thing. He did cover everything they admitted to. But that said, though, the prosecutor is going to hammer them, and I think we know where that's going to come from. But overall, no, I thought he was great. That starting off quote, I've actually used that RFK quote before in a trial. Granted, I saved that one for when it really matters, but there was nothing wrong with the quotes, and I thought that was a great starting. As far as using race, I understand, guys, you don't want to, but I think I mentioned this before. My job is to help my client, and if I can deal the race card, I'll use it. If I can use a card for gender, sexual orientation, play upon emotions, I know you don't want to hear that, but also at the end of the day, let's say you're facing a murder charge. Are you going to sit there and say, if you get convicted, well, at least my attorney didn't do anything underhanded? No, you want your guy to do anything possible to win within the rules. And if you can play on people's emotions and their biases, I will do that. You may not like that, and that may not be the answer you want to hear or you'd expect out of an attorney, but my job is to help my client, not to, that's where it goes at the end of the day. Froyo addiction destroys lives. Yeah. John Plaster, yes, I'm an attorney. I am an attorney out of Cleveland, Ohio. I'm an Ohio licensed attorney, and I had some off time this week, so I thought I'd cover the case. Edgecomb has to testify because none of the other witnesses support his theory. Puck, he has to testify. Unless somebody else could say everything else he claimed happened, then he wouldn't have to. John D., they showed you can't tell anybody on the jury's there, so no, that's not a problem. Yeah, piece of cat hair on me. No, that's not an issue. And yes, Gabby, you're correct. The judge warned them about food poisoning, which, God, that just seems really bad. That somebody finally did get sick. I apologize if I told you guys that thing about race and it's upsetting some of you, but at the end of the day, my job's to advocate for my client, not to just take a knee and hope the clock runs out. Let's see what else you guys are looking at here. The judge isn't biased. Look, guys, if you come think about your job, if whatever job you have, and it's you and a coworker, and you guys have your prospective things to do. If one of you is unproductive, not prepared, and kind of makes a mess of things, and you on the other hand has your shit together, your boss is going to treat you differently. There's only so much a judge can hide when it comes to that, and his comments, his bias, none of that will get an overturn on an appeal. Sharon, yeah, he has a bad attitude, but once again, it's hard to suffer fools and competency like this. After a while, it just wears you down. Well, Adrena, it's in trial. It is a card to play. I'm not saying that racial issues are not something to use. I mean, just like Johnny Cochran said, the race card. He said we dealt the whole damn deck. So I mean, there's nothing wrong with it. It's to help your client. If I can get you acquitted, that's my goal. As long as it doesn't get me in jail or make me lose my law license, then I'll do it. Puck, you ask about why not focusing on the knife more. Well, they did. They focused on it in the sense that there wasn't any image. Nobody saw a knife, and that's how they focused on it. Kind of like it's Schrodinger's knife. It's there, but it's not there. By focusing on the fact nobody saw the knife, then it shows the knife was never in play. I don't think the judge is rushing the case. I know you guys probably saw the Kyle Rittenhouse trial. That Judge Schroeder did not have control of his courtroom. The speed at which this trial has gone is about what, if you go to your county courthouses, on average, you're going to see this, especially in a bigger city where they actually have a substantial docket. For example, go to the other courtrooms in Milwaukee, it's probably going to be similar. Even in a lot of smaller communities, the courtrooms are going to be, especially for felony cases, similar. There's a pattern. It moves. There's this idea of kind of like a drawn out. Some of these TV trials lately have done a disservice in that regard. The Kyle Rittenhouse trial, because it wasn't properly managed. The Ahmaud Arbery situation, there was just so much evidence and so much going on that warranted being a little more deliberate. But this is really a run-of-the-mill murder case. It should be going along. There shouldn't I mean, this is long for a murder case. I mean, like, let's be real. This is very straightforward. Guy A shoots B. Is it self-defense or not? Thomas, I don't know where you live right now, but it's really cold in my neck of the woods. I wouldn't go outside and help. Let's see, what else are you guys asking here? Show enough, yeah, people. I'm pretty sure I've had COVID a couple of times already now at this point from being in court. There's only so much I can do. Especially, I have clients who are in jails. If I go see them or I have to sit next to them in court, I don't put up walls between them because I don't feel that's professional. So I'm pretty sure I've gotten sick from my clients alone or just sick from people in the courthouse. But, kind of what I've said before, shit happens when you play on the road. If I don't want to get sick, I should just work from home. Jeanette Perkins, I think he's a skilled orator, but his work as a defense attorney, he needs a lot of work. Let's see here, what else we got? Nine canines. Yes, much of the way the judge is treating the defense is self-induced. If they had been filing motions properly and timely, every once in a while something may pop up in a trial, and I think the court's okay with that. But, for jury instructions, I think they already knew at the end of the day yesterday they were going to bring up criminal, like negligent homicide. But bringing it up right before they start jury instructions or right before everything starts, that should have been done last night. That should have been sent out to everybody. That wouldn't have been a big deal. Yes, it's just like, a lot of places, if you have a reasonable boss, your conduct kind of sets the tone for how they treat you. Well, if these guys had been a little more on top of things, I think the judge would be treating them differently. Okay, Rich, is this a court disruption that would cause an appeal? No. He's going to appeal this certainly, but will this overturn the case? No. You'd have to show, generally when it comes to an appeal, did this prejudice him? I mean, somebody getting sick, especially another juror, cleaning up the courtroom, I don't think so. They could argue, yeah, this threw off the defense attorney, but at the end of the day, I think an appeals court's going to look at this and say, even if that hadn't happened, would this change the outcome of the trial for Theodore? I think he's going to get convicted no matter what. Maybe he's lucky and somebody decides to hang the jury, but it's what would be called a harmless error. Even if it is an error, even if it is a problem, was this a problem critical enough to cause an issue? Think about it like if you're on an airplane and they run out of drinks on the plane while you're flying flying on a 2-hour flight. Is that a problem? Yes. Is that a big enough problem you should get a refund on your ticket? No. I don't even know if that's a good analogy, but that's really what just came off the top of my head. Donna Cox, no, I just started this channel a little bit ago. I'd like to cover trials as they go. But like I said before, in kind of yesterday's issue, I try to work this around my schedule as an attorney. I kind of just doing this for fun. You know, if this ever turned into something where it's a full-time job, then yeah, I would really be doing this all day long. But if I can, if there's trials available, I certainly would like to. Puck, no, I am in Ohio. I've been doing this, well, I started this like 2 years ago and I did like 2 videos, then kind of got sidetracked. And then in the past like month, I really started doing this again. James, no, like I said, I don't think this was an issue of reversal for anger. The court, it takes a lot to get a case overturned misconduct-wise. And even if you disagree with this judge, nothing he's done so far would probably get an overturn. Maybe Wisconsin's different, I highly doubt it, but in the courts I've been in Ohio where I've done appeals, and I've done appellate work as well, writing appeals for people, yeah, I'd bring this up and say, oh my god, this is a travesty. The appeals court's going to say, nah, no big deal. No worries, no problem. Adrena, I just represent people in the state of Ohio. I am not licensed in other states. Girl who lived. Oh, ineffective assistance of counsel. I know we talked about this just a little bit. It's a very massive mountain to climb. You basically have to show, had they not sucked at their job and they would have done it the right way, he would have been acquitted. You have to show it's that high. There have been cases where attorneys have fallen asleep in trial, and courts have said, nope, not ineffective. It is a high burden. You're more likely to get the case overturned on some evidentiary issue than you are ineffective assistance. That's how hard it is. Do I think it should be that hard? No, but it is what it is nowadays. Are you guys hearing me okay? I'm not too loud or anything, right? So, Sue, you're asking what happens to the other jurors? Well, they have 14 they started with, 12 jurors and 2 alternates. I'm not sure how this judge selects his alternates. Some judges just have all 14 sit together and decides at the end who's going to be the alternates. Either way, we lost one already last week, and now it looks like we're going to lose a second one. Well, now we've got an issue. You've only got 12. If one of them drops out at this point, you're now below 12. What happens? And then another thing I'm just thinking about myself is potentially there could be some of those jurors sitting around saying, I'm not sitting in that courtroom till it's disinfected. Maybe one of them wants to go check to make sure they're not sick and get tested. So we might not have the end of this trial today, theoretically. Jurors arguing from a safety standpoint, who knows what could happen really here. Puck, my opinion of the Judge Borowski, pretty much what most judges are like. The counties I'm in where I practice, I pretty much would expect him. He could be here and I probably wouldn't notice much of a difference. Jody, juries can sit, in some states you're allowed, like Florida, your felony jury can have 6 people. But no, in Wisconsin, your felony jury has 12 people. So you have the right to be tried by 12 people. That's your constitutional right in the state of Wisconsin. A trial by less, well, I think that turns into a mistrial. I know example for in Ohio, you have 12 by the state constitution and by state law. If you don't have 12, it's not a full jury, it's not a fair jury, and it's not an authorized jury. So if you have less, yeah, you got problems. But it's state by state. Like I said, Florida does 6. They're famous for doing that. Other states, you can have varying numbers, up to 12. The judge did a diversion so he could go to his appointment with the Packers. Yeah, he made one of those jurors get sick. Andrea, they might be out of alternates at this point, so that's the concern. It depends on who got sick. Donna, somebody got sick in court, so now we're taking a break. One of the jurors or somebody did. Yeah, Eric, they're not just going to sprinkle the puke dust on this. Judges aren't going to let that happen. James, I fully expected that argument to come up. I didn't bring that up because I don't. If there's arguments out there, I think that somebody's keeping in their pocket. I don't want to spoil something for them. I don't think that's fair. I wouldn't do that for the defense either. But yes, it's a very big point. But there's also, on the other hand, and this is where I think if the defense were smart, they would have had the blood and the DNA experts explain. Just because you touch an item does not mean you leave fingerprints, DNA, or blood on them. Everything can happen. I've had cases where my guy's on camera with a gun in the store, pointing the gun at people. He's got bare hands, and he's holding the gun for like 10 minutes. And there was no DNA, no fingerprints on it. He didn't wipe it down. They didn't stick. Nine canines. I guess I'm Mr. Moderator. Do I think I could get a successful self-defense in this case? No. The facts don't support it. Maybe I could, if I had a bunch of jurors who I could bullshit my way through, maybe. His best bet is to get a hung jury. Hang 1 or 2 people. Or, get him down to criminally negligent homicide. Get him the least severe of the charges. Babylon will fall. Yeah, like I said, there's an issue if that turns into COVID. Out here in the Cleveland area, one of the suburbs, there was a capital murder trial, a death penalty murder case, and there ended up being a COVID issue, and it blew it. The jurors refused to come in and sit because one of the other jurors got full-blown COVID, and it caused a mistrial, and they had to restart everything. So yeah, this could happen, but it's vomiting. I'm thinking that's more like food poisoning or the flu. But yeah, given the state of the coronavirus, people, or the flu-rona, or the heightened ability of getting sick and dying, yeah, I could see that being an issue. Like I said, I don't know. Kimberly, the food poisoning warning by the judge was a joke. I think he was making a lighthearted joke that you don't get sick from the cafeteria downstairs. Sadly, it sounds like somebody got sick from that place. So it was a joke that turned out to be true. Yeah, if it's a juror, they're probably going to ask to be dismissed. I don't know. If I'm the defense attorney, I don't want somebody who's sick and thinking about being miserable sitting on the jury. Number one, I'm not sure the other jurors are going to want to sit next to that person anymore. Number two, and number three, I don't want them getting sick again and fucking up my ability to present a closing argument. Funny lady, yes, if they don't have enough jurors, it'll be mistrial, but I still think they had 13, so this will make 12. Ruthless, no, I don't think it will be a hung jury. He'll probably get convicted of the reckless homicides or the negligent homicide. On the very rare chance, like, outside of most likely possible options, yes, he could get a hung jury, but I don't think that's going to happen. Babylon, it's the issue of self-defense is it has to be proportional. So, you may think you're in fear of death, but it has to be a reasonable fear. So a guy who's about your height, who might be heavier than you, yeah, he says he's going to kill you, but he has to show means of doing it. I can tell you I'm going to kill you, but if I'm just standing there, have I presented a threat? No. I have to show the means of doing it, the immediacy. And even Theodore's statements, I don't think Theodore basically admitted, I don't think he had anything. I don't know if he had anything. Because he said he was focused on the other stuff. Now, if he had been surrounded by a group of people, disparity of force, that could be a weapon because 5 people beating you could be fatal. But he had self-defense from the aspect of if him and Jason Clearman got into a fist fight and he knocked him out. Yeah, he would have had self-defense, but he doesn't have the right to use lethal defense. James, I don't know if she knew she was sick. I mean, I've been sick before where all of a sudden it just comes up and all of a sudden you're barfing. And then it goes away. I mean, sometimes that happens. So I don't necessarily think that's the case. Babylon, if there's a mistrial, oh, I see this going back to trial. I easily could. Usually if it gets to the point where there's a mistrial, for whatever reason, well, if it's not a hung jury and there's a jury issue, then yeah, you definitely mistry it. You retry it because you don't know what happened. But yes, if the jury came back 11-1 not guilty and there was one holdout for guilty, they wouldn't retry it. But this is a pretty clear-cut case. This is murder. It's not self-defense. I see them retrying this one. Adirondack, would I use race? I mean, I think I would a little bit. I would point out, just like he said, like B.I.V. Lamar mentioned, he has concerns about turning himself into the cops because he don't want the cops killing him because all this is going on in 2020. And then he's, the whole issue about, oh my God, these crazy white people are about to run me down and kill me just like Ahmaud Arbery. You got to use what you have, and really that's all they have is the emotional play. So, yeah, you use what you got.
Back in the record on...
Oh, here we go.
Edgecomb, it's 12:15. I discussed the situation with the attorneys. Unfortunately, one of the jurors, about half an hour ago, maybe 20 minutes ago, felt a bit lightheaded. She does not feel well. I'm going to make her, and the lawyers are stipulating to this, the alternate. We have 12. I believe we should continue, finish the closings, and let those 12 deliberate. Either side object to that plan?
No.
Great. All right, I'll bring in the 12. The juror, I'm not sure of her number. We'll make a record of that later. It's a younger white female, will be excused as the alternate, given that she's not feeling well. The remaining 12 will come in.
Kimberly, yes, if there's a mistrial, you can enter new evidence. It's like a whole new restart. The only issue is if you've given prior testimony, the other side can use that against you if you start telling a different story for most of the witnesses. The only person who's probably got the ability to weasel around things is a defendant. So Theodore could come in there and talk about different things, and it would be hard for them to use his prior testimony against him. But all the other witnesses are pretty much locked into what they said. So mainly it's like physical evidence or brand new video. Some random mom, I don't know if the defense was going to get to that, but they may challenge that. They still have to get through their whole argument. Yep, crafting a juror tossed her cookies. Looks like she was about to throw up. Ella, Mrs. Clearman was seen messing around there, but the witness had to admit she didn't get her hand into the right front pocket. So that takes away the idea she put something there or took something away. Okay, Rich, I guarantee you he could crack walnuts with his butt cheeks right now. I'd be nervous too.
All right, jury's coming in. Everyone can remain seated, please.
Active shooter.
All right, the jury's back. Welcome back, everybody. The juror.
I gotta
saw
get
was
something
not
at the
feeling
front
well.
door. I'll be right back, guys.
The lawyers and I have agreed she's the alternate. We excused her. There's 12 of you. The 12 of you will deliberate. My bailiffs have checked on her. She's fine. She felt a little lightheaded. She indicated it might have been something she ate, but she feels fine. She's doing better. So we'll continue. Defense can, if you remember where you were, pick up where you left off, but go ahead, counsel.
So members of the jury, we were talking about the state's burden of proof in this case. And just a quick reminder, a quick review is that the defense in this case doesn't have a burden, have no burden whatsoever. And we discussed prior to the break that majority of the reasonable doubt that can be established in this case can actually come directly from the state's own witnesses. So we're going to go through the testimony of the witnesses in this case, and we're going to show it to you. We're going to show you reasonable doubt in that they cannot satisfy this burden of proof. Let's go to the first slide. So the first witness, we discussed Rotrell Cameron. Well, he was one of the state's first witnesses. And what Rotrell Cameron testified to is he described witnessing the shooting occur, and he described it as the words being cold-blooded. Cold-blooded. He used those words. Now, that's why the state liked Mr. Cameron. That's why he's essentially almost their star witness. He's the one witness who could testify outside of Ms. Clearman, outside of Mr. Edgecomb, who had witnessed the last two incidents that occurred. So we know there was 3 incidents. We know that something started this. Mr. Cameron witnessed the last 2. He described the last final incident as being, it was cold-blooded. Now, what was interesting about Mr. Cameron's testimony is that immediately after he described it as being cold-blooded, he testified that the defendant appeared to be in shock afterwards. Those were his words. He said he appeared to be shocked. I don't know how many cold-blooded, heartless, violent killers are shocked after they shoot somebody intentionally. But that was Mr. Cameron's testimony. So what happened? You seen the state, after they worked hard to get this witness here, you seen the state jump up and start trying to impeach their own star witness. You remember? Do you recall? Mr. Huebner was right here and he said, well, you never said anything about him being in shock before. You didn't tell the detective, the officer, that when he was on the phone with you in the patrol car, you didn't say he was shocked. Remember that? Go look at your notes. That's not consistent with being a cold-blooded killer, the way they're trying to make Mr. Edgecomb to be. This is their witness. We didn't call him. Let's look at what else Mr. Cameron told us. He admitted, after the punch, he used a very key word. Mr. Cameron used a very key word when he described it. He was asked, did Mr. Edgecomb, after he punched Mr. Clement, did he withdraw from that confrontation? He said, yes. He was asked, was he a threat at that point? He said, no. He admitted that Mr. Edgecomb withdrew once he got on his bike from that confrontation. Now, members of the jury, you're going to see that word withdraw again. You're going to see it in the jury instructions. It's going to be under the provocation. See, the state wants you to believe that, oh, well, let's see who started it. If you started it, you can't claim self-defense because you're the aggressor. Well, they forget about a very important word. It's called withdrawal. See, once you terminate and you provide notice,
I apologize, I'm going to eat my lunch.
to the party that you acted aggressively with, you can regain your right to self-defense. That's the law. You're going to see it in the jury instructions. Mr. Cameron, their star witness, testified to this. What else did we get from Mr. Cameron? He admitted that Theodore appeared afraid when he turned the corner. He almost fell trying to evade him on the bike. Cold-blooded killer, violent, heartless, appearing afraid? Those don't even go together. This is their witness. They caught him on this stand. We asked him. So when he turned the corner, he appeared afraid. I said, when he went from the bike lane and jumped the curb, he said, well, he fell. He definitely appeared afraid at that point. When he continued going on the sidewalk, and when he went into this little stairway, he appeared afraid then too. He told you he was trying to go down the stairs. This is their witness. This is their witness. It doesn't matter how loud Mr. Huebner comes up and how passionate he is. These are the facts. Check your notes. Now, the state just came up and tried to make a big deal. Now, let's just get this straight. We started and we said this is a very tragic situation. Our heart goes out to the Clement family. This is a situation that escalated and it should not have. At some point, Mr. Edgecomb was responsible for a part of this incident. He punched Mr. Clement. He got upset because racial slurs was used based off of his testimony, or rather it was a swear word, whatever the case is. At some point, Mr. Edgecomb got upset. We know that. But at the end of the day, this situation escalated, and we're not trying to go back and forth and do victim blaming. That's not what this is about. As the state tries to indicate, they talked about, well, they said, oh, the wife, Miss Claremont, was old. She was not hysterical. She wasn't acting a certain way. We, the defense counsel, never said that. You want to know who said that? Their star witness. Let's go back to Mr. Cameron. Mr. Cameron is who said that. Mr. Cameron described the wife's demeanor as calm, but he was hysterical. That's what he said. That's what their witness said. He said, I thought that was a bit unusual because I was hysterical. I was going crazy. I was on the phone with 911, but she seemed to be calm. We didn't put that at issue. Their witness did. So again, let's just put that for the record. Now, as we talk about different things that happen in this case, it is not to, blame anybody. but it's to show that Mr. Edgecomb cannot be proven guilty beyond a reasonable doubt. That's the purpose. We're showing all these things that appear suspicious. There's a lot of questions that are unanswered in this case. And if the questions are unanswered, they have not fulfilled this burden. This is not about, we've never met Ms. Clement. I don't know her. Either have you. So we don't know what she would or would not have done. We're not sitting there just trying to kill someone. All we're saying is that the possibility exists. And we don't know. So Mr. Edgecomb should not be convicted of murder because we have a lack of knowledge in that area. That's why we go through all these different aspects of the case that seem a bit suspicious or that warrant more explanation. Or we talk about the failures of law enforcement in this case, and the investigators, to not be thorough. And because of the lack of thoroughness, that's why these questions remain. And that's why, ladies and gentlemen of the jury, Mr. Edgecomb should be found not guilty on every single charge. Let's go to the next slide. This is Officer Patrick Tibney. Now, the state called Officer Tibney. Officer Tibney testified that initially
Your Honor, state did not call Officer Tibney. Defense did.
Gotcha. All right, my apologies. If the defense called Officer Tibney, my apologies. So with it, the testimony that was elicited from Officer Tibney, he initially stated it was two potential witnesses that he believed wanted to give statements. But what did the video show? Remember? Remember the end of the video of his body cam? When he goes and he asks another officer and he says, hey, I see a guy standing over there. I see a guy standing over there. He looks like he might have seen something. Should I talk to him? The first officer says, we were wrapping up whatever he says, it was inaudible. So then he goes to Officer Mahalik, who's coming down. And Officer Mahalik, he says, hey, I see a guy over there. Looks like he has some information that could, in this case, I want to go talk to him. Officer Mahalik says, fuck that. We got enough. Fuck that. We got enough. We got the wife. We got this 911 caller. We got this young gentleman right here, which I believe was Jose Perez. He was in the video. We got enough. That's the evidence in this case. How? You never have enough of anything in a homicide investigation. Mr. Clement deserves a full investigation. Guess who else deserves a full investigation? Mr. Edgecomb. He deserves all the facts as well. You don't just jump the theories and rush the judgment.
You're setting yourself up. Stop here.
I mean, this is 43 minutes after the incident occurred on the stairwell. 43 minutes later, you got an officer telling Officer Tibney, we got enough. Members of the jury, you proved guilt beyond a reasonable doubt. You didn't do a thorough investigation. Then the evidence showed with Officer Tibney that he was instructed to turn his body cam off. He asked, hey, are you live? Are you live? Think that's a fair assertion as to are you recording? Is your body cam recording? Think that's a fair deduction? And what Officer Tibney does next is he says, should I cut it? He said, yeah. At that point, that's the end of Officer Tibney's body cam. We don't know what happened after that. This is all reasonable doubt, members of the jury. Next slide. So now we come to Detective Tyler Kirkhope. Now, Officer Kirkhope, he agreed that any time an item is removed from a scene, from a crime scene, it is compromised. That's what he told you. He talked about the duty of a first arriving officer to preserve the scene preservation. He talked about that's why you see the yellow tape immediately after a scene, because you don't want to have evidence tampered with. You don't want that crime scene to be compromised. Members of the jury, it's no longer an allegation as to whether an item was removed in this case. I told you in opening, we're gonna prove it. We've done that. Whether the admission was of a wallet or whatever the item was, an item was removed and the crime scene has now been compromised. That's just it. So how do you prove guilt beyond a reasonable doubt? We don't know. Again, we're not making any, listen, we have to put out theories. We don't know. I don't know any of these individuals of these parties. So, Detective Kirkvold said that no citizen, under any circumstance, should remove anything
Sorry about that,
from
guys.
a
I
crime
didn't mean
scene.
to kill the feed.
It should be further investigated. Detective Kirkvold also said he can't confirm or deny whether an item was removed or placed at the crime scene. This is the lead detective. So what do? We go back to the burden of proof board. This is the detective. Can't prove anything beyond a reasonable doubt when your lead detective can't confirm or deny whether an item was removed or placed at the crime scene. We don't know. Again, it's not an accusation. We just don't know. We don't have enough information. Detective Kirkvold also testified that he doesn't know where the first incident happened and he didn't follow up. He also admitted when asked, I just thought that was unbelievable. The lead detective on the case cannot tell us where precisely the first incident occurred where Mr. Edgecomb and the Clearman had an altercation of some sort involving a vehicle. We don't know. The lead detective does not know. But then we asked the detective, we said, how long would it have taken you to ask Ms. Clearman to get in a vehicle with you and have her show you precisely this is where it happened at? Sounds reasonable? He admitted it would have only taken...
Your Honor, mischaracterizes the statement that was by Detective Alvarado, not Detective Kirkvold.
That may be the case, but it's closings. Let's move on. Go ahead.
Said it would take 5 to 10 minutes. 5 to 10 minutes to have confirmed. So we wouldn't be here a year and a half later, members of the jury, still not knowing precisely and exactly where even the first incident occurred. 5 to 10 minutes. They didn't do it on September 22nd of 2020. They didn't do it on September 23rd. And we asked, have you done it? Have you ever done it? In a year and a half that this case has been going on? No. That shows you the quality of the investigation in this case. Mr. Clearman deserved better. Mr. Edgecomb deserved better. And that is another reason why the state cannot satisfy their burden of proof. Next slide. So members of the jury, we now remember where Detective Alexander Klabundy was called to the stand. I believe, if I'm not mistaken, that he was the state's first witness, I believe. And he testified that the knife found in Mr. Clearman's pocket was a folding knife with a serrated blade, perhaps up to 10 inches in length. He confirmed that police never submitted the knife for DNA fingerprint testing. Here's the knife. You heard in testimony that other items like bottles, eyeglasses, those items clearly would make it really hard to exert deadly force toward anybody, but those items were tested. Why was the knife not tested? he also confirmed that the White Claw can was never tested as well. The White Claw can that was in a back door, that can was never tested either. We don't know whose hands were on these items. And that, ladies and gentlemen of the jury, brings us back to our board. Burden of proof. Can't prove guilt beyond a reasonable doubt. Now, the state came up here and they talked about, well, his hands were bleeding. And his hands were, he came off the door, he got punched, he touched his face at some point. So that's kind of trying to indicate whether or not, the knife should have blood or anything like that. But remember this exhibit, Defense 11? This is the pants pocket of Mr. Clearman. You see specks of something. Could be blood, could be dirt. We don't know. We just don't know. Now, does the state have resources to make that determination so we don't have to guess? Of course they do. This pants pocket could have been submitted to DNA as well. But it wasn't. And that, members of the jury, brings us back to the board again. Proving guilt beyond a reasonable doubt. We wouldn't have to speculate if the state would have done their job. Next slide. Now, it brings us to Ms. Evangelina Clearman. And again, our heart goes out to the Clearman family. Now, let me just get a couple things clear. Just get a couple things clear. We understand that after, seeing or being involved in such a traumatic experience, one would tend to be distraught. That's fair. You don't know how you would react in a situation like that, especially involving a loved one. That's fair.
Be careful, dude.
Now, the issues that we bring are not to any way, blame, victim blaming or anything like that, as we just discussed. But when there's conduct which is somewhat suspect or it brings or begs a question, we have to present it. We have to bring it to your attention so that you, the trier of fact, can determine whether something has been proved beyond a reasonable doubt. So one thing I can say is that, there's several things in this testimony that, we have questions about, some of which, like I said, could be reasonable under the circumstances. But the state has not proven beyond a reasonable doubt. Her testimony is simply not reliable. It's just not. And we're going to go through why. So it doesn't mean that, she's a bad person. It doesn't mean that, there's any type of issue. But it just means that simply because of those circumstances, her testimony is not reliable. Let's start. The first thing that she recalls saying, she said her husband said, "What the heck?" That was her recollection. She said, "What the heck?" Ms. Clearman went and did media interviews, and she told those journalists that Mr. Clearman said, "What the heck?" Fair. Now, on the body cam, we showed you in evidence Ms. Clearman clearly saying, "What the fuck?" Now, the issue is it just goes to the reliability. This could indicate a tendency to water down a situation that was a little more severe than what it actually was. There could have been some things said that was beyond what the fuck, as Mr. Edgecomb claims in this case. But that tendency, we don't know. Ms. Clearman also says she was looking at Theo in her rearview mirror. She also says she doesn't recall her husband opening a door after being punched by Mr. Edgecomb. Now, again, when you have a traumatic situation, I'm sure this, when Mr. Edgecomb came up, and I'm sure the state is going to come up, he came up, he violently punched him in the face, blah, blah, blah. We know that. But we have to now assess her recollection now and the credibility, because you members of the jury have to determine the veracity and the weight that you're going to credit her testimony. So what she testified to is that she doesn't recall the door opening when Mr. Clearman looking to exit, likely to proceed after Mr. Edgecomb at that point. Now, generally, when you open the door, especially at night, your lights are on, right? Her lights were on because you're going to see later that those same headlights were going toward Mr. Edgecomb. But when the lights were on, you know, when you open the door, some cars, you know, the interior light comes on. That would further be an indication that that door was open. Sometimes you might hear some type of noise when a door opens, a chime, if you will. So she doesn't recall that. And again, I'm sure it was a traumatic situation, but again, we have to determine how much weight. Some credit should be given to her testimony, absolutely. But how much do we give it? And that's where we go back to the board. This is how the state is improving their case. Guilt beyond a reasonable doubt? No. So let's go to the next slide. She said her husband told her to turn the corner because he wanted to talk to Mr. Edgecomb. But the video shows that she likely made an illegal turn from the middle lane to make that right turn. She also admits that Mr. Edgecomb was no longer a threat when he got back on the bike to leave.
Don't play traffic cop, that's not going to help.
That's important. I don't know if you recall when we stopped the video, and you probably were wondering, like, what are they doing, and why is this point being driven so hard? Because we wanted to make sure that she agreed that Mr. Edgecomb was not a threat to her at the time he punched and got back on his bike. And that's why we asked questions. He said, so he's in front of you, right? Yes. You see the back of him, correct? Yes. And at this point, he's not a threat to you. She said, yes. That's important for a couple reasons. Number one, it shows that Mr. Edgecomb retreated, or the word that you're going to see in the jury instructions, he withdrew. That's the word that the state is not going to want you to pay much attention to. They want you to gloss over that fact. Withdrawal. That's what it is. He got on the back, he got on his bike, he proceeded forward, he turned the corner. That's notice that's imputed to the Clearmans at that point. No doubt about it. The next point is she also admitted that she could have kept driving straight to go home. I don't know if you guys, members of the jury, I don't know if you recall, I don't see it here now, but we had a board that we referenced at a couple times in the trial. And in that board, we look, you turn right here, what's these locations here? And we asked, okay, so which way is home? And she testified that, yeah, this is the board. Thank you. So you remember the board, but we asked which way is home. And here's Brady Street. Here's the intersection where the X is. One of the witnesses during the course of this trial placed the X at that intersection. That's important. And she testified that home was straight. That would be the direction to go home. So Mr. Edgecomb had already made his right turn already. He already made his right turn. That's not a dispute. You've seen it in video. She decided to go take a right turn after Mr. Edgecomb, likely under direction of Mr. Clearman. So when the state comes up and they talk about, he's a cold-blooded killer. He's a cold-blooded. He's violent. He's all of this. Mr. Edgecomb, at this point now, he punched somebody. And the question you have to ask, did he have a firearm at the time he punched the first time? Did Mr. Edgecomb have a firearm on his person the first time he decided to punch Mr. Clearman. Of course he did. Of course he did. If Mr. Edgecomb was a cold-blooded killer, so why not take the gun out at that point and shoot at that time? Why? Why not? He was upset. And again, we said at the beginning and opening, there's no justification for punching anybody. Mr. Edgecomb should have called the police, let the authorities handle the situation. He should have done that, just as the Clearmans should have done so as well. The state asked Mr. Edgecomb yesterday, they said, when you came down that stairwell, did you know it was a police department right there? Did you know it was a local police department right there? You know when they were grilling Mr. Edgecomb? When he was nervous? The same question applies to the Clearmans. Actually, the Clearmans would have gotten there faster because they had a vehicle to get there. They could have used the same vehicle they turned to go after Mr. Edgecomb to go to that same police station that Mr. Attorney Huebner came up and asked Mr. Edgecomb about. Could have went to the same police station, but they didn't. And that's, members of the jury, are why we're here today. They didn't. Nothing stopped the Clearmans from taking a... How did Mr. Edgecomb get apprehended? They did great work using video to track him down. Just like they are tracking him down for a murder case as we're here today, they could have tracked him down for a simple battery case. A misdemeanor for punching Mr. Clearman. They could have used the same technology to track him down for punching someone, but they didn't. That's key. Next slide.
Victim blaming is wrong, but
so,
you gotta do what you do.
Ms. Clearman also, confirmed that, she enabled her husband to pursue Mr. Edgecomb while he was on a bicycle. We just talked about that. She admitted that a gun was brandished by Mr. Edgecomb. She admitted, she shouted out, he has a gun, but says her husband did not hear her. Why is that important? If Mr. Edgecomb has a weapon brandished, that was his testimony, right? On direct, he talked about it. I had my weapon. He said it was around his waist area. He said, I brandished it. Well, can we, now I know, listen, we know certain parts of Mr. Edgecomb's testimony, you're probably like, okay, it's some part that, especially in cross, that, is questionable because he was feared. He was scared at that point. It wasn't me talking to him. It was somebody who's trying to convict him of murder. But when Mr. Edgecomb was asked, he said, yeah, I had the gun brandished. He said, I used my left hand and I said, stop, do not come any closer. That came out on direct. The gun was out already. The gun was used to deter conduct of Mr. Clearman. But it didn't work. Even his wife, who loves him dearly, yelled out, Jason, he has a gun. That didn't stop. He kept coming. And ladies and gentlemen, that's why we're here today. Next slide. Two points here. Ms. Clearman admitted that Mr. Clearman got so close to Mr. Edgecomb. This would be invading his personal space. She admitted that her husband advanced toward Mr. Edgecomb. So initially, she testified that she seen her husband walking toward Mr. Edgecomb, which is fair. She pulled off and she used her vehicle to catch up with Mr. Edgecomb. And then she turns on her flasher lights in the bike lane. You've seen the video. So maybe it's fair that she didn't see a part of the jog as the state has described it. We consider it to be running or hunting someone down. But the more friendly term is jog. But nonetheless, we don't have to talk about words because it's just wordplay. We seen that yesterday. We talked about the testimony of Mr. Edgecomb.
I will be right back, everybody.
Just words, different ways people describe things. Ms. Clearman described it as advancing toward Mr. Edgecomb. Nonetheless, the evidence now shows that it wasn't Mr. Edgecomb who was advancing toward Mr. Clearman. Ms. Clearman's testimony says it was her husband that advanced toward Mr. Edgecomb. That's why self-defense is at play. A cold-blooded killer doesn't run. How many cold-blooded killers run? Cold-blooded killers normally go after who they're trying to kill. That video shows Mr. Edgecomb running. Running, trying to save his life. That's her testimony. Next slide. Okay, we talked about that there was a warning first, then the gun she touches. So then immediately after the gunshot, she goes to the scene. So immediately after her husband is now on the ground, she gets out of her vehicle and she goes to the scene. Now, you've seen the video. And she gets out the vehicle within 6 seconds. And she goes over to the body, she reaches down, and I count it. It's 4 seconds. Count it. When you get in the jury room, go to the video. Now, the defense has actually enhanced the video to try to make it more clear. You're going to learn Mr. Edgecomb had to give $5,500 to have Mr. Mark Robinson fly in from New Jersey to testify about enhancing the video, because it's important that you see. This case is about seeing. It's not about just hearing different versions. Thankfully, we got A-class evidence in this case. Men lie, women lie, video does not. You got permission, members of the jury, to believe what you see. So what she kneels down for, we don't know. She testified that she placed her hand on her husband's back to see if he was alive, then she ran back to the car. Very possible. We don't know. And neither does the state. We don't know. But that was her testimony a year and a half later. You know who didn't ask that question? The Milwaukee Police Department when they were investigating this case. She was never asked. Why did you go out the first, why did you go the first time? There's no record of that. Now, we later learn, and we'll get into that later, that she goes a second time. Again, she retrieves, they don't say. She makes a 911 call, and she testified that she wasn't able to remember her PIN code initially. Very possible. Again, it's a traumatic situation. That's very possible. Your mind, I can understand your mind not working the same, but so that being the case. However, at the time that Ms. Trotter comes on, she testified. She came right to this stand and she said that between the time that she got back in the vehicle and you see the red SUV come around, Ms. Trotter testified that she was on the phone with somebody. That's the testimony in this case. These are the confines of evidence that you have to consider. We don't know. I wasn't there. I don't know. Either does the state, and that's why we have reasonable doubt, because they can't prove guilt beyond it. You also heard in testimony that she said she wasn't in the car with Denise's boyfriend, who was an off-duty police officer. Then later she says that after seeing the video, she's like, oh yeah, I do remember him. The police officer, the off-duty police officer who came, Ivana's, boyfriend or husband. She's like, after seeing the video, oh yeah. She recalls that. Again, sometimes after traumatic situations, your memory can fade. That's possible. Our point, members of the jury, is that just the testimony is not reliable. That's all. That's it. No blaming anybody. That's reasonable to not recall certain things. Only thing is, the state has to prove it beyond a reasonable doubt. Next slide, please. So, she admitted that she did go to Mr. Clearman. Now, this is all before the authorities arrived. This is all before.
Sorry, guys, I'm back. Amazon's
Milwaukee Fire Department, Milwaukee Police Department, anybody gets there. It's just civilians at this point. She testified and admitted that she went back and forth to Mr. Clearman while he was laying on the ground, not once, but twice. Then she admitted to removing a wallet from Mr. Clearman, and here's the issue. We don't know when that wallet was removed. We don't know when the wallet was removed. She admitted of taking the wallet. We understand you want a piece of, okay. She said she wasn't interested in the contents of that wallet. Fair game. When was the wallet taken? We don't know. The defense does not know. Guess who else doesn't know? The state. Did the officers or the detectives ever ask Ms. Clearman when she said, hey, I have his wallet, right? And then, remember, Officer During goes to Detective Kirkvold, and he said, I'm Detective Kirkvold, Tyler Kirkvold. And Officer During says, hey, I have her wallet. And he says, did that come up out of him? Go into it's in the blood, the body-worn camera of Officer During. It's that video. And he says, did that come up out of Mr. Clearman? He said, I think so. He said, that's a problem. Testified to that on the stand. That's a problem. The other detective next to him said, incredible. So what happens next? At that point, Detective Kirkvold orders Officer During, go find out where that wallet came from. Who got it? So you see on that video, Officer During says, okay. And now he goes and he asks Officer Mahelik, and he says, do you know where this came from? He said, no, I don't know. He said, I think the wife got it. He says, I don't know, or maybe MFD, Milwaukee Fire Department. Maybe they got it. So Officer During is shown on that video going to the Milwaukee Fire Department, individuals that are on the scene, and he says, did you guys get this wallet? And they say, no, we didn't get it. No, we didn't get it. No, we didn't get it. Why is this important? Because that goes and it imputes notice to law enforcement. Notice is now imputed to the Milwaukee Police Department. And now that they know an item has been taken from Mr. Clearman, it has been removed from the crime scene, at the very least, members of the jury, wouldn't you expect them to go ask Ms. Clearman, well, why did you take the wallet? Why? Isn't Mr. Edgecomb entitled to at least understand why an item was removed from a crime scene in which the state is prosecuting him for murder? They don't even ask the simple question. And you heard testimony from retired Officer Browns who said that would have been standard protocol to ask someone why something was removed from the scene. And that, members of the jury, is yet another reason why we go back to our board here, burden of proof, because they can't prove guilt beyond a reasonable doubt. Too many questions unanswered. Too many questions never asked. Next slide. we have Miss Stephanie Trotter. She admitted, and she said that it was weird that Mrs. Clearman was going inside of Mr. Clearman's right pocket. And we just talked about, she admitted that when she pulled up, when the two vehicles on a red SUV, when they pulled side to side, you know, in that 1 minute and 34-second video, she admitted that she was on the phone and she was saying, Anna, Anna. So she was indicating that she was on the phone with someone. Now, let's go back to the first point. Ms. Trotter testified. We know she was there. We seen her on video before the video cut off. We know she was there. This woman was there. We know that. She called 911 while Ms. Clearman was by Mr. Clearman while he lay there. Ms. Trotter was very specific when she told you one thing, members of the jury. She indicated that Ms. Clearman was doing something with the right pocket of Mr. Clearman. The right pocket. The right front pocket. That was her testimony. The right front pocket. That was her testimony. I didn't make this up. She came on this stand and she raised her right hand like everybody else did in this case. Members of the jury, what was found in that right pocket? The folding knife was found in that right pocket. Let's discuss this issue. Let's just get it out the way right now. Are we saying that she put it in there, this and that? No, we don't know. We're saying we don't know. We don't know what she did with the right front pocket. I don't know if the wallet and the knife was in the same right front pocket. We don't know. They never even asked, when did you get the wallet? The question was never asked. That's why we have reasonable doubt here. If all the questions were asked, if we had the whole video, maybe we would have more information so that maybe the state could get up this ladder to guilt beyond a reasonable doubt. It's not there. Now, the state just said something in their opening. They said, well, Mr. Edgecomb is saying he's seen something in his hand. That's his perception. He believed he's seen something. Now, what you didn't see is Mr. Edgecomb come up on this stand and try to exaggerate a situation. He didn't try to say, oh yeah, it would be quite convenient for him to just come on the stand and say, oh yeah, I see the knife. Mr. Edgecomb didn't do that. He just said, I seen something. It happened so quickly because he had a big right step and then he lunged at me. So he couldn't really determine what was in his hand. That was his testimony. He also indicated that there was a second threat that he perceived, which was the vehicle. The same vehicle that hit him the first time, that knocked him on top of another vehicle, and where a racial slur was yelled out at him. The same vehicle that you saw, members of the jury, almost hit him a second time in the bike lane. Same vehicle. So at the time, Mr. Edgecomb's perception is these two threats. So he's not going to exaggerate something just to make the story sound even grander. He has every reason to, because he's facing a very serious charge, but he took the same oath that every witness did. And he was advised, you don't exaggerate anything. You only tell the truth. So if you only believe that you've seen something, then that's simply what it is. We don't need to exaggerate anything. They still can't prove guilt beyond a reasonable doubt. Next slide. Now, that kind of brings me to, testimony that was provided by Miss Clearman when she said that they were out drinking. And I always messed his name up, so you guys got to forgive me. It's Scaffides or Scaffides, it's one of the two. But they were, wherever they were at that evening, she indicated that she had one glass of wine And she indicated initially that Mr. Clearman had 3 beers. That's what she testified to. Once I brought out, like, well, you know, based off of his size, in a way, he's not a small guy. He's 6'3", 250 pounds. Not a small guy by any imagination. So when we presented the question to her, and we said, well, you know, it showed on his toxicology a blood alcohol level of 0.12. And we question now, 3 beers? Now this is Wisconsin. We know, if we know anything about anything, we know about beer. And 3 beers, a 0.12? So then she testified and said, oh, well, okay, maybe it was 4 beers. Okay, maybe it was 4 beers. I don't know. The defense doesn't know. You know who else doesn't know? The state. But their witness testified that based off of that blood alcohol level, a guy with that weight, he agreed that 8 beers was more consistent with the blood alcohol level of Mr. Clearman. And that was at 240 pounds. The autopsy indicated that Mr. Clearman was 250 pounds.
Counsel, I lost track exactly, but you probably have about 10, 15 minutes.
Thank you, Your Honor. Next slide. So then we go to Lorenzo Hernandez. The assignment was to canvass 4 blocks between Houghton and Humboldt. He observed many video cameras going east on Brady Street, including 2 at Gloriosio's. They were all marked on the maps. This is diagonal to Dynamite. Evangelina said during her testimony, this is where the first incident occurred. He stated in testimony, he never was given a follow-up task as the investigation was turned over to the detective. Again, a lack of follow-up. Next slide. Dr. John Black, you know, what John Black essentially, you know, told us, he talked about selfies, and he talked about when you take a picture with a selfie and how, you know, when you focus on the one object, it's only after you actually get the picture, and then you notice some of the other things that might not have been in your perception at that very moment. You know, that's the same thing in this case. You know, so when you're looking at the video evidence, understand that everything might not have been within Mr. Edgecomb's, you know, perception at that moment. It was a heightened situation. It was, you know, obviously it was an intense situation. So again, that's something for us to consider. Next slide. All right, next slide. Go to the next one. All right, so that brings me to the next point. Mr. Edgecomb testified that he had 17 bullets, fully loaded. How many bullets were actually fired? 1. A cold-blooded killer that only takes 1 shot. He never shoots at the vehicle that struck him one time and almost struck him another. He never shoots when he could have punched, when he punched Mr. Clement. He doesn't shoot then. What kind of cold-blooded killer is that? Mr. Edgecomb testified that is after, you will see the step. You know, the state said, oh, he was just standing there and, oh, Mr. Edgecomb just pulled out the gun and shot him. No. Let's go to the video. Let's scratch. Let's go straight to the fence. Was it 15?
$780 people watching this. You guys are crazy. Guys, let's chill out. We may make mistakes on the evidence here. It's not a big deal. Yeah, Perch, don't get carried away. I'm just a regular dude who happens to be an attorney.
Mr. Members of the jury, this is the last time the defense will show you this video before you have it on your own to deliberate. There's no doubt, members of the jury, at this very moment, see, we use that word, withdraw. Don't forget that word. Withdrawal cancels out the first incident. It makes it first incident. Who cares what happened in the first incident at this point? It doesn't matter. It also doesn't matter, the second incident doesn't matter either, because of the word withdraw. This video at this frame shows withdrawal. Could we play, counsel? Stop it right there. Mr. Edgecomb testified to the screeching tires that he heard. He testified to the heat from the motor that he felt on his back. He testified to just the loud noise and shouting coming from this vehicle. He's testified he was fearful at this very moment. Mr. Edgecomb didn't chase after them in the vehicle after he punched them, which he already admitted. He's not charged with simple battery. When you get that verdict form, battery is not going to be on there. If it was, Mr. Edgecomb would have took responsibility for that. He admitted. Continue playing. At this point, stop. Back it up, please. And stop. Right there. That's the key frame of this case. You see that right step? That was the right step that Mr. Edgecomb described. He turned the corner, he made the right step, and he's lunging toward him. And when you heard the evidence, that's when the gunshot goes off after he lunged after me, Mr. Edgecombe's trying to describe the time that he believes makes his actions reasonable. The time of when the shot goes off. That's important. Not that, there was some accident, it malfunctioned. No. This was the time that the shot goes off. This is what makes his actions reasonable. This is why this jury should find Mr. Edgecomb not guilty because of self-defense in this case. Same plan. All right, let's stop that video, close it out. Now, Mr. Edgecomb has testified that he goes down these stairs, he goes home, you don't see him for 6 months. Now the state is going to argue, that's consciousness of guilt. Remember in voir dire, Attorney Ahmad, he came up to the podium and he asked a question to you. He said, how many of you believe that only guilty people run? Remember that question? Only guilty people run. None of you raised your hands. And then the next question that Mr. Attorney Ahmad raised, what other reasons might there be that someone would run? In that jury room, there were several different people. They said, somebody could be scared. Somebody could be fearful of their life. Somebody could, especially as an African-American man, we still have issues in this country. I mean, listen, we talked about the cases. He talked about he believed he was hunted down like Ahmaud Arbery. He talked about the George Floyd and being taken into custody in an unfortunate situation happens like Sandra Bland. He talked about that in his testimony. We still have work to do. Now, the state, he also testified that he set up a GoFundMe account, that there was a GoFundMe account set up, and that he was trying to get a lawyer. Then he said, couldn't you just call one of your lawyers? Just because you have a lawyer on one matter, this is common sense. Use your common sense. Just because you have a lawyer on one matter does not impute an obligation for them to accept you on another matter. That's just common sense. He called lawyers. They told him $50,000 to $140,000. That was the testimony in this case. So just having a lawyer available doesn't mean you have the resources to get one. He was scared. He talked about that fear. So the consciousness of guilt stuff, that's a distraction. That's simply a distraction. If he's not charged with, just running. He's charged in this case with murder. If you want to charge him with battery, go ahead. You want to charge him with obstruction or whatever you feel like the appropriate charge is for not being available or turning yourself in for 6 months, do so. It's not murder. You got video evidence to make that decision on. Thank God for video. Look where Mr. Edgecomb is when there is video. He's still sitting here. That's why he's so nervous on this stand. He thought that the video itself should be enough. You see it with officers all the time. I thought it was a gun. It turned out to be a cell phone. But we understand, it was reasonable fear.
Brilliant.
He looked like he was
Brilliant.
reaching for something. It's the same law. It's reasonable. It's still the perception that Mr. Edgecomb had. Now, I'm going to wrap this up.
Slip that in there with the cops.
Frederick Douglass once said, in a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny. And here we are, members of the jury, still embarked on that destiny. Mr. Edgecomb has accepted responsibility for his actions. We told you, he wasn't supposed to have a gun. He pled guilty to bail jumping. He took responsibility so that you guys wouldn't have to start your year off having to decide something that he needs to take responsibility for. He punched the guy. If he got charged with that, you're right. He should be charged with simple battery. He fled for 6 months. He provided his explanation for it. It wasn't because of what you've seen in that video. Any reasonable person would be fearful under those circumstances. Those are all true. But ladies and gentlemen of the jury, those are not charges that Mr. Edgecomb is facing. The charges that's going to be on the form that you're given is going to be murder. And a whole different multitude of degrees of murder. You got to go through that. That's what's on your verdict form. And that's why you need to find him not guilty, because they have not proven this case. Mr. Edgecomb is no murderer. He's a very soft-spoken, scared individual. Members of the jury, I want you to look at Mr. Edgecomb.
Look at him. Look at him.
Objection, Your Honor.
Well, let's wrap this up. We're at about an hour and a half. The jury's had plenty of time to look at the defendant. Let's just finish with a couple sentences or whatever, counsel, and let's be done, okay? Please.
Yes, Your Honor. Mr. Edgecomb is no murderer. What he is, he's a survivor. He's a man who has already taken responsibility for any wrongs related to this incident. But today you decide, is he an imperfect person? The answer is yes, he's imperfect. But is he a violent, heartless, cold-blooded murderer? Absolutely not. Members of the jury, as the great Willie Geary often said, you have the power. You have the power, members of the jury. You can see wrong, and you can make it right. You can see suffering, and you can stop it. Members of the jury, Attorney Huebner is going to come again, another great attorney. He's going to talk about the rest of his arguments. Use your common sense. You didn't check it in when you came in this building. Use your common sense. And if upon doing so and applying the law to the facts, there will be only one just verdict in this case on all counts that have been on that verdict form. And that verdict, members of the jury, is not guilty. Thank you.
Thank you, counsel. You can just move that exhibit, please, and the stake and do rebuttal.
gentlemen, defense counsel stated that the state has not met its burden of proof. And then they didn't mention a single element. Not one of the legal requirements you have to take a look at here. Not one of them. We showed and proved that the defendant caused the death of the victim. We showed he did so with intent to kill. And defense counsel stated, oh, well, he's not a cold-blooded killer because why didn't he shoot 17 times? That's not the law. The law is whether or not he shot with intent to kill or practically certain to cause death. He took a gun that he's trained on, that he knows what will happen. He points it at the head of another individual, ladies and gentlemen, and he pulls the trigger and he puts a bullet in the victim's head. He says he's not a killer. He killed someone. That's what this is about. Ladies and gentlemen, Roger Cameron didn't say he was a cold-blooded killer. What he said was what the defendant did was cold-blooded. He didn't mention any time, during any time, about the defendant looking shocked or in looking scared or any of that. Not when he's talking to the police. Ladies and gentlemen, when he was talking to the police in that 911 call, what was he doing? Begging the 911 caller to do. Get here. He's still here. He's still here. You can find him. He's got to go. He just shot him in the head. He was begging the police to find that man, the defendant. Rotrell Cameron wasn't saying, oh my God, that guy looked really scared. You better go try to find him and make sure he's okay. He's saying, find him. I'm a person that just saw a man's head get blown off in front of me, and I want the person who did so found and caught. And he couldn't because he ran. And then he ditched the weapon. And ladies and gentlemen, we talked about a lot of things in voir dire. We talked a lot of things in voir dire. One thing we didn't talk, that defense counsel didn't mention, was that we also mentioned that your verdict has to be based on this case and this case alone. The defense, with the way they present their argument, is like a Chicago Bears fan talking about a quarterback. They'll talk about anything else. They'll talk about running backs or the 85 Bears defense, but they won't talk about what you're actually talking about because they don't have an argument. We bring up other cases. We bring up all sorts of other things. We bring up other things that have happened outside in some other place. Let's talk about here. Let's talk about what he did. Some injustice that you may feel that happened in some other case does not excuse or allow or invite an injustice in this case. What the defendant did was homicide. All of the elements have been proven. It was not self-defense. Ladies and gentlemen, even if, yes, withdrawal and he provokes, that doesn't mean he then is automatically in self-defense. A man comes up with no weapon in his hands, and ladies and gentlemen, be absolutely clear about that. This leaves just a few specks. The weapon, the knife, has no blood on it. No one says that knife is out. Not one single person says this is out. Defense counsel spent 35 minutes talking about a knife that's in a pocket that nobody sees come out. And says that is what makes it self-defense. Well, ladies and gentlemen, let's take a look at what defense counsel is saying. Your Honor, can you give me evidence control quick? Ladies and gentlemen, defense counsel is saying that the defendant was acting in self-defense because someone approached him. Someone engaged in his personal space. Someone had their fists up. Someone had a weapon that nobody sees. Ladies and gentlemen, at 1 minute and 26 seconds into this, all of those things apply to the defendant. He's got a firearm that nobody sees. He's engaged and invaded Jason Clearman's space. He pulls his hand back. He's engaged in violence. He has violence intent in his heart. He's going to punch him. And if Jason Clearman shot and killed the defendant right then and there, oh my God, would there be a different sort of circumstances and arguments coming from defendant. It'd be a different super team of lawyers. I'd still probably have to run all their equipment for them, but it'd be a whole different thing. But you know what wouldn't change? Your verdict. Your verdict wouldn't change. Because at this moment, ladies and gentlemen, it's not self-defense. Bringing the identities and characters of who people are in an attempt to influence your verdict just goes to show you don't have an argument. If Jason Clearman had shot and killed the defendant at that point, I would be here arguing the same thing, that he is guilty and the defendant is guilty. There was no weapon. There was no imminent threat of death or great bodily harm. He started a fist fight, and then he ended it with a bullet. And I am just glad that finally at the end of this, the defense is willing to admit that the victim's wife loved him. Because for 2 or 3 days we were hearing about purportedly loves, and why didn't she do CPR, and oh my God, how cold she is, and oh, why didn't she get the wallet? She told the officers right at the beginning, it's on the body cam. She was asked on the stand, she got the wallet. The knife never came out. The defendant shot and killed a man with his hands up, worst case scenario, in a situation in which Jeffrey Parr states he shoots an unarmed man, in which Jose Perez states he shoots an unarmed man, in which Rodro Cameron states he shoots an unarmed man, in which the video shows he states and it shows that he shot an unarmed man, in which Evangelina Clearman states that he shot an unarmed man. And keep in mind, defense counsel stated that she heard the defendant give a warning. No one hears that. Not one person. Not one person hears any of what the defense counsel is trying to say the defendant heard. Nobody hears it. Because it didn't happen. It just didn't happen. He started a fight, and then he killed the man. Every portion and escalation of violence came from the defendant. Words, I'm going to punch you. You want to punch me? I'm going to shoot you. And ladies and gentlemen, when you go through all of the elements like I went through with you and the defense avoided, you find that he's guilty. Negligence out. But I do think you should at least keep in mind one thing. Defense counsel spent about a half an hour trying to explain away his own client's words. The defendant could not have been more clear. He says the gun is pointed down. He states that the victim is lunging at his gun, by the way, or about to spear him, and the gun goes off. That's his words. Not, I shot in self-defense. Not, I was trying to keep him away. I stepped back and the gun goes off. That is what he said. And defense counsel spent half an hour trying to make it seem that it's not what his client said. That is what his clients said. Because when that last-ditch effort by the defendant doesn't work, now the defense counsel's got to try Plan Z. Running didn't work. Ditching the gun didn't work. Lying to Kentucky didn't work. Lying to MPD didn't work. Lying to you didn't work. And now
I'd object to that.
Another plan. This case is what happened right then and there. And on that video, there was not.
Actually, never mind. I got carried away.
Rodro Cameron says he has his hands up. Other people didn't see it. But regardless of it, the worst case scenario is a person who got punched was getting ready to punch back. And the defendant shot him. That is first-degree intentional. If you think he actually believed that there was a threat of death or great bodily harm, because that's what he has to believe, then it's second-degree intentional, because there's no way that's reasonable. If you think that maybe shooting only once somehow is not intent to kill, even though he's a trained weapons guy who's got a gun and at close range puts one into someone's brain, then it's first-degree reckless. If there's utter disregard for human life, if there's not, it's second-degree reckless homicide. Everything defense counsel just went through in terms of their arguments does not get you to not guilty. It's just a matter of which one of the homicides he's guilty of. Because there was not a valid self-defense claim here. Ladies and gentlemen, when you go through it, and you go through everything, regardless of whether or not they went and found something at Glorioso's, and keep in mind, defense counsel made a big deal of all this video, only to find out, and not mention at all in their closing for some reason, that the defendant says it's even further eastbound than that. Who cares about the swerve on video? It wouldn't have changed what happened when the defendant pulls a gun and shoots the victim. And their whole point for why that matters is Ricky Burns. Keep in mind, you are taking and hearing someone criticize an investigation in which they are doing everything they can, and he and they cherry-pick the evidence, cherry-pick the result, and Ricky Burns never asked for anything more. There were reports he didn't see and didn't even care to see. Why? Because they didn't want him to see them, because it didn't help what they wanted him to say. Talk about showing everything. They didn't. We called all the witnesses. You've heard all of the case. This is about this case and nothing more. And the simple fact that anybody tries to draw your attention to something else goes to show that they know they can't win when it comes to the elements and the facts in this case. He's guilty, ladies and gentlemen. The facts are clear. The law is clear. He's guilty. Your verdict is clear.
Thank you. Ladies and gentlemen, I'm going to read you a couple of additional instructions.
All right, that's
Duties
it for
of the
arguments.
attorneys in the court have been performed. The case has been argued by the lawyers, and I have instructed you regarding the rules of law which should and must govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision in this case is to be thrown upon you, the jury, the jurors selected for this duty. You are not to be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate. Please be careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to render a just and true verdict. You will have the jury instructions when you go back immediately. You will also have verdict forms submitted to you. There will be eventually 5 verdict forms. The first one will read, "We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree intentional homicide." If that's your decision, you then answer the second question, did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Yes or no. The second potential verdict form that will be submitted is, "We, the jury, find the defendant, Theodore Edgecomb, guilty of second-degree intentional homicide in violation of the Wisconsin Criminal Code." Again,
I'm
there
gonna
will be
stick
the
around for a
second
bit,
question
but,
if
I mean,
you find him guilty on
I
that
plan on
charge.
coming back live.
Did the defendant commit the crime of second-degree intentional homicide while using a dangerous weapon? Again, yes or no. The third verdict form, "We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree reckless homicide in violation of the Criminal Code of Wisconsin." Again, if that's your verdict, you will have to answer the second question, did the defendant commit the crime of first-degree reckless homicide while using a dangerous weapon? Yes or no. The next verdict form will be, "We, the jury," or reads, "We, the jury, find the defendant, Theodore Edgecomb, guilty of second-degree reckless homicide in violation of the Wisconsin Criminal Code." Again, if that's your verdict, you answer the next question. Did the defendant commit the crime of second-degree intentional homicide while using a dangerous weapon? Yes or no. And then finally, the last verdict form would read, "We, the jury, find the defendant, Theodore Edgecomb, guilty of homicide by negligent handling of a firearm in violation of the Wisconsin Criminal Code." And the last verdict that's submitted, the sixth potential verdict, so you'll have six forms, reads, "We, the jury, find the defendant, Theodore Edgecomb, not guilty. It is for you, the jury, to determine whether the defendant is guilty or not guilty of each of the charged or any of the charged offenses. You must make a finding as to each count or the count of the information. Each of these counts that I just mentioned is a separate crime, and you must consider each one separately." Ladies and gentlemen, as you know, this is a criminal, not a civil case. That means before you, the jury, can return a verdict which I can legally receive, the verdict must be reached unanimously. In a criminal case, all 12 of you must agree in order to arrive at and reach a verdict. When you retire to the jury room, I would ask that one of the first things you do is select one of your members to preside over your deliberations as the foreperson. That person's vote as the foreperson, however, is entitled to no greater weight than the vote of any other juror. If during deliberations you need to communicate with the court, that means communicate with me, you need to send out a note through the bailiff that's signed by the foreperson. To keep a complete record of this trial,
Come on, Judge,
it's
let's get
important
through this. Let's
that
go,
you
let's go,
communicate
let's go.
with me as the court only by writing or only with a written note. If you have a question, I, as the court, will discuss the matter with the attorneys before I answer it, so it may take some time. You should and must continue your deliberations while you wait for an answer. If there's a question, I will answer the questions or any question in writing, or I might bring you here to answer it here in open court. Most likely I'll answer it in writing. After you've agreed upon and reached your verdict, you should have it signed and dated by the foreperson that you've selected to preside over your deliberations. Madam Clerk, if you can swear in the bailiffs, please.
All jurors sworn at this trial together in some private place, and then you will not, before they render their verdict, communicate the state of their deliberations.
I'll tell you what I think in a second.
They have agreed upon stuff.
All right, ladies and gentlemen, if you can follow my bailiffs out, you'll have the jury instructions immediately. You'll have the verdict forms in just a minute or two. All right, the jury's been excused to deliberate. I'll make a record. Earlier today, let me step back. A few days ago, there was a juror that was excused because she had a family emergency. I think there was a death in the family. Both sides stipulated to her being an alternate. That was, I think, last Friday. Is that correct, gentlemen?
Yes, Judge.
And today, the juror that was not feeling well, that was lightheaded, the lawyers, both sides, also stipulated to her being an alternate today, correct?
Yes, correct.
I think I should also make a record, and both sides can chime in. The jury that was seated in this case is one of, if not the most diverse that I've ever seated in Milwaukee County. The jury that's deliberating has 6 people that are white or Caucasian and 6 people that are minorities or people of color, including at least 4, possibly 5 African Americans. It's a very, very diverse jury. It's obvious to the lawyers.
Wow.
Both sides agree with that for the record.
That's a very interesting jury pool makeup.
Is that a yes, Mr. Hibner?
Yes.
The defense agrees with that statement?
Yes, Your Honor.
All right, we're in recess. Give my clerk, please, a phone number that you can be reached. As is my normal practice, I don't send back exhibits unless they're requested. I have sent back, or will send back, the jury instructions and the verdict forms. If they ask for an exhibit or anything along those lines, I'll advise the lawyers. We'll come back. We'll discuss any exhibits that are requested. It's about 1:45. We're in recess. Off the record. Thank you.
All right, so it's done. The jury's got it. What do I think? I think he's guilty, and they'll convict him of the second-degree intentional homicide. There's too much there. I don't think they'll give him reckless. So, girl who lived, it depends on where you live, but I mean, typically, minorities are not, and I'm not saying this to be racist, I'm saying in my experience, even if you try a case in a very built-up area with a high minority population, they generally don't show up for jury duty. So no, it's not very common that you have a jury that's half and half. Juries are predominantly white. That's just the nature of it. Now, to everybody who was wondering if I'm going to do other trials, I kind of just did this as an experiment to see what would happen. Seems like you guys like it, so I will try to do other ones coming up. I didn't plan ahead, so I don't really know other trials that may be worth looking at coming up. The Waffle House killer, the guy down in Nashville who shot up a Waffle House, I was curious, but I don't think that one's streaming. I can't find it anywhere. Also, apparently it's running right now, so I don't want to cover two at once. Yes, I will be back on for the verdict, and if they come back while we're talking, and I have no problem sticking around this afternoon for a bit. If you guys have questions about things, we can talk about it. Yes, Puck. Every juror has to make a decision. All 12 of them have to agree. Guilty or not guilty. Robert, he didn't kill a Waffle House. He killed the people inside the Waffle House. Well, he potentially faces, if convicted of intentional first-degree homicide, I believe he can get life without parole. So, and then from there it goes on down, and I think for negligent homicide he can get a good number of years, but not too bad overall, considering the alternatives. Sue, I do plan on trying to set up all that, but like I said, I just really got the channel started. I need to work on setting all those things up. Thank you very much for your comments, guys. I do appreciate it. It means a lot. Cover the lady that left her kids in the basement. Are you talking about where, like, the one kid died in front of the other one's paper finger? Do you know the name? Thomas, if you can't do trials of young children involved, I mean, try doing a sex offense trial involving little kids. That's rough. 9 canines, I don't think, well, they're going to have to eat lunch. So, I think maybe an hour and a half at most. Oh, GPS, I don't have court today, so nothing to worry about today. I can stick around forever. Oh yeah, they can deliberate and eat. That happens. Sometimes they just focus on eating. I mean, they could be sitting back there drinking coffee. Back when you could smoke, they could sit there and smoke while they're talking. I mean, there is no rule like no food allowed when it comes to deliberation time. Snake breeder case out of Missouri. I haven't heard about it. I'll take a look at it. I have to write some of these down. Also, guys, if I don't, there might be times where I don't do things live. You know, maybe I'll do a periodic live stream. I don't know. Sounds like you guys might like that. I do want to make like subject videos that might be like 10 minutes or less, but just I'll post those that won't be live necessarily. Kim, will they sequester a jury? No, not these guys. Sequestering is a very serious step. And I mean, when you think of sequestration for a jury, think of like OJ. I mean, it's got to be a big, big case. I mean, this is on TV, but there are probably 20 to 30 other murder trials right now going on across the country that are just like this one. This isn't really that big a deal. Okay, Rich, it just depends on my schedule. If I know it's far enough out and for example, as long as I don't have a trial scheduled, yeah, I can clear out schedules. I can get things continued and moved around to be available for trials. I just need a little bit of preparation. Or, some days I do have spots in like a week where I have maybe 2 or 3 days at a time ready to go. We might be able to squeeze a trial in then. It really all depends. And typically a murder trial, this should have been like a 3-day murder trial. I don't know why it took this long. It was a bit unnecessary in my opinion. Lauren Courtney case, okay. Sue, I'm not going to be able to cover the 3 cops for Chauvin because that's going to be in federal court, and I don't want to sit there and read what somebody else reported on and give that to you guys. I don't think that's very helpful. Okay, Rich, it all depends on if I have time. If I know I'm going to have that time coming up, I will put as much work in. I will work as far ahead as I can to make sure it's available. I mean, this is kind of me just messing around. It's a little bit of kind of liking it so far. So it's like a little bit of a hobby. So I'm working it in around what I do normally. If I can't do a lot of trial streaming, I'll just be doing a lot of video topics. Especially after this case, I've got a bunch of them to cover. I think the Kim Potter verdict wasn't correct. I think that they gave the jury basically the law and made the jury pick which law applied. And I think that should have been set with the jury instructions. So I think it's going to have to go back. But I think ultimately you end up with her going back to prison regardless. Yeah, the Bumble date case, that's brand new. The Crumbleys, yep, that's what I'm looking forward to. My leg hurts. My name's Sean Martin. I'm an attorney. This is my channel. I was just commenting on the case. Mongo, how much preparation do I need for each hour in court? It all depends. If it's a pretrial where I'm still waiting like on discovery, or there's nothing new, or the case is getting continued, it doesn't take much time at all. If it's a sentencing, for example, I've already done all the work to get to that point. Not that much time. If there's a plea, I've probably already done a lot of work to get to that point of the plea. So it really depends on what type of hearings they are. But I mean, it's not like I have to spend 2 hours for every hour in court. I mean, it's not like that at all. And a lot of times, the amount of time you spend in court is a fraction of what you spent preparing for something. I have no idea how long Edgecomb will get. I don't know Wisconsin sentencings that well. Zacocracy. Yeah, people, I kind of look at it this way. We all fuck up on our jobs. If you're flying the space shuttle, you're going to fuck it up at some point. It's just the margin of oopsie poopsie on the space shuttle is 0. If you screw up there, somebody's going to die. When you're a police officer, the margin of error for having an oopsie poopsie is going to be very bad. But that to say that they can't or shouldn't ever, okay, that's unrealistic. People will screw up, and there should be as much mitigation as possible. But to sit here and claim there should be none whatsoever, I think is a bit much. Adam, unless you're in Ohio and looking to actually retain me, I'm not going to talk about my rate. Time traveling painter, I'm an attorney out of Ohio. Guys, if you've asked a question and I didn't see it, I'm sorry. Yeah, ask a question. I'm totally fine with answering them. Do I think Kim Potter was negligent? Yeah. But was it criminal? And that's where I think it gets hard. That's not an easy one. Kimberly, can I explain the discovery period? Yeah, so the way discovery works is you send to the state a demand. You demand any and all relevant discovery that they may intend to use at trial that would show guilt or show an exculpatory nature of your client. And you ask for everything and you get it. Now, for a lot of cases, it's usually like a police report, maybe a couple of witness statements, or in a drug case, some drug testing results, and then sometimes video. And usually there's not a ton to them. In this case, there was probably banker boxes full of discovery, ultimately, if you printed it all out. But once you go through all of it, if you're the defense, then you have a burden to provide the state with the discovery you wish to use at trial. So that's why the defense, when they put on their case, the prosecutor knew about every single person who was going to testify and any exhibits they were going to talk about. Sarah Garwood asked, am I a private attorney? Yes, I'm a sole practitioner. I run my own law firm. It's Martin Law Office. I have a website, seanpmartinlaw.com. I should probably put that in the YouTube description. But yeah, I run my own practice. So yeah, I take private cases. And every once in a while, a court may call me and ask me to represent somebody as a court-appointed attorney. For example, if the public defender's office has a conflict and they can't do it, and I take those as well. Candace, yes, first-degree murder was charged. Funny lady, I don't know. Actually, can you guys still hear me? I think my mic may have pooped. Okay, just want to make sure. So, funny lady, you mentioned is discovery in America the same as depositions? In America, depositions are typically where you have a witness sit under oath and you question them. Both sides in a case will. Typically, those are done in civil cases. Sometimes they are done in criminal cases if a witness will be unavailable, or let's say a witness has got a terminal illness and they won't survive to a trial. They may do a deposition on those people. It's not as common, but it does happen sometimes in a criminal case. Lucas, no, they can't smoke in courthouses anymore. I was just talking about like back when they could smoke. You could smoke or drink coffee, or if they still have food while they're deliberating, they're allowed to do any of that. Well, Brenda, the flight can be used as circumstantial evidence of guilt, so it can be used in that regard, but it I'm not sure which part you're talking about. I'm trying to remember if you can provide more. Let's see what else is there. Hold on here. I'm trying to read up. Andrina, can they sneak in a drink? I wouldn't want to be caught trying to sneak alcohol into the courthouse. The judge probably would put you in jail for a day or two for that. Was the witness in shackles eventually released, and why was he in prison clothes? So he was a critical witness to the case, and the prosecution wanted him to show up. It sounded like they wanted to serve him with a subpoena, which is a court order to appear. And they wanted him to come pick it up. That way they could verify he actually received it. It sounds like he wasn't able to because he had a job and was busy. So the prosecutor was worried he wouldn't show up to court and testify. Well, without him, that could hurt their case. He's a material witness. What you can do, and a defense attorney could probably get this too, it'd be a little harder. I just think, especially at this court, is you get what's called a material witness warrant. That way you show the judge, hey, this person won't show up. Can you please make sure they're available? And the only way to make sure they're available is you throw their ass in jail and then drag them out in a jumpsuit and shackles, have them testify, and then cut them loose. That is very rare, so that's why I was even surprised. I've only seen it one time myself. It doesn't typically happen. Now, what I've seen happen, though, and I've had this happen myself, somebody doesn't show up for court in the morning, and one time as a prosecutor, it was the victim on a case. They weren't showing up. I think they had been tampered with. I asked the court to send the sheriffs out to go arrest that person and bring him back. And they knew where she was. They found her and they brought her back. And yeah, she had been threatened and kind of forced to stay at home, but the police showed up and drug her into court, and we went ahead with the trial. Aiden Higgins, I don't know what the next trial is going to be. I'm going to have to figure out my schedule and figure out what's available out there. Just check in with the channel. I'll try to keep it in my videos as well. see what else. Why was it a mistake for the defense to claim self-defense and have the defendant say it was an accident? Well, because you can't accidentally defend yourself. You have to intend to do it. Now, I understand, like, let's say somebody was coming up behind me and I was holding a stick and I threw it behind me and I knocked him out. Yeah, that's kind of an accident. But the idea is if you're attacking me, I can't accidentally punch you back. I have to intend to do it. So the idea of, oh, the gun just going off, well, guns just don't go off. You're pulling the trigger, which means you're intending to use it. And if you're intending to shoot somebody, you're generally intending to cause them harm and or kill them, so that means you're acting intentionally. That's why they were making that distinction. And that's why that's a problem, because if you claim self-defense the whole time, say, I was in fear of my life, but I had no intent to kill him, they don't work. You're trying to, you're trying to add 2 and 3 to make 4, and it does not work. Bonnie, do I think Edgecomb's lawyers did a poor job? Yes. I will give Ivory Lamar credit. That closing was very good for what they had to work with. If he was this good the whole way through, I would have a very much different opinion of him. But yes, I will give him, like a B+ on his closing. That was very well done. Sandy, I agree for Mrs. Clearman. She really tried to church up her husband, and I don't think that did her any favors. That helped Theodore a lot, I agree. Judging the defense's performance in this trial hurt them in the future for other trials. It could hurt them in the future. People might see these guys are unprepared, so if you know you're going against them, you'll understand that they're not capable. This could hurt them as far as if people are thinking to hire them, they might look at this trial and say, well, holy shit, these guys suck. And then if they ever need an attorney, they definitely won't hire those guys. So, this could impact them down the road. Couldn't they have him testify in close to be more dignified? The only person we're ever really generally worried about in a trial setting that isn't in shackles is the defendant. That's highly prejudicial. It's highly prejudicial to see him in prison clothes or jail clothes. So, for example, I had a trial set for January 3rd. My guy was in custody. I had to get him a pair of slacks, I had to get him a dress shirt, a tie. I had to get him dressed in regular they called street clothes or civilian attire, because the jury would be very prejudiced against him if he was in a jail uniform. Anybody else, though, it doesn't matter. I've had trials and cases where a witness is somebody who's already been sent to prison and they're brought back and they're wearing their prison uniform. So, no, it does not matter unless you're the defendant. Everybody else can show up in their jail's clothes. He should have filed a complaint for them on that. Anything could happen to him in jail. Yeah, K-Rich, he can file a complaint, but it's out. The fact they got their warrant granted and were allowed to incarcerate him before the trial, there must have been quite a bit of evidence there, so I don't think anything will happen to any complaint he were to file. Also, they probably would keep him in a protected custody situation and not put him in general population, because think about it. If he gets thrown in there and those guys are asking him, well, what are you in trouble for? And he says, nothing, I'm a witness. That would be very dangerous for him. So I bet he sat in an isolated area and was in a special cell. Yeah, Marcy, the optics were awful, but honestly, the prosecutor, he doesn't care. He's got to get his case in. So he might say, "Oh, you don't like it." He might say, "I don't give a shit." Is probably what he would tell you. Oh well. What else is going on with questions you guys have? Okay, Rich, that's correct. He's a witness, but it's they just need him to testify. So, I mean, you can be mad about it, but it's a practicality and reality situation. I will take your word on that. Okay, Rich. Puck, are all court-appointed attorneys worthy? Are all attorneys required to be court-appointed at some time? No, there is no requirement that you're a court-appointed attorney, and I don't think you should force people to do it. I'm not a big fan of forcing people to do a certain role for a certain amount of time. If you're court-appointed, for example, if a court calls me tomorrow and says, "Will you represent this guy?" Yeah, I will do it. But you don't get paid. I don't get to charge the public defender's office my full rate. It's actually for a lot less. Many counties, it's done county by county in Ohio. Some counties you can bill $75 an hour. Some counties you can bill about $45 an hour. Either one of those is not a ton of money, so it's not something you can live off of. But are they worthy attorneys? I'd like to think so. I mean, if I was appointed on a case, I will give that person the same effort as if they were paying me. A lot of attorneys do make no distinction. They work hard. Now, there's some that phone it in, sure, but they're still working. It's just, the range of acceptable is kind of like a spectrum. And, now, are public defenders good? I'd say most public defenders are very good. Most people who are public defenders are devoted and very idealistic that they want to help their clients and do what they can. So I think public defenders are good. Now, have they gotten bad raps over the years? Sure. But I think some of that's just bad stereotypes. Kimberly, there's nothing you can really do. A valid warrant was filed for him. There's not a whole lot of options there. What else is there? Okay, Rich, I'm talking about a court-appointed attorney. I'm limited in what I could charge by the county. So that's an issue of, a court-appointed case versus if you walk into my office and you pay me. Obviously, if you pay me and I'm privately retained, I charge a lot more than that. Ed, there's very few attorneys that actually charge $500 an hour. That's a lot of money for an attorney's hourly rate, especially for criminal defense. Gabby, no, I haven't. I'm serious. I kind of just did this for fun and started doing this. I thought it'd be neat to stream the trial. I haven't thought I was far ahead to set up a Discord or anything like that. Apparently you guys like it, so I might do that. Really, I was just kind of doing this because I thought it'd be fun. But yeah, I'll work on some of this other stuff like notifications, the community, Discord, whatever. I didn't want to do all of it and then nobody like it. That would have been a little depressing. K Rich, yeah, I bill in 10-minute increments as well. Actually, I'm sorry, I bill in 6-minute increments. I do the 10th of an hour. Yes, Chauvin did plead guilty to the federal cases. And yes, federal prison is a lot better than state prisons. If you have to go to prison, the Fed system's pretty good, from what I understand. A lot of people prefer doing federal time versus state time. Overall, it's fairly safer too. Have any of my trials ever been filmed or televised? Uh no, but I have had interactions with clients televised before. Um, we'll get it. That'll be a story for another day, but we'll get to that. Yeah, I'm just gonna leave that there for now. Does Chauvin pleading guilty hurt his co-defendants? No, I mean Chauvin was clearly the guy who did the most culpable of them all. You know, that doesn't hurt the other guys as much because they were doing less than him. If any of them were like one of them wasn't even on top of him, so the guy who did the most doesn't really hurt the guys doing less. I have a feeling they're toast anyway. I don't think they should be, but they are. I think I mentioned this before. Those other guys, if they had just been doing what they were doing, they wouldn't have killed him. So I don't see why they're culpable to the same level. Most attorneys are $150 an hour. Yeah, that depends on where you live. I know where I'm at, that's a little bit more than that, but you're kind of in the ballpark. Puck, as far as an hourly rate for defense cases, I generally charge a flat fee and I estimate how long I'm going to have to put in on it. That's, I think, a far more reasonable way of doing it because otherwise, if you pay me by the hour and I keep going and going and going and going, you're probably going to run out of money and then I'm going to be standing there waiting for the rest of it. Whereas if I charge you, that's why in these things where Theodore talked about, these attorneys wanted $50,000 on up. They're generally doing it as a flat fee. They know, okay, well, it's a murder case. I'm going to have to invest this much amount of time on it and do this much amount of work. So that's generally why I generally do flat fees. Sorry, I'm trying to figure out who just called me. Andrew, I think we're going to get a verdict today. I don't see why we wouldn't. There's no reason why we wouldn't have that happen. Yep, that's about right. So they'll tell you what their hourly rate is, but then they'll explain to you why they're asking for X amount up front. I wasn't disappointed in the prosecutor's closing argument. I thought he did very good. It's about how I would do it too. If you guys would give me 1 minute, I do need to take this call. Okay, sorry about that. So what's going on? Sorry guys, if you put a bunch of questions up above, I didn't see them, so. The girl has a vinegar tits attitude. Jesus. That's the first one I saw. Kimberly, I don't think it would matter if we had the first incident, because does that give you the right to self-defense? Maybe it shows a little bit of the story, but sorry, it doesn't. It doesn't change whether or not he had the right to shoot Jason Clearman in the face, because that's. Does it make it more likely or less likely he had that right? It is vital, but we don't know exactly where it happened, and I don't know if there's a camera for it. I honestly don't think it was. I think the cops actually did try to look for everything. Oh, Michael Collins, the barcode pictures. Those are actually from a website called From. The one over here is the Hunt for Red October compressed down, so it's just kind of like a big, like all those scenes squished down. Over here is actually my favorite movie of all time, Heat. It's got Robert De Niro and Al Pacino in it. It's a crime story. That's the same thing compressed down. I think it's kind of cool. Ed, I don't mind Rekida's thing. I actually like watching it from time to time. It's hard when you're sitting there with people who, you're kind of like colleagues. It's hard not, just think about if you're sitting around with your friends. It's, you're watching something. It's hard not to sit there and bullshit and talk about stuff. If you put me and my friends around together, we'd be making fun of stuff too, or me and other attorneys I know. I think you'd get a similar result. So no, it's just the way they present it. It is what it is. And also the black squares above those pictures, that's a bunch of sound foam. This room is a little echoey that I'm using as my office when I tried to do recordings prior to testing it out. So also on the other side of this camera, there is a ton of foam on the wall to absorb echo. Now, Kimberly, I think you're correct, and this is something, going back to what the defense pointed out. When you're on defense, think about it. Think about the prosecution's case as like a boat, like a ship. And your job as a defense attorney is to start poking holes in the hull. You have to poke enough holes in it that you sink the boat. Okay? Because reasonable doubt, either they have it or they don't. The boat floats or it doesn't float. Now, hopefully you can poke a bunch of holes. Either you poke a bunch of little holes and too much water gets in, or you can blow a big old hole in the side of it. In Theodore's case, it's about poking all the little holes, and are there a million little paper cuts they can inflict? There are some things they could do that I think were helpful, but is it enough to shoot down what the prosecutor's doing? I don't think so. Some random mom, none of the witnesses reported him using a slur, but remember, 2 of those witnesses were like 300 feet away, so who the hell knows what they heard? And then you're left with Evangelina, and she's not going to be straight. And then your other witness, Ratrell Cameron, well, he didn't necessarily hear it. He was driving by, so who really heard what? Michael, I've been an attorney since May of 2014. I I know I look really old. I'm only 36, so I took a couple of years to get through law school. Will life insurance pay out? Generally speaking, I think it will. I mean, granted, insurance companies stay in business and make money by denying claims. I don't think they're going to say there's like contributory negligence. He was murdered, so he was killed. His life insurance policy, unless it exclaims it or it exclaims an untimely death before a certain period, yeah, that should pay out. Oh yeah, and I plan on making cases about like covering things, recapping them if I'm not available to do them. So let's say there's a trial 2 weeks from now. Yeah, I plan on trying to do videos where I can, when I can, but also just about like topics, like really like what's the standard for ineffective assistance? Can the police lie? DUIs, like how does this work? How does that work? How does an appeal work? If you want to represent yourself, what do you have to do? What do you have to know? Just like a million different things that are out there. Yeah, Matthew, I appreciate that, but I've also had gray hair since I was 14, so kind of used to it. Don't worry.
From good things she bought extra, Rashida.
This one's a goner.
To always needs to end on a zero, Rashida.
Okay, you totally distracted me. That's not fair. What?
Earn cash back that automatically adjusts to where your spending is trending with the City Custom Cash Card.
Will actually cool us back down for Friday. A bit of a roller coaster ride as far as temps go in the coming days. Again, we're at 4 in Milwaukee and Chicago, 2 above in Minneapolis, but farther west, the Dakotas, you can see 20s, you can see 30s. So along that warm front, once again, we will be warming things up. Teens for high temperatures this afternoon, and then continually warming through the night tonight. We should wake up to 20s tomorrow morning. That'll feel very warm compared to this morning. Topping out around 30 by maybe midday, early afternoon tomorrow. Then that cold front will allow us
Matthew, I think you noticed or made a comment about the father-son dumpster shooting case. Yeah, if that gets televised, I want to cover that. That looks hilarious. I can't wait to see what'll happen there. I plan on doing a review of it coming up. Andrina, I think I might just leave it up for the verdict. I'm not sure. I mean, if it comes back too while we're here, obviously we'll cover it. If anybody finds out that the verdict's coming in, go ahead and spam it in the chat, because if I don't see it, I don't want to miss it. Huck Puck, do judges have open door policies where you can approach them about cases they're preparing? No. You can't do that. You are not allowed to speak to the judge about your case without the other party being present. That's called an ex parte communication. Those are highly frowned upon. Now, let's say I have a trial and it's over. I can go talk to the judge afterwards, and I do generally do this, and I'll say, hey, Judge Bob, how do you think that went? Do you have any recommendations for me? Do you have any input? What did you think of the case? Is there any questions you had? I'll do that to kind of get some feedback. And why do I listen to them? Because, they're watching it, they're impartial, they have a different view on it than a jury would, and that's about the only time you could talk to them is something after the fact. Or if I'm dealing with a judge in another county or another location who isn't handling the case, I might ask them, hey, do you have any thoughts on this trial I'm preparing? Other than that, you cannot talk to the judge you're directly dealing with on a case. Jim Curry, why do some lawyers try to get guilty clients found not guilty? I thought they only had to ensure their clients receive a fair trial. Jim, I guess I'll say it like this. Any attorney who... I guess I'm going to start swearing, and I apologize. This is probably going to turn into a rant, and you guys are going to think I'm a lunatic. When you do criminal defense work, you should be going hard in the fucking paint for your guy. And I'm not joking. Now, does that mean you cheat? No. You do everything within the rules of professional conduct, the rules of your state laws, and any other rules you have to abide by. But you go hard in the fucking paint for your guy. You go toe-to-toe for him. You will go all out for him. Okay, great, he's guilty. That doesn't mean anything. If the state can't prove it, that's their problem. That's not yours. By yours, I mean mine. It's not my problem the prosecutor can't prove his case. If he's got a shit case, that's his problem. Okay? I'm not going to sit there and just tick boxes and let the state get shitty and shoddy cases through that send somebody up. That's not how it should work. I believe in that concept of zealous representation. Now, there are attorneys who do go along with this idea of, oh, I'm just here to make sure they follow the rules. Great. That's not how I operate, and I never will operate like that. I'm talking about you got to fucking get it. I mean, like I said, if I was defending Theodore, I would use whatever I could within the bounds of the rules that I have to operate in to get him acquitted. If that means throwing the race card out, fine. If that means I have to sit there and berate his wife and treat her like a complete piece of shit till she cries and breaks down on the stand to get my guy acquitted, I'm gonna fucking do that. If any of you were a witness in a case and I have to come at you as hard as possible and I have to come at you like a god, an angry God in a land full of sinners, you best bet I'm going to do it. My job is to help my client. It's not meant to be helpful to the state or just, minding P's and Q's. It's zealous representation. So, I guess I'll put it like this. You commit a crime, you know you're guilty, you know you're fucked, and you know you're going to prison. Do you want your attorney to just sit there and say, oh, well, we gave it the old college try, or do you want the guy who's going to get your ass out of trouble? Now, if you're going to sit there and say, I'll just go to prison and accept my fate, you're a better man than I am, because I want the guy who's going to keep me from going to prison. Also, Jim, that was not a comment upon you. That's a question topic I get a little passionate about. Not all lawyers do. And I know there are women listening. A lot of lawyers are pussies, okay? A lot of lawyers don't like going to trial. They don't like doing the work. I think there's a good number of defense attorneys who are afraid to go to trial. I mean, that's like trying to be in the NFL as a quarterback and being terrified of the playoffs. Like, what the fuck are you here for? Like, that's showtime, man. Like, that's the thing. Trials are fun. They are stressful. They are tiring. But at the same time, when you're in them, it's hard to describe it. You can't beat it. Now, does that mean I go in there with like a careless attitude? No. But for me, it's exhilarating and it's intense. Like, I guarantee you, by Ivory Lamar and Anik Ahmad, and then also Assistant Prosecutor Huber, I guarantee you right now they're all exhausted and just want to like go home and just chill. I mean, it takes a lot out of you. Thanks, Beeps. Well, Cheryl, there is going the 9 yards, but I mean, there are a lot of attorneys, but it's just still it's that intensity. I mean, you need to go in there like a laser guided bomb plowing down some Taliban guy's house, like relentless. But some people don't. They do it a different way. I'm just a little more about getting to it and just plowing through the door like the Kool-Aid man. And I don't just say that because I'm a fat guy, but I think that's a good, mental picture. And Barbara, I know Natalie Lawyer Chick. I've seen some of her stuff. It's personality-wise, I think she's a little bit different than me personality-wise, but that doesn't mean she doesn't work hard and go hard in the paint. I'm just a little more outspoken and bombastic. So I have no doubt she's a very adequate and competent attorney. I just think our personalities are different. So I don't mean to say somebody like her is that case. So, Puck, by the way, you're asking a lot of good questions today. Is there a way a defendant can stop a trial and tell the court his attorney's not doing their job? Kind of once the trial starts, cake's baked. I mean, that's like saying once the plane takes off, you don't like the pilot. You're a little late for that. But in the lead up to a trial, I've had this happen. I've had guys fire me and say, I don't like what Sean's doing. I want a different attorney. I've had it when I've been appointed. I've had it when I've been a public defender. I've had retained clients fire me. It happens. That's not uncommon. But once you start trial, it's a little late. Loy Matar, you sound like a cool guy to hang out with. Not really. Yeah, I'll just leave it at that. Chandler Hollison's sentencing date's March 17th. Might be, I don't know. It probably is a little ways out. He's going to prison forever, so it doesn't matter when you do it. It can wait a while. Given the size of it, I bet it is going to take a while to do his pre-sentence investigation. Can I show you the dog? No, because the dog will not consent to being picked up, and I don't need to make a mess on my desk when she's flailing around. I heard you could punch your attorney and then play the race card. Maybe the race to find another attorney because nobody's going to want to fuck with you at that point. Do you think the longer it goes, the less likely it's first degree? So, there's always a thought that the longer things are going, it's better for a defense because it shows that the jury is starting to deadlock. It depends. If there's a lot of evidence and they are going to do their job and go through every single thing, taking a while is not necessarily helpful one way or another. Generally speaking, if the jury comes back right away, that usually means a very quick guilty verdict. The only thing I will say is like OJ. OJ was like 4 hours. And everybody was completely blindsided by it. So, you'd like to say you have an idea and based on experience, but it's always a crapshoot. You never know what's going on. Have I ever seen a judge like this before? I've been not necessarily as bad as B. Ivory Lamar and his co-counsel, But I have had judges I've screwed up in front of before, and they don't tolerate fools. You know, some of them do. Some of them are like, yeah, it's okay, no big deal. And some of them are like, are you fucking retarded? Like, what are you doing? So it really depends. But yeah, I've never made a judge that mad, but I've had a judge say, like, you know, what the hell are you doing? I've had a judge at trial say, counsel, what's the point? Move along. You know, I think that happens to everybody. Can't imagine anyone firing you. Well, they have. You know, and you know, hey, it's their call. How much am I making per year? Not as much as I prefer, but, you know, I've made positive growth every year. You know, like the 2 years I was a prosecutor, obviously I didn't grow, like, but it was a different way of being paid. But I do better every year, and I've got some different goals set for this year, so I hope to really knock it out of the park. I'm not driving like a Maserati, if that's what you're asking. Puck, do I believe our system of justice, I'm assuming you mean the U.S. system, best in the world, how could it be improved? For what we have, yes, I would not want to be on trial in other countries. I mean, for example, you go to Britain. You have a right to remain silent, but the fact you remain silent can be pointed out. I don't like that. You know, I don't like the fact that in a lot of countries, double jeopardy does not exist. You get acquitted, you can be retried. A lot of countries don't have a Sixth Amendment right to an attorney. A lot of them don't have search and seizure rules that are, which you can argue the Fourth Amendment's been really heavily eroded in America, but I would rather have our search and seizure laws versus a lot of countries. I mean, there's still places where the cops can probably beat the shit out of you to get a confession, and it would still be valid in a lot of places. You know, I definitely want Japan's legal system where they basically act like we're never wrong, and they have like a 99.999 conviction rate, and nobody ever wins. It's you know, the best for what it is. Yeah, Aiden, it does surprise me. You know, it's weird in the Anglosphere that we share a common law heritage, but you know, a lot of these countries, Canada, England, New Zealand, Ireland, Britain, we don't have the same, you know, same rules anymore. IRS audit incoming. Yeah, right. They can count the cobwebs in my wallet. Sold for sale. Well, I guess I'll shill for my channel since we're on here. I actually did something talking about what do attorneys do while they're waiting for the verdict. I mean, breaking it down, they're working on what else they have. I mean, they probably have other cases they're working on, other things coming up. You know, what are they doing tomorrow? What's the day after tomorrow? Like, you've got to keep going on your schedule when you have a chance. For the defense attorneys, they're also trying to keep Theodore calm. I bet he's a wreck right now, and I wouldn't blame him. So there's actually a lot's going on, and I have a video. If you click around my channel, you'll find it. How long will they be sitting with their client for? Well, Theodore is in custody, so he's probably back at the jail, but they're probably in a waiting room with them, at least for right now. I mean, in a situation like this, I don't think I'd bail on my client. I'd stick with him for as long as, till the jury's done for the day, and then I would go home. So I bet at least one of them's hanging out with him, and the other one probably went back to their office, and they'll probably trade off. You know, Adam, I'm sorry. You may be trying to make some jokes or whatever, but I'm literally just trying to read and answer the questions to keep up. So yeah. Playmaker, why was the OJ trial so long? There was a ton involved in that. That was a massive undertaking. Part of the reason why it became nothing like that had happened before. I mean, on the scope and scale. I mean, in a big murder, like that's one of those times where yeah, it's a murder, but there was a ton to it. Tons of witnesses, tons of experts. The defense is also part of the reason why it took forever. You can watch that TV series, but remember that trial was months and months and months long. Is a murder a common charge these days? Has violent crime increased? I mean, I think there are more murders overall, but generally speaking, violent crime has gone down in America. And it's been on a downward trend for like the past 2 decades or so, 3 decades maybe. I mean, in the 80s, people were dropping like flies. I've heard the stories of prosecutors where it was like raining bodies some years. Stop making fun because I'm black and trans. Oh, Jesus. Time Traveler, are you in Ohio? Matthew, why do police do that? Because to do a breathalyzer test, like on an actual machine or a valid thing that could be used as evidence, you know, because of our Constitution, you have the right to be free from unreasonable searches and seizures. And doing that on the side of the road, I know, for example, in Australia, they can make you do it right then and there. The other issue is portable breathalyzer machines that the police may have in America aren't calibrated to the same level, so they're not as reliable. Part of that is you just have the right not to comply with the police, and that's something that goes all the way back to our founding. I mean, they'd have to be a mistrial because they don't have enough jurors to go forward. I mean, theoretically, the defense may stipulate to allowing 11 if they thought they'd get an acquittal, but generally speaking, if you don't have your 12 jurors, then you have to stop. Aiden, the issue with the open can of beer was to show these guys were being. They were trying to show that they were being super drunk and being very belligerent and fighting and being aggressive. Because in America, generally speaking, in most states, at least in the Great Lakes region, which Wisconsin and Ohio are part of, you generally aren't allowed to ride around with open containers of alcohol. Now, an empty beer can is one thing, but a beer can that still has like beer in it is another issue. And usually that's a citation. What does it mean for the jury to be sequestered? They're put up in a hotel and basically guarded by the police when they're not deliberating. And that's like the nuclear option. That's very rare, and this is the type of case that would warrant that. Do you have any cases where your client was saved by video evidence? I have one. Normally, video evidence screws them over, or picture evidence screws them over. Usually, it doesn't help. Hey, time traveling painter, you mentioned you might have some expungement work. Do you live in Ohio? Because that's where I practice. Ed, do I think we should have professional juries? No. I don't like that idea. I do like the fact that the jury in America is a cross section of America. You might have nurses, retired people, engineers, garbage truck drivers, mechanics, teachers, stay-at-home parents, unemployed guys, some kid who just turned 18. You can have anybody and everybody. I think that's important because a professional juror, I don't want to have to deal with professionals. I want to be able to deal with people in a community who, you rely on their experiences, and I think it's far more effective. I think it's representative of American democracy and our democratic principles. To have professional jurors, I mean, that really seems to be like an aristocratic concept. I don't like that idea. Besides, professional jurors to me sound like people who, they turn to people like, oh, we see this all the time. I don't want that. I want people who are, in the community, and I want that to always be something I can go through. Could they pause deliberation? I mean, maybe, but the problem is, like, how long? How long is that guy going to be sick for if another juror gets sick? If I'm the defense attorneys, I'm not generally going to agree to that. I'll just say mistrial, new trial. I'm generally not going to work. I'm a pro se lawyer who's represented myself 3 times. Representing yourself pro se isn't easy. I hope you did okay. Puck, what is expungement? Some states it's called expungement. Some states it's called sealing your record. Basically, if you have a conviction for a crime, you literally wipe it off and get rid of it and kind of delete it so nobody else can know about it. The damage to the car, I mean, if you saw the pictures of it, it's a dent buggy at this point. I mean, it's a rust buggy. I mean, look at it. It had rust all over it in spots. It was dented up real bad. I mean, also number 2, it's a Kia Soul. I mean, think about that. The last time you're ever in a car, it's in a Kia Soul. Holy shit, that'd be embarrassing. Not even in a decent car. Now, the sad thing is they probably liked the Kia Soul, and I think that says a lot about their personality. Yeah, Facey, the damage was already there, but it's kind of like if you get in a car accident and your car's already beat to shit, how does the insurance adjuster know which is the new damage, which is the old damage? Also, if anybody here is a Kia Soul fan, I apologize. Well, no, I don't apologize. If you own a Kia Soul, those are ugly looking cars. Does the jury decide how late they work, or does the judge? Uh, it depends. There are some judges who will ask the jury how late they're willing to go. Some judges decide for the jury. It depends. It's up to the judge. No lawyers want professional jurors. Um, I don't like that concept, but I think if the average person were to sit down and think about it, I don't think they'd want professional jurors either, especially in our system. Some crimes have different levels, like murder, CSE. What's a crime do you think that should have? Are you asking what crime should have more levels of it? Is that what you're asking, Fiery Weasel? I don't understand your question. Yes, Aiden, I've seen that there's some places where they're not allowing jury trials, which seems really, really weird. I forget what I saw a while back, but it just looked really bad. Alexandra, why was the defense attorney's closing interrupted? One of the juries got sick. One of the jurors actually tossed their cookie, so you have to stop. Tasha, I understand, but your husband might want to pick a better car next time around. No offense, but you can tell your husband I think that was a bad choice. Fiery Weasel, I guess I'll say it like this. There are enough laws on the books. We don't need more. Less is better. Now, you might say, wow, as a defense attorney, you're advocating for less laws. Yeah, I am. I also realize most people aren't in favor of less laws on the books. But no, I don't think adding striations of it. Generally speaking, there's already some striations to the laws. Like, I'll use Ohio for example. There's burglary. A burglary is a second-degree felony. If you can show that the burglary was not into a continuously occupied structure, it can become a third-degree felony, which is a lesser offense. And then if you go down a little further, there's another version of burglary called trespass and habitation, which is a fourth-degree felony, which is really low on the felony scale. So there already are in many states and many places where, like, first-degree murder, second-degree murder, third-degree murder, there's already a lot of those built in. And then for every offense, there's usually, like, an attempted version of it you can plea out to. So, like, attempted robbery, attempted burglary, attempted arson, attempted breaking and entering, attempted possession of drugs, which usually lowers the rating. But I don't think necessarily we need to add more and more laws. There's already enough out there. Stay, I'm not sure what you mean by home invasion. Does the gun register too? Did they cover that? Well, they didn't actually say who bought the gun or, all that, because the documents, we couldn't read them. They were kind of blinded out on screen. But, ultimately, I think they have an issue of which gun it was because they claim it was a Glock that shot the bullets, but they said it was a Ruger in the house they found magazines for. So I don't think we know for real what gun it is. Yes, the lunch was supposed to be good today, but I don't think they had eaten yet. Why wasn't manslaughter an option for the jury to consider? Because nobody wanted to put that on the table as an option. Also, I don't know if manslaughter is applicable under their state law. So that's the reason why. I think the options are pretty fair, including the negligent homicide. I mean, if he gets that, that's awesome compared to what he's facing with the first degree intentional homicide. Dude is a chunk of shite. Yeah, he shot somebody and he kind of bitched out and, got scared when somebody finally stood up to him. But, can happen to anybody. John, nobody, Ruby's house, Ruby's gun. Yeah, it probably was hers, but I don't think we know 100% for sure. And I'd like to see what the 4473 at the store actually says. I'm going to miss this channel. You have the most velvet voice. That's impressive because I sound like I have a very nasally voice. Aiden, don't worry, there'll be more then. Don't worry, you'll be able to ASMR my voice if you want to in the future. Do they have the death penalty? No. Wisconsin has not had the death penalty since like 1853. It's one of the first states to abolish it way back in the day. But that said, they are not little interesting fact for people if you ever need it and you're in a bar trivia. Only one state in America has never had the death penalty, and that's the state of Michigan. They have never had the death penalty, only when they were a federal territory. Should you be able to use self-defense with an illegal firearm? Why not? If I have the right to defend myself with lethal force, okay, the gun's illegal, fine. That doesn't mean if you're coming at me with a knife and I pick up a stolen gun and use it, do I not have the right to self-defense because it's a stolen gun? No, and could I be charged with that stolen gun later? Sure. But to say I don't have the, oh, you gotta just give up and die because you don't have something that's on the up and up, I don't think that's a valid way to look at it. Are attorneys allowed to arm themselves in the courtroom? No chance in hell will that ever happen. I would like to be armed in a courtroom, but no. No. Generally speaking, the only people armed in court are the court security. Now, there are judges who are armed. And why can they do that? Because it's their courthouse and they get to do whatever the fuck they want. I know judges who are armed. I know judges who have a firearm underneath their bench, ready to go. So there are some perks to being judge. But no, I can't bring anything. When I go in the courthouse, everything stays in the car if I'm carrying that day. I generally don't carry if I know I'm going to court, just to avoid that issue. Well, Persh, I understand if you're carrying, but let's say I have a gun where, like this, the serial number is filed off of it. That's illegal under federal law, and that's illegal under the law of the state of Ohio. That's a defaced firearm. Now it's a contraband thing. Like, the police should be able to pick it up and take it because nobody should be allowed to own it. If I use that to defend myself, yes, that's an illegal firearm. I'm in possession of a defaced firearm, which is a crime, but I'm still allowed to defend myself. Does that make sense, I guess, for a question? I hope it answers it. Or if I'm a felon. I did have a case where a guy had a disability because of his felony convictions. And he grabbed a pistol and shot at people attacking him. He was allowed to do that. He ended up, long story short, he ended up having to do a year in prison because the whole story went sideways. But just because you aren't allowed to possess an item doesn't mean you can't defend yourself. And I don't know if Borowski's armed. I don't know his political affiliations. Kimberly, the Michigan Ethan Crumbley's trial, if he does have one, will be interesting, but also for his parents. That'll be actually more interesting, I think, if that does go all the way to trial. I don't think they should have been charged. I think that was the prosecution flailing and looking for people to punish. Do I think the death penalty should be abolished? That's a long... that's a lot longer than I could talk about here. I guess I'll just give you the quick run-through of that. Yes, the government sucks. Do I necessarily trust the government? No. But do I trust then that government to then lock up people for life without parole? Well, if I don't trust them to kill them, I shouldn't trust them for that. I shouldn't trust them to send somebody away for life. I shouldn't trust them to send somebody away for 30 days in jail. I shouldn't trust that same government to fine somebody $150. I look at it as, if you're talking about injustice, it's injustice no matter how big or small it is. If you can't trust that government, then you can't trust it, period. And if you can't trust it to administer law, well, then why do you have that as a government? And I think that brings up a bigger issue. But that's kind of like my brief run-through of it. I don't necessarily oppose it, is I guess what I would end with. Time-traveling painter, it all depends on where you live. If you live in Ohio, you're not barred. And in fact, it should be... let me check. Okay, time traveler. I just put my email address up there. So go for it. If you live in Ohio, I'd be happy to talk to you about it, and I give a consultation free of charge. So if you're in Ohio, let me know. But I have a Beretta 92 as well, Puck Puck. Yeah, like I said, Alexandra, I think I made it clear. I don't like material witness warrants like that. I think the state was a little bit dramatic when they got it, but it's already happened. So, the horse is already out of the barn. Stay, I didn't necessarily. I don't think I could tell that was a lunge. Even if it was, you still have the problem of Theodore saying, I didn't really know for sure what he had in his hands, if he had anything in his hands at all, and that the gun just went off, and that I didn't have any intent to do anything. Because you can't unintentionally commit self-defense. If you decide to grab out your gun and it's time to put in work, you don't accidentally put in work. You have to mean to do it. So, even if I'll argue in arguendo, I'll give you that point. There was a lunge. I still think he's got a problem. And also, I think there's an issue with the way the bullet trajectory went through Jason's skull that doesn't support this was a lunge. Johnny, and that's the thing, though. And guys, I think this is a great example, like Johnny Nobody and Stay Green. We can both look at a piece of evidence and come to different conclusions. I think it's just like a couple of years ago was the just green, blue or gold. I don't think either of you are wrong. Some facts are up to the person. Some of it is up to interpretation. That's the weird thing. You think in a trial we would know for sure X, Y, and Z. Like all the blood testing, the DNA testing, we know for sure some things. Sometimes though sometimes it is, people peering at a picture, what do they think? Or basing all the, this one witness's testimony, and it all hangs in the balance. Sometimes that does happen where it does come down to, well, who's got an interpretation and which, side can convince the other. Jackie, I agree there are hands raised. That doesn't surprise me at all. Sorry, I'm trying to catch up. Oh, there might be jury questions. Guys, if there's a jury question, I can't find any channels covering it right now. Thomas, it wasn't necessarily that Cal went to the riot to protect himself, but to protect, a community he's part of. And I do think people have the right to band together and ward off the people who wish to cause harm to their community. Oh, John D, yes, that's entirely going to be on emotion. I think once more and more comes out that the school knew something really bad was happening, yet they brought the kid in, they hadn't checked him, I think the school's going to be a lot more culpable at the end of that whole trial branch. So, but yeah, it'll be emotion. People people, when something bad happens, want to find somebody to be at blame. And, emotions can be run high, and those people could become the scapegoats. So you admit... Playing scared is a coward's role. Scared of cars. Yeah, Krill, if the Crumby trial does go forward, I'll be looking for it. Matthew, that whole thing with Facebook, that was done outside the jury's presence, so there was no prejudice to anybody involved. Thomas, not just Rittenhouse, the police even said it was a war zone. The police said, holy cow, there were people shooting guns off the whole time, and that they didn't feel comfortable. So I think anybody who was there would have said it would have seemed crazy.
I am living proof that Buddy checked.
Okay, guys, I don't know how to get I don't know a stream right now. Does anybody have a stream?
I'll hear from both sides.
If anybody has a link, let me know, because I cannot find it.
Join our award-winning team and find a way of life that values your...
Or arguably independent witnesses, all of whom testified. The defendant testified. Mrs. Clearman testified. That's 6 people that were at the incident or near the incident that saw what occurred. So if there's a case out there, great, but that's certainly my rule. These cases are not going to be situations in this or any case where I'm going to repeatedly play or allow a video to be played repeatedly for the jury while they're deliberating. This video and other unenhanced video was played, I can't even count how many times during this trial. I said multiple times, it was cumulative. Both sides belabored it too much. That's not going to occur. It'll be played once.
Let me know if everybody can hear this.
Counsel can make a record on the exhibit number and how long it is. I think it's a minute or a minute 35 or something like that. It's played start to finish. No commentary from anybody, including the court, and then they will be told to continue to deliberate. Mr. Ahmad, what juror number is it? sorry, exhibit number.
D25, it's 1 minute and 49 seconds long, and I think, Judge, the jury can be told if they want to look at the monitor and get out of their seats, they can.
Well, I don't want them parading around, but I'll move the monitor closer to them, the one monitor, or I'll have Mr. Hubner do it. So, since both sides are stipulating, if you can cue that up, counsel, I'll have my bailiff in a minute, go and get the jury in about 2 minutes. When you get that queued up, 2-minute recess.
This is live, guys. That is up to the judge to allow them to see exhibits and how often they do them. Well, John, my apologies, but I kind of did what I did because it's my channel. Jackie, it's not necessarily it's an issue of what's proper. Letting a jury watch it too many times, that creates issues in and of itself. So it's not unprofessional if that's everything gets the same scrutiny. That's also an issue that some judges don't like the jury being able to sit there and play through and play back and look at, like, they might focus on this one frame, which is like one picture. Think about it that way. Each frame is a picture. There might be 1,000 pictures to look at, and instead of looking at all the pictures as a whole, they're focusing on one. So there's times where I understand that. And sometimes that leads to a jury getting confused if they start screwing with exhibits in the back. Guys, I appreciate that. I was just trying to be nice because I could have told John, go fuck yourself. This is my channel, you cocksucker. Eat my whole asshole if you don't like it. But I was trying to be nice and civil about it. I just want you guys to know I do have some backbone. I'm trying to be nice. Stacy, good thing you mentioned White Claw. I'm out of White Claw, so I'm actually stuck to drinking beer right now and whiskey, so I think I'm going to do beer today. And it's almost 5 o'clock, so I think I will have a couple. If you guys want me to wear a suit and tie and sit here and watch something, you guys, I don't get super chats yet, but then you guys are better be sloshing money into like my Venmo or Cash App accounts, because I'm not doing that for free. Fuck that. I know it's a joke. Jackie, Bud Light. I'm a man of the people. I don't drink hop milkshakes or whatever it is the kids drink these days. In fact, I think I'm going to get a couple of Road Pops. Give me 1 second.
For the jury. Obviously, it's a grainy video, and we're concerned about the distance of it.
Yeah, we're on the record. Everybody use the mic, please. Go ahead.
Yeah, we just want to request that the TV be placed closer to the jury box. We also want to put on the record, we understand that the court is inclined to show the video once. Obviously, this is a grainy video. You know, the moment in which they're requesting happens very quickly. So we understand the court's position to show it once. We would like to preserve our objection as to the amount of times that the video be shown, and also request that the TV be moved closer so that the jurors can at least appreciate what they're seeing. We would like to preserve the objection as to the amount of times that the video be shown.
That's a fair
this
objection
video,
to make.
the incident in which the jury is requesting happens quickly, and we believe that the jury should be able to see the video evidence as many times as necessary. In addition of that, we would also request that the TV screen be moved closer to the jury box to ensure that all jurors have the same appreciation of being able to see the video. Thank you.
Mr. Hubner, be brief, please.
Well, first of all,
Use the mic.
Yeah.
Somebody, if you guys don't use the mic,
It's a valid argument.
seriously,
I'm really close to
I'm
the
gonna
mic.
sicker on both you guys, really.
That's okay.
Don't piss off the court reporter. That's a bad idea.
Judge, I guess I can move the computer, but I have to be able to see also what's being shown here.
Very
I
true.
moved it. This is the closest it's ever been to the jury.
Right, the TV's fine. If it gets much closer, then some jurors are gonna have a very bad angle. You can move it another
I
foot.
got no problem because then I can see it. But
Okay,
right
enough.
Are bunions keeping you from showing off your feet this summer? Here at Northwest Surgery Center, we're the
What happened? I think Skynet attacked, or my computer was asking me to repeat the question again. Also, I'm sorry about the whole, kind of asking them, like, what the fuck are they doing? But the defense is a stupid argument. Get up and stand in front of the TV if you have to and move. Also, for John, whoever was complaining that I drink or do stuff on air. Oh, yeah.
All right, the jury's coming in. You can remain seated, please.
Lisa, the judge can tell them no. Puck, I never threaten to wear a tie. I will not do that.
All right, the jury's back in the box. I received your question from the four-person juror 4. The lawyers have queued up the video. It's the enhanced video. There was a defense exhibit. It is going to be played. It is going to be played one time. No one is going to comment on it. It's going to be played start to finish. Then we're done, and you go back to continue to deliberate. Go ahead.
Hey, Stacy, leave Soul alone. He's asked some good stuff. I didn't see what he said before. Well, miss, I was just antagonizing the people that were complaining. I appreciate your thoughts, though. No, he lived in the area, Krilla. Yeah, it would, but I think I'm gonna have something else for dinner. Actually, I gotta go take care of something.
That was it, correct, gentlemen? Yes. All right, if you can all retire to the jury room and continue deliberations. Thank you.
Do I teach at law school? No. Ha ha. No, I'm not laughing at you, but no.
We're off the record. We're in recess.
No way in hell I'd be in a law school.
Thank you.
No law school would ever hire me. Okay, yeah, if he was calling people that, that's fine to give him a warning. So we'll try to just have a little bit of civility on here. Stacy, I would rather we not try to just ban people outright. I mean, if they want to be dickheads and assholes, just keep muting them at times, and if they do that, then they can leave on their own. But I don't like necessarily my channel banning people. Nas, you're correct. The jurors are focused on that spot. What happened? Did he lunge? I think there's, it might be, who knows? They all might be focused on it, 1, or it could be 1 or 12, or anywhere in between. Darren, as far as arguing he took something out of his pocket, there's no way to tell from that video he pulled something out. And even if he did, Theodore kind of blew that up when he said, I'm not 100% sure I saw anything, if anything at all. Adrena, I understand, but also, like I said, I'm fine with just muting people for things at a time. I don't like necessarily the concept of banning people, so just like I said. I mean, Nas, it might be good. It might be good. It might be bad. What I would tell you is anybody who thinks they can truly tell you what a jury's thinking, you're kind of up there with like a polygraph guy. It's like chicken with its head cut off levels of voodoo. Maybe you're right. Maybe you're wrong. Adam, I appreciate you talking. I'm working it out with my mods. Let Daddy handle this, please. Daddy Hebrew. Did they mention the lunging before yesterday? I think they did, but also just the squaring up to fight as well. No, Jenny, I had something yesterday, and what I had today, I was able to shift stuff around, so I actually didn't have to worry about it today. Robert, I don't think that's necessarily fair. Some words are pretty bad, and sometimes some people get mad at what you say. It's just how the world is. Time Traveler, I got your email. I'll be in touch. I I've seen judges do it all kinds of ways, Michael, as far as what the juries can see. Some judges make you, if you want to watch it, you have to come back out and watch it in front of everybody, and you watch it the whole way through, no stops, the way it was presented. Some judges say, here's a laptop, go knock yourselves out. I think both sides have positives and negatives. I mean, I've had things go right in trials where I've had judges do it one way and things go wrong where judges do it the other way. So, I mean, it's kind of a crapshoot. The jury wanted to see the video, Leslie. Yes, this is from the enhanced footage of the expert the defense hired. Well, I have to pay my bills somehow, so I do have to go back to work eventually. But as I've been here, I've been taking care of my emails and whatnot, and I had to take a phone call earlier, so I'm still working. Tim Bradford, is it justified for self-defense? No, but it sometimes is if it's in a provocation. So, for example, if you use the N-word towards a black person and they start beating the shit out of you, you might not have the right to self-defense if you provoke somebody with such actions that would cause a reasonable person to get mad. So, provocation can be an issue. In this case, it isn't. Yeah, just saw that Justice Breyer is retiring. I think that's good. He is past his expiration date, I think. Let's see here. Why didn't defense not get bar footage? Eric, you have to look at what relevance does that bar footage do. Does it make it more likely or less likely that Theodore had the right to self-defense on the bridge that night? I think that's kind of what you have to look at. Any piece of evidence you want to offer, you need to think about that. Does it make it more likely or less likely what it is you were trying to prove happened or didn't happen? Have I ever considered being a judge? Well, I'm just now eligible to be a judge in Ohio, so, I mean, yeah, it'd be nice. You get pretty good pay and, 9 to 5 hours. It's a lot of work, though. And, I do know a judge who used to be a defense attorney, then was a prosecutor, and is now a judge. He says there are advantages to being a judge, but he said at times it's like being a child. And the defense attorney and the prosecutor are the parents, and he only gets to know what they tell him. And for him, it's frustrating because he wants to know those questions that are out there, but he knows he can't ask them. So, I mean, yeah, there's times where it's nice being a judge, but I'm not sure if I want to be one yet, even if the opportunity were to rise. John, is it possible to differentiate on that video when the lunge and the... No, I don't think so from that, and that's why, like I said, we all can look at that video and come to a million different conclusions about what happened. Do I think it was a mistake? No. Theo had to go on the stand. None of the evidence supported him, and he had to go up there and lay it all out. None of the other witnesses backed up his claim that Jason had a knife on him or anything in his hand, so he had to go do it. What do I do? Puck asks, what do I do as a defense attorney if my client tells me they did a crime? Well, it depends. Do I have to put you on the stand? Okay, that becomes an issue because I can't support perjury. I can't offer falsehood before the court. There are some things you can do, but generally speaking, if I know you did it and you tell me you did it, but I don't ever have to worry about you taking the stand, that's fine. I can work with that. It's not the first. I've had that happen quite a bit. Okay, Rich, words are words and doesn't give you the right to assault them. No, but remember, there's the principle of free speech, but that's me and you don't have, I can't infringe upon your right to free speech. I'm not the government. Like I mentioned in the video with Jason, getting into this fight and getting shot. If you fuck around with people, sometimes stuff will happen to you. So, just something to think about. Don't go around calling people the N-word. It's generally a good idea. It keeps you from getting your ass kicked. Will this trial hurt Ivory's reputation in the long run? Probably not. I mean, maybe there's one or two people who might not hire him, but otherwise, it's free advertising. I mean, it's a commercial and he's on TV and he's got offices in a couple parts of the country, so hey, he can put on his website, I defended Theodore Edgecomb and I was all over TV, and it looks like he does stuff for Court TV and crap like that, so no, I don't think ultimately this will hurt him. Fiery Weasel, you're right. This could be just for one holdout juror and they're saying, look, here it is, now shut up and move along. It could be. Like I said, it could be one juror wants to see it. They all want to see it, or somewhere in between. I would agree about the reasonable doubt thing about the lunch stay. The problem is Theodore's case, when he testified, he really kind of fucked himself. And yeah, you can make some hay, but the problem is you got to testify and he's got to nail it. And he did not stick the landing. So no, Theodore kind of shot himself in the foot. Pun intended. Okay, Rich, I agree. Yes, when you're a CO, when you're walking the tiers, you can't thump every skull, but the rules are different when you're out and about on the streets. You might say something and you might get Donnybrooked for it. The prosecutor was fine. He did an okay job. I mean, he did about what I expected. Jenny asked, are there any crimes you not litigate? Nope. Nope. Nothing. I know, like I said, I think Nick Ricated does a great job. He says he can't do cases involving kids or sex crimes. I've done those. I've taken those to trial. I've won, one of them. That one was really tough. That one, actually, my guy, I'm pretty sure was innocent. But no, I'll take, anything to trial. I've taken guys with, a hard drive full of child pornography and dealt with those cases. I mean, I mentioned this, I think, yesterday. If you called me right now and said, hey, the police are digging up the crawl space in my house and they're finding the 35-year-olds I abducted and murdered 20 years ago, yeah, I'll defend you. I mean, probably have to pay me, but yeah, I'll defend you. And some attorneys don't handle certain cases, and I get that. That's fine. It's just as long as the ones you defend, you're willing to go all out and work for your guy. As I said earlier, you got to go hard in the paint. Adam, we will respect you. We will respect your journey. Like I said, guys, if you asked a question, I didn't see it, let me know. Have I done a murder trial yet? No, that's like the last thing I haven't done yet. I've assisted, like I've been a second or third chair, but I've not done one on my own. But, fingers crossed. How is Edgecomb paying for this defense? His family may have raised money through the community. I don't know. I think his attorneys may be working on a reduced rate because of the exposure, but I truly don't know. Where am I streaming from? I'm streaming from WISN. That's another channel in Milwaukee. It's like the ABC affiliate. And I use that now because apparently somebody in one of the comments said, oh my God, you're using Fox. I can't work with that because that might be Fox News, and they unsubscribed, which I think is a little spastic, but whatever. So we'll use the ABC one. I'm sure somebody will get soggy underwear over this too for some reason. Facing McGee, you want me to repeat that? I acted in self-defense and I was in fear of my life. Puck Edgecomb screwed himself over by stating, no, I didn't intend to do that. I didn't have intent to hurt him or kill him. Number one. Number two. Fuck, I gotta work on this. This is hard when the screen's off to the side. Number two, he then went on the whole part about, well, I don't know what was in his hands. I really couldn't tell if he had anything in his hands at all. I thought there was something, but I was focused on these other threats when he mentioned the other people rolling up and he thought that there were multiple threats to worry about. I give him credit for using all that language, but it sounds like he watched a self-defense video on YouTube and just started barfing that out. What about Epstein? He didn't kill himself. I mean, I can tell you that much. Would I defend Epstein? Hell yeah, I would. You know how much money that guy's got? Or did at the time? I'd defend him. I could pay off my loans. I'd own a yacht by the end of that. Heck yeah. And it's not like he's toast anyway. Donna Q, why is it acceptable to punch someone who calls you a name? I'm not saying it's acceptable, but if you act like an asshole, don't get upset when people treat you like an asshole. You know, that's just more of a life lesson. Kind of like, is it fair that the lion eats the gazelle? No, but it happens. Biggest case I've done a couple of, higher end drug traffickings. I mean, also drug possessions. Kidnappings, that almost turned into a murder. Thankfully it didn't. Pretty much everything in between. Probably the first trial I ever did, I was actually, the first serious trial, I was the second chair. We did a home invasion a burglary gone wrong, and the homeowners showed up, and yeah, they worked her over pretty good when they were leaving. I defend Markeith Lloyd. Like I said, I defend anybody. I don't care what it is you've done. I'll defend you. Jenny, I don't care if I offended British people here. Woo, 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 woo. And yes, Jenny, do I have a license for this? Yeah, Andrina, I don't care. I've had cases where, the person didn't have a chance in hell, but you go as hard as you can with what you have. Now, that means you might not be able to work that hard, or do that much, but you do what you can for people. Thomas, yeah, what have we learned? It's to walk away from confrontations. If you can, you should. If you're an adult and you're deciding to get into a fist fight, you better be willing to go to prison or die for that reason. Somebody, a fender bender or some dumb shit like this. Yeah, some guy punched you and rode off. Okay, that's it. Are you willing to get killed over this? I think if you ask Jason specifically, are you willing to die for this right now? He probably would change his mind. But yeah, if you're a grown adult and you're getting into fights voluntarily with people, now it's one thing, if you get jumped, do what you gotta do, but if you decide to voluntarily get into a fight with strangers, you're a fucking idiot. Did I have to switch my mindset going from prosecution to defense? Not necessarily. I mean, you use the same mindset. It's, I'm looking to do this. Is it just? Am I doing the right things? Is this an ethical, consideration? I don't think it changed too much. It just, you focused on different things. Now, as a prosecutor, I didn't necessarily, the idea that I was going to go as hard as possible in the paint and push the rules and the boundaries. Yeah, I don't think you should be doing that as a prosecutor. You should be well established and calm within paint and color within the lines. You should be like Grant Hubner and not Thomas Binger. And I've done cases where the guys have been on camera with like a shotgun in a convenience store and they forgot to put their mask down. I mean, and if you want to go to trial, I'll take you to trial. And we may lose, and I'll tell you it's a bad idea to go to trial. But yeah, I don't, like I said, literally there's nothing nothing. I don't care. I'll the evidence is not scary. The evidence is what it is. And Rich, you're right. The rule of law should reign supreme, but we are but men, and that's the hard part. We fall short. So June Doe, do I think jurors who don't agree with me are correct? No, they're wrong. They completely fucked up. Obviously I was right. Sometimes, yes, I'm like, I can understand why they made the decision they did. There's other times where I don't understand how the hell they did what they did. But generally speaking, yes, you understand what they've done, and it's okay. It is what it is. What if Jason had a gun when he was punched? Jason would have to meet all the elements of self-defense using lethal force. Adirondack, if Jason had a gun and he got punched, he would have to show he had a reasonable fear that he was facing immediate death or serious bodily injury. He could also claim that defense of others. So he could claim, I was worried my wife was going to die or face serious bodily injury. But he has to show that. And getting punched in the face alone isn't enough. Even though, yes, it's your car and he reached in the car and punched once, but he punched once and stopped. Now, if he had punched and kept on punching and was trying to open the door or was leaning into the car and jumping into the car, then yeah, that would change the whole story. But just one punch? No. Now, the only time that's different is, let's say you're a 90-year-old grandma and Mike Tyson's about to punch you in the face. Yeah, you have probably the right to kill him because he would probably fracture your skull. But for the average person walking around, getting punched in the face is not enough to think, oh my God, I'm about to die. Unless you're like a hemophiliac, your skull's made out of paper mache. Is the prosecution supposed to get a guilty verdict if they think the guy's innocent? If they think he's innocent, they should dismiss it and dump it. I mean, they shouldn't be prosecuting people who are innocent. That's super fucked up. And that's also a violation of their ethical rules. Like, there's a special rule in the Code of Professional Conduct in every state that prosecutors have to follow. Generally, it's like Rule 3.8 if you want to look it up in your own state. But it talks about it. They have to support all their cases with probable cause. And if they don't have that, they could, be sanctioned for that. Can I take a case outside of Cleveland? 6 cents. If it's in Ohio, yeah. Shoot me an email or go to my website and, we could talk about it. Like, let's say you're down in Cincinnati, you know, you'd have to pay me for travel. But yeah, I wouldn't be opposed to that. Andy, what did Binger do that was so bad? My biggest problem with Binger is, well, that he shouldn't have been prosecuting this. This shouldn't have been a case that went to trial. Now, I understand his boss is the district attorney who, you know, you take your marching orders, and that's one thing. But Binger went about this. There were questions about how they were providing evidence. I suspect evidence was tampered with, and they provided bullshit copies of evidence to the defense team. More importantly, when Kyle was on the stand, Binger kept on commenting on his Fifth Amendment silence post-arrest. That is a big no-no. You have the right to remain silent. And if you use that silence, it cannot be used in court to infer guilt. He knows that. That is something that's been established case law for like 40 years now. Actually, go back to the 70s, almost 50 years now. Like, you know better. And he knows that. He would have learned that in law school. Like, that's a no-no. He did the trial very underhandedly, and I think he was rather unscrupulous about it, and that's a very big concern, because if he's doing that when the cameras are on, what does he do when the cameras are off? Auntie Jen asks, when the right to self-defense versus resisting arrest, when does one supersede the other? I think like Indiana's the only state where you have the legal right to resist an illegal arrest. Now, here's the problem. The cops start arresting you, you start fighting them, what happens? Generally, more cops are going to show up. And if you keep resisting, they're going to beat the living shit out of you. They might even kill you. So what I would tell people is, take your pinch like a man. Don't fight. I mean, you're not going to win right there. You are not going to kick their ass so bad they decide to let you go. If you kick their ass, you're going to have to kick his buddy's ass, and you're going to have to kick the ass of every other cop that shows up. And even if you get away, they're going to hunt you down and then probably kick your ass when they find you. So, my advice is just surrender, go to court, and then fight it from there, because you're not going to win on the side of the road. The thing is, Matthew, Binger is not necessarily the one in charge of that. That would have been the DA's case, but I think Binger fully agreed with the district attorney on it. So he's an underling, so it's not necessarily his call. My leg hurts, was that an insult to the defense? No, I think he was just pointing out that had Jason shot Theodore, the roles would be reversed for, like, you'd have a different guy sitting in the defendant's table, but he would still be doing the same thing he's doing right now. I just think he was trying to say, like, I would literally be sitting here guzzling down Diet Coke and playing the laptop video feeds for you. That's all he meant. It wasn't meant to be underhanded at the defense. Yes, Jenny, I talk about that in one of my early Theodore videos. Don't go chase after people. I mean, chase after some random guy and it's dark out, and I mean, what's your game plan? Let's say he's got a gun or a knife. Like, what are you gonna do? And is it worth it? You know, sure, you might fight him, but what do you gain out of that? And if you gain, is it enough? Is it, you know, a minor gain, or is it a massive gain? What about the guy that ran out in traffic and supposedly jumped on top of the truck An off-duty officer shot and killed him. Is that justified? I don't know which case you're talking about, so, and I would try to Google that, but I don't think Google's going to understand what I'm asking. Court TV has advertising revenue, so might be a little better. GPS JC, I don't know if you heard me earlier. If you said remove them, I don't. Like I said, please don't ban anybody. I'm fine with you muting people. I definitely don't like the concept of banning people. If they're going to be asshats, people will ignore them enough. They go away on their own. Donald Davies, do 40-something old defense lawyers get better, or are they always going to be bad? I mean, you can always learn and progress in your profession or trade, just like any job. You can always get better, or you can stagnate and do what you do. Some attorneys keep refining their craft and get better and, gain wisdom and experience and keep gaining wisdom and experience till they're done. And those are the dudes who are like, the slick older guys in their 50s and 60s who, get hired and really pour it on a case. So it just depends. 500 subscribers now, yeah. You guys are ridiculous. I truly mean that from the bottom of my heart. Thank you. It's kind of nice. People want to hear what I have to say, but preparing for 1,000, I'll worry about that when I cross it. I don't think it's wise to tempt the fates. Rich, the video of guys getting gym. I'm going to have to look that up because I don't know, but that sounds interesting. Rich, is that on YouTube? Time traveling painter. Super chats only work, I think, once you get. I think you have to get monetized or reach some milestones, and I haven't reached those yet, so I can't do super chats. Yeah, Andrina, monetizing is different, but I still don't think I've met the requirements. Some random mom asks, do you think it would be the same if the victim had shot Theo in the head when Theo rode up to the car to punch him? If some random mom, if Jason shot Theo, he should be on trial for murder and get convicted of murder if he had done that. John D, yes, I have heard that case. The news articles I've read about it, it's very confusing what happened. But yes, it sounds like the cops got scared and started shooting not at the proper targets, which is a big problem. As part of your job, you get a shiny black gun and a bulletproof vest and a lot of trust from the public. I expect you guys, maybe it does get a little dicey before you start shooting. God forbid we hold them to a standard that's a little more dangerous. GPS, don't worry. Thank you for bringing it to my attention.
Your home you'll perfect with Windows Select. You'll say big.
Hold on, my bad. Guys, 1 second. I'm going to be right back. The verdict has been reached. I'm looking. I don't see it. Hold on.
Your home you'll perfect with Windows Select. You'll say big.
So, verdict is in, but I think right now we're in a holding pattern. So, let's hang tight, guys. Puck asked a question. Is it always best not to speak after Miranda rights have been read without an attorney present? Okay, if the cops read you your Miranda rights, you're in deep shit, okay? If they tell you about all the rights you have, you need to shut the fuck up and get an attorney. That's it. I mean, if you're sitting in their office, you're already in deep trouble. You're probably going to get arrested, so shut up and get an attorney. If you can leave, ask if you can leave. Because if you can leave, get the fuck out of there like it's on fire. Otherwise, you generally don't speak to the police. There's very little to gain. Now, you're walking down the street with your dog, and let's say you own a bulldog, and the cops walking by. It's like, hey, do you like those? I was thinking about buying one. Get one for my kids. You don't have to tell them, fuck you, go talk to my lawyer. You could probably answer that question. But generally speaking, if the cops are asking questions, you should do so with an attorney present. You don't know what they're asking. You don't know where it's going to lead. They might think you're a bad guy, or they think you might know something. You just be very careful. That's why I recommend don't talk to the police. But yeah, if they're reading your Miranda rights, you need to be very worried. Yes, my leg hurts. Yeah, I had to go pay the water bill. Sorry, Robert. I didn't mean to ruin that in case you need new windows. Thank you, Marcy. I did find news stories about that guy shooting the dude on the hood. I'll take a look at that. Yes, Sandy Rhodes bring up a great point. Yes, never submit to anything. They want your fingerprints, tell them to fuck off. They want your DNA, tell them to fuck off. They want you to take a polygraph, never take a polygraph. Okay? They want to ask you questions. They need anything from you. The answer is no. I'll getting an attorney first. Oh, 20 minutes? Jeez, that's gonna be a while. Facey McGee, no, I did not see your question. Can you please repost it? They're waiting for the media, Brenda, but I think they're also waiting for the attorney and the prosecutor and everybody to get back. Some courthouses I've been in, the judge says stay in the courthouse. Some of them stay within 5 minutes. Some of them 20 minutes is actually kind of nice. Yeah, if you guys need to go take a leak, now's the time.
We can ditch.
Eric McDowell, polygraphs aren't admissible in court. That's correct. So why are they allowed? Never understood that. Because the police use them to fuck with people. Because they'll say, "Oh my God, you lied," and it gets people to confess. That said, though, on the offhand, you convince their bullshit voodoo technology. I mean, it's like a Ouija board. If you convince them that you're telling the truth, then they actually do leave you alone generally. So that's like the only positive side of a polygraph, is that if they think you're being legit, then they stop. But I never recommend you to take one. And do not do one unless you're with an attorney. Rich, I did find your case, and actually, we got time. Let's try to watch it.
You've been
So, Facey, after they read you your Miranda rights, what happens? So, here's what can happen. If they've already decided to arrest you, you're going to have to wait till you get to court and run into a public defender, and you're just going to have to say, I need to hire an attorney, and go from there. They generally aren't going to have one sitting there waiting for you. You're likely not going to be able to find one at that time. When you say you want an attorney, that just stops the interrogation. That said, though, if you happen to have a relationship with an attorney previously established, like you've talked to one, sat down with one, what you would do is call your family and say, hey, call attorney Sean, tell him I'm in jail and he needs to come see me, and then that attorney comes and finds you. Or you call your family and say, hey, get me an attorney, I don't care who, I need one right now. I mean, that's generally the 3 ways you're going to get an attorney if you're in custody. But if they read you your rights, ask if you can leave, and if you can leave, get out. Okay, guys, this is what Rich brought up about looks like somebody being killed and being attacked, and kind of want to know what I thought. So I don't know if you guys are interested, but we're going to look at it. You guys all ready? So from what I know, this is out of Mesquite, Texas. So here we go. Alright, so they're being told to go. They're leaving. Oh, yeah, yeah, they're fucked.
Hey, go call somebody, Hey, go call somebody, man.
Hey, bro, get somebody.
I did read an article talking about 7 seconds, and it said that you were at first hesitant to take that role. Why?
I mean, look at this young man that is my
Your home you'll perfect with Windows Select.
So yeah, that guy got his head stomped in. Yeah, those guys are in serious trouble. In many states, a shod foot, and by shod I mean wearing shoes. That's a, if you want an English trivia point for today, horses are not shoed, they are shod. Kicking somebody with a foot covered in a shoe is considered deadly force in many states, especially if you kick someone in the head. And they were kicking to the upper body and head, so yeah. They're going to have a tough time explaining why they did that. Why did you use deadly force on this guy? He told you to leave and you're acting like assholes, and he does have the right to get trespassers off his property. If he actually is a security guard, he has that right. And if it's in Texas, those guys, they're probably going to be making some license plates coming up at the state prison. I mean, they don't really have a good defense at this point, but there might be more to it that I don't know. And they might be able to tell more they don't know. But right now, that doesn't look good. All right, well, I'm going to end the poll. So yeah, it looks like a lot of people think Theodore's guilty. So, yeah. Yeah, Sue, that was the other part of that. That was multiple people attacking. Why did they have to? The guy was on the ground. Would that now put that guy, that security guard, in the other hand, would he have the right to use lethal force? People are trying to kick his head off his shoulders, and there's multiple people. Yes, they may be only using fist and shoes, but there's now a disparity of force regarding the disparity of numbers. So, yes, could he have been on the ground and shot them? I bet he could. And I bet in a lot of states he would be justified. You don't always get, like, one phone call, you don't have the right to a phone call, but generally they're going to give you one. Little miss, that guy was getting kicked and punched. I don't think they were, patting him on the head. Will I explain after the verdict? Yeah, I'll explain what I can. Deborah, I don't know why they wanted to see the video again. That's something the jury, if they ever get interviewed about, could talk. But, yeah. How would this case play out in Ohio? It would probably play out the same way. He'd be facing murder charges. You are allowed to disengage, and he did retreat. But yeah, he'd still be facing murder charges, and he's still going to be toast out here. Okay, so what happened at Law and Crime where happened at Critterville? I've seen this critter pop up before, so what happened? I'm confused. Fill me in on your lore. Irene asked why was she charged with, assault with a deadly weapon or tested for DUI. Well, to charge her with assault, you have to show an intent to cause harm. And I don't think you could demonstrate that. She said she never did, and there's some reasonable minds could differ. One, two, for the DUI, you'd have to prove it, but we don't know what her alcohol level was. And I said this before, the prosecutor's a political person. It's going to look really bad on an election if somebody brings up, remember when that lady who her husband got shot in the head and you prosecuted her for a bunch of crimes as well? That's not a good look. But you'd have to prove she committed those crimes. Sue, no, that you will not. They inform you that if you cannot afford, you have the right to counsel, and if you cannot afford counsel, one will be appointed to represent you. But the cops don't do that. The court would appoint counsel for you. So the cops aren't involved in that. They're just telling you what would happen. No, Candace, Wisconsin does not have the death penalty. John D, do I find it valuable to talk to the trial after it's over? Yes, I do. They don't have to talk to me, and sometimes they will. It's entirely up to them. I try to send them out a letter. Please, if you like to, please contact me. I would appreciate it if they don't want to stick around. But yes, sometimes they say, hey, I'll ask them, what do you think? What did you think about the case? Are there things you thought were good or bad? How did you interpret this or that? And it does help because it helps you understand, well, I thought it was being shown this way and a juror saw it in a different light. Or they may say, hey, if you would have talked about this point, that would have been important. I wanted to know about X, Y, and Z. There's always feedback to be had, but they do not have to talk to you. So sometimes you don't know the answer to a question. Oh, sorry, Facey. I gotta look for that. I gotta do some more looking in on that. I think I said this. Wisconsin does not have the death penalty. Nuxaw, if Wisconsin had stand your ground, I think Wisconsin does technically have stand your ground, you still have to prove you were in fear of your life and that you had to use lethal force. You have to meet that requirement, regardless if it's stand your ground, regardless if you're in Texas. You still have to prove you had, some fear. Actually, Texas, bad thing. But you still have to prove there was a fear or reasonable belief that you were going to be killed and or seriously injured, and you have to show that. Stand your ground doesn't alleviate that. Irene, yeah, it would have had blood alcohol would have been tested at the time, but why didn't they? Because they had a guy laying on the ground with his head turned into a canoe. And she wasn't involved in that, so I think they were more focused on that anyway. Adam's asking about law and crime giving Rekieta a cease and desist. Yeah, and it's all bullshit. Law and crime can go fuck themselves, and if they send me one, I'll wipe my fucking ass with it. And I'll personally write back my own response, so. But I'm not. I'm just some, piddly-dink dude, so they're not going to come. They could care less about me. He is eating into their revenue, though, I guarantee it. He basically blew up their model. Stacy, yeah, there's no duty to retreat. It's actually getting more and more like 75% of states don't have a duty to retreat. Ohio just got rid of theirs last year, so, that's increasing. Jules, about the broadcasters and social media and the jurors. No, actually, the court had its own live feed that it was playing, and that accidentally showed the jurors. So it wasn't even a broadcaster. The court themselves did it, which is kind of funny. A CCW class talks about the bare minimum. It's not; those aren't very in depth, and I would never rely on what they tell you as a way to guide yourself about the law. I mean, it's bare bones. Oh, here we go. Up, he juked us out. David, why does long crime not do it anymore? Well, because people were kind of eating their lunch proverbially.
Record in Edgecomb.
So that's
Madam
why.
Clerk, can you call it again?
They put it behind a paywall.
State of Wisconsin versus Theodore Edgecomb, 20 CF 3535. Appearances.
Grant Huebner for the state.
Theodore Edgecomb appearing by attorney Anik Ahmad.
Diabri Lamar.
As the lawyers are aware, for the record, it's 4:50.
Drum roll.
About half an hour ago, approximately, the jury indicated that they've reached a verdict. At approximately 3:45, so maybe 20 minutes to half an hour before that, based on a stipulation of the parties, the court played a video once for the jury. It was a defense exhibit. They went back to continue to deliberate.
I am not tipsy
And about
yet.
half an hour
You'll know
after
when I'm
viewing the
tipsy.
video, they reached a verdict. I gave both sides time to assemble, including the Clearman family and others. I'm going to bring the jury in. I will read the verdict. It's my practice that I read the verdict. I will make sure the verdict's in appropriate form before I read it. When I read the verdict, I expect silence in the gallery. No matter what side you're on, I understand this is an
Sentence
emotional
up
case.
to how the
I
judge
understand
does it.
that people are
Probably not now.
excited and charged up maybe. I expect everybody to behave appropriately in a courtroom. That means no outbursts, no screaming, no standing up, no stomping your feet, no celebrating, nothing. I will read the verdict. Depending on what the verdict is, I will poll the jury and then most likely discharge the jury. I expect everybody to behave. I'll bring the jury in. Again, as has been in practice during this entire trial, the defendant's in court, he's in custody, he's in street clothes, so everybody can remain seated. I'll have the jury brought in.
The suspense is, when you're sitting at the defendant's table or at the prosecution table, this is a very intense couple of moments. Yeah, Lisa, don't break it. Don't spoil for us, please. We'll see if Ivory and Anik stand up with Theodore. So of course he's probably panicking right now. I would.
All right, the
too.
jury's coming in. Everybody can remain seated, please.
Mantra, his attorneys have no idea what the verdict is right now. Nobody does except the jury.
Welcome back, ladies and gentlemen. It's my understanding you've reached a verdict. Is that correct?
Yes.
And you're the foreperson, ma'am?
Yes.
You're juror number 4, is that correct?
Yes.
Can you hand the paperwork to my bailiff, please?
It's so serious right now. Here we go.
All right, it appears to me that the verdict's in appropriate form. It's been completed. I'm going to read the verdict. Again, I would ask that there not be any overt reactions. We, the jury, find the defendant, Theodore Edgecomb, guilty of first-degree reckless homicide, a lesser-included offense of count 1 of the information.
Wow.
Based on that, the jury was requested and asked to answer a second question. Did the defendant commit the offense of first-degree reckless homicide while using a dangerous weapon? Answer, yes. It's signed today by the foreperson who's juror number 4. Based on that verdict, everybody, I'm going to poll the jury. I'm going to start with the foreperson, move to my right, then start in the back row in the left, and move to my right again. Ma'am, was this and is this your verdict?
Yes.
Ma'am, was this and is this your verdict?
Me? Yes.
Sir, was this and is this your verdict?
Yes.
Ma'am, this is and was your verdict?
Yes.
Ma'am, this is and was your verdict?
Yes.
Starting in the back, my left. Ma'am, this is and was your verdict?
Yes.
Sir, this is and was your verdict?
Yes.
Ma'am, this was and is your verdict, is that right?
Yes. Yes.
Ma'am, this is and was your verdict?
Yes.
Ma'am, this is and was your verdict?
Yes.
Ma'am, again, this is and was your verdict?
Yes.
And last but not least, ma'am, this is and was your verdict?
Yes.
All right, I've polled the jury. The jury has confirmed their verdict of guilty of first-degree reckless homicide, a lesser-included offense of count 1 of the information. I will ask the foreperson, ma'am, I presume, based on this verdict, that you left the other verdict forms blank. Is that correct, ma'am?
I did.
Fine. Ladies and gentlemen, I am going to thank you on my behalf, first of all, and also on behalf of the parties. I said previously, more than once this week, and the lawyers acknowledge this as well, that to my observation, you've been certainly patient, first of all, and secondly, very, very attentive.
Yes,
there
can
were
you
times
repeat
that
that?
things dragged. The case lasted a day longer than I thought it would, but you've all been very, very upright in coming to court, being here on time, listening intently to the evidence, the witnesses, the arguments of the attorneys. I am going to excuse you with the thanks of the court. I would ask if you stick around for a few minutes, I will come back to thank you in person in the jury room. I have to discuss a couple things with the attorneys. I would expect that that will only take 5 minutes. I will come back, thank you in person, and also potentially ask, or I should say, answer any questions that you might have. Again, I very much appreciate your efforts over the course of the last 6 or 7 days. I appreciate your patience, and I know the parties appreciate your work and efforts as well. So everybody else can remain seated. If you can follow my bailiff out, in a few minutes I'll come back to thank you again in person. All right, the jury's been excused. Is there a motion?
Your Honor, state moves for judgment of conviction on the verdict.
I'm granting the state's request, denying the defense request. I'm entering a judgment of conviction on the verdict of guilty of first-degree reckless homicide while using a dangerous weapon. I'm ordering a judgment of conviction against the defendant. The defendant will be remanded for sentencing. We can discuss sentencing on this I'll ask the defense if you want a PSI, a pre-sentence investigation, done either by the DOC, or if you want to prepare one yourself. That will affect my sentencing date.
Yes, I would think we should have a PSI, Judge.
Fine, I'll order a PSI. Do you want that with or without a recommendation?
Without recommendation.
All right, I'll order a pre-sentence investigation from the state of Wisconsin, from the DOC. It will not include a recommendation. I candidly don't think I need a recommendation in this case.
Oof, that's not good.
We'll set a sentencing date. The sentencing date will be in approximately 60 days. Again, the defendant is remanded for sentencing. I'm going to presume that the attorneys want to deal with the sentencings on the other two matters, the bail jumpings that were pled to last week at the same time. Is that correct?
That's yes.
Fine. Sentencing on all three matters will proceed in about 2 months. I'll have my clerk pick a day. We'll set aside a fair amount of time. Madam Clerk?
Jenny, I'll translate. Give me a second.
What day of the week is that?
No, I can't do that Friday. And I'm not available the next week. I apologize. And I'm going to need a Friday.
April 8th at 1:30.
April 8th at 1:30?
Yes.
Yes, that will work.
Is that a date the state can confidently be here? I'm not going to want to adjourn the sentencing. That's plenty of time. I don't want this to be put off any longer than necessary. Is the state relatively confident you'll be available? I'm sure you'll be in trial on something else, but hopefully available.
Well, the trial I have is in Judge Watts' court. So, but I still think I should be able to be done by that Friday.
Fine. What's the date, Madam Clerk?
Promises like that, you're usually screwed, brother. You know that. I know
For
that.
sentencing in person, 423 of the Safety Building.
All right, the sentencing date's April 8th. We're adjourned for today. We're going off the record. Thank you, everyone.
Okay, so happy trails, Theodore. He faces up to 60 years in prison. With this, I did a little research quickly on the first-degree reckless. So, yeah, it's kind of where I thought that they would go. The pre-sentence investigation report, a PSI. Basically, the judge wants to sentence him properly, and part of sentencing somebody is you learn their story. So it's kind of like a reader's condensed version of the life of Theodore. Because the judge really doesn't know anything about him except what's been in here in trial, and that may not be helpful. So you sit down with somebody, they talk to you, they find out about your family history, growing up, your health, mental health. Well, somebody's not happy. Oh, wow, that's... Oh, okay, fucking... Attorney Ahmed, dude, you don't fucking saddle up until your guy's out of the courtroom. Okay, that was kind of shitty. Sorry, I gotta stop. If you're an attorney, you can't be suited up and ready to walk out the door till your guy's gone. That's not fair to him. That looks like you don't give a shit. Sorry, that's just... I wouldn't do that. That's not how I roll. Anyway, going back to the PSI... It gives the judge the idea, hey, what's your history, everything about you, your family life, your personal life, have you used drugs, substance abuse, anything you think that might be relevant for the court to know, education, all that stuff. Doing without a recommendation, they would rather just go in and argue on their own behalf why the sentence should be what it is. Because if there's a recommendation, there's a way the judge might accept that recommendation and roll with it. And if you know it's probably not going to be favorable, you'd rather give your own recommendation than let the judge have this other one hanging out there. Sorry, guys, I kind of ran through that. Tell me if that made any sense at all. No, the judge didn't want the PSI. He asked defense if they wanted it to include a recommendation, and the defense attorneys asked for no recommendation. Yeah, thank you. You guys have any, let's see, any other questions? Yeah, I mean, it sounds like he probably won't get out of prison before his mom's either old or dead. No, I will not repeat that. Connie, that was probably somebody in Theodore's family who was upset that he's going away for a while. Puck, as long as it's statutorily allowed, the judge probably can sentence him however he wants to, as long as he's following state law. But given how this all went down, he's definitely going to probably be getting the better part of 30 years, I bet. It's not going to be a good sentence. At least I don't think he'll max him out, but he'll be getting a lot. Catherine, he faces up to 60 years in prison. He was found guilty of first-degree reckless homicide. Well, Minier, he's not going to get all that time. I don't think he'll get a full 60 years. David, he might win on an appeal, but you're better off playing to win the lottery than winning on an appeal. Okay, yeah, if you guys are hanging out, have a good night. If you have other questions, I'll stick around for a bit. Theodore is in his 30s. Yeah, Adirondack, his attorneys are standing next to him, but like they're already look like they're packing up and getting ready to go. I wouldn't pack up till my guy's out of the courtroom. That's just not cool. Cheryl, he probably is eligible for parole. I just don't know what Wisconsin's parole statutes and rules are. Gaddy, I don't know when I'm going to do my next live stream, but I'll be putting out videos, from here on out. I think starting to get in the hang of this, and it appears enough of you guys like it that I'll put stuff out. Yeah, Rich, he's definitely going to appeal, but, once again, it's probably like spitting into the wind at this point. Kimberly, yeah, the defense wasn't good, but I don't think this really changes where it was going to happen. I think he was going to get convicted. Based on all the evidence the prosecutor had, it was kind of a matter of time. If not, maybe, but when. Well, the reckless and negligence just like you weren't paying attention. Reckless is you didn't, kind of like you weren't caring about your actions. Like, if I'm waving a gun around, that's being reckless. You're not really caring what happens. I think he had to get on the stand. He had to. But, absent God intervening, it wasn't going to turn around. Yeah, his pending cases are for misdemeanor stuff. Those will probably settle out. They'll probably dismiss a lot of it because he's going to prison, so they don't care to deal with him. He's going to serve far more time than these misdemeanors could ever get him. Yeah, thank you guys very much. I appreciate it. Yeah, I think manslaughter may have been the more appropriate charge, but without knowing Wisconsin's, looking it up, it might not have applied. Kimberly, bail, theoretically you can get appeal bond, meaning like you're out on bond while you're waiting an appeal, but given a sentence like this, there's a high likelihood he'll take off. He's already taken off once, so he wouldn't get that, and, nobody ever gets appeal bond. Random Mom, it'll be noted in his PSR. they won't necessarily get to use those pending charges as a like recidivism, but they'll have to note that he's in trouble for other stuff in other courts. No, Lil Miss, the first degree intentional homicide was the most serious charge, and that could be life without parole, so it's better than the alternative. He kind of got option 3 of 5. They kind of went halfway down the list. And I don't know if this was a compromise verdict, but it easily could be. Some people thought it was intentional, some people didn't, so they met in the middle. I think they'll probably televise the sentencing. If not, I'll do what I can to fill everybody in on it. Andrina, I don't necessarily think he'll get maxed out, but I bet I could see him getting 40 years, 30 years. Pretty easy. Mindy, as far as people, as far as parole is concerned, I don't know Wisconsin specifically, but generally parole is something that the prison system handles. Now, they may consult with the judge saying, hey, we want to put this guy up on parole. Do you agree? But generally, the judge doesn't get to say on hand, I'm not making you eligible for parole. Maybe in California or somewhere they do that, but generally speaking, no. Chad, I appreciate that. I mean, I'm not really worried about the right to second, maybe down the road. So there's not going to be rights tonight. Come on, this isn't like the trial of the century. This wasn't that big a deal. I'll be doing another one. Like I said, we're going to have to find one that works out for everybody. So, just keep your eyes peeled, guys. In the meantime, I'll be releasing videos. I'm working on one right now that covers Theodore's testimony, his cross and direct. I've already put like 3.5 hours of work into it, so I'll put that together. I think you guys will like it. I think it'll be kind of funny as I critique what happened. James, I don't like majorities. Because I want, if they're going to convict somebody and put them in prison for 60 years, it should be all of them, not, 7 out of 12. Chad, I appreciate that, but, like, I get it. I'm not... Dude, look, I'm tired, bro. I don't have time for this, and I get you want to simp to be moderator. Like, I get it. Just on my list of things I'm kind of worried about right now, this isn't one of them. I appreciate it, though. Thanks, Chad. Chad, can you repeat that, please? David, I don't think this was that fast. I told you, I think it was going to be maybe a couple of hours. There isn't a whole lot to this case. It's at that time, did he have the right to shoot? And he didn't. Thank you for the kind words. Yeah, I'll work on finding another trial coming up, guys. Anybody else have any other questions real quick? Yeah, he should have asked the judge to repeat the verdict, yeah. Or immediately he should have said, I reacted in defense of myself, Judge. I think they have to, yeah, I mean, when the guy says, yes, I did it, but it was an accident, Hard not to take him at his word. Yes, Nerd Love, you always ask that. Anytime the state's done presenting their case, you say, Judge, we don't think they've met their burden. Usually you lose that argument, but you always ask. And just like at the end of this, when he got convicted, the state asked for the court to finalize that verdict. The defense always objects, saying, Judge, we object to you finalizing the verdict. It's going to happen anyway, but you object just to protect the record for appeal purposes. Thank you very much, guys. If you got 180 on the LSAT and you didn't go to law school, dude, you got some problems. If you have 180 on the LSAT, you better be working for like SpaceX or something. Okay, well that works too, being a test prep tutor. That's also a good way to make money off that. Gaddy, do I do civil suits? Sometimes. It depends on what it is, but you know, I might cover some of that stuff every once in a while if it shows up and it's interesting enough. But generally, I'm going to try to stick to criminal things. That's a lot more in my wheelhouse. Yeah, well, find somebody who's willing to hire me to teach. I appreciate it, you guys. And, yeah, like another minute, I think I'm going to wrap up because it's been since, like 9:30. Jeez. It's like 6, 9, yeah, almost like 10 hours of this. So I think I'm going to call it quits soon. June Doe, what determines the trial's aired? I mean, does it have any publicity for it? Is it an interesting case? Because a lot of these average run-of-the-mill stuff isn't going to get aired on TV. Alright, guys, well, if that's it, yeah, I'm going to turn... Yeah, guys, I'm going to kill the feed. I'll see you guys next time, and, yeah, until then, have a nice night. It's been a pleasure.